Chapter 21, Part 2 of the Commentaries on the Laws of England, Book 2, by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Of Alienation by Matter of Record, Part 2. 3. We are next to consider the force and effect of a fine. These principally depend at this day on the common law and the two statutes 4 Henry VII c. 24 and 32 Henry VIII c. 36. The ancient common law with respect to this point is very forcefully declared by the statute 18 Edward I in these words: and the reason why such solemnity is required in the passing of a fine is this: because the fine is so high a bar, and of so great force, and of a nature so powerful in itself, that it precludes not only those which are parties and privies to the fine, and their heirs, but all other persons in the world, who are of full age, out of prison, of sound memory, and within the 4 seas the day of the fine levied, unless they put in their claim within a year and a day. But this doctrine of barring the right by non-claim was abolished for a time by a statute made in 34 Edward I c. 16, which admitted persons to claim and falsify a fine at any infinite distance, whereby, as Sir Edward Coke observes, great contention arose, and few men were sure of their possessions, till the Parliament held, 4 Henry VII reformed that mischief, and excellently moderated between the latitude given by the statute and the rigor of the common law. For the statute then made restored the doctrine of non-claim, but extended the time of claim, so that now, by that statute, the right of all strangers whatsoever is bound, unless they make claim, not within 1 year and a day, as by common law, but within 5 years after proclamations made, except them coverts, infants, prisoners, persons beyond the seas, and such as are not of whole mind, who have 5 years allowed to them and their heirs, after the death of their husbands, their attaining full age, recovering their liberty, returning to England, or being restored to their right mind. It seems to have been the intention of that politic prince, King Henry VII, to have covertly by this statute extended fines to have been a bar of estate's tale, in order to unfetter the more easily the estates of his powerful nobility, and lay them more open to alienations, being well aware that power will always accompany property. But doubts having arisen whether they could, by mere implication, be adjudged a sufficient bar, which they were expressly declared not to be by the statute de donis. The statute 32 Henry VIII c. 36 was thereupon made, which removes all difficulties by declaring that a fine levied by any person of full age, to whom or to whose ancestors lands have been entailed, shall be a perpetual bar to them and their heirs claiming by force of such entail, unless the fine be levied by a woman after the death of her husband of lands which were, by the gift of him or his ancestor, assigned to her entail for jointure, or unless it be of lands entailed by act of Parliament or letters patent, and whereof the reversion belongs to the Crown. From this view of the common law, regulated by these statutes, it appears that a fine is a solemn conveyance on record from the cognizor to the cognizee, and that the persons bound by a fine are parties, privies, and strangers. The parties are either the cognizors or cognizees, and these are immediately concluded by the fine, and barred of any latent right they might have, even though under the legal impediment of coverture. And indeed, as this is almost the only act that a femme covert or married woman is permitted by law to do, and that because she is privately examined as to her voluntary consent, which removes the general suspicion of compulsion by her husband, it is therefore the usual and almost the only safe method whereby she can join in the sale, settlement, or encumbrance of any estate. Privies to a fine are such as are in any way related to the parties who levy the fine, and claim under them by any right of blood or other right of representation. Such as are the heirs general of the cognizor, the issue in tail since the statute of Henry VIII, the vendee, the devise, and all others who must make title by the persons who levied the fine. For the act of the ancestor shall bind the heir, and the act of the principal his substitute, or such as claim under any conveyance made by him subsequent to the fine so levied. Strangers to a fine are all other persons in the world, except only parties and privies, and these are also bound by a fine, unless, within 5 years after proclamations made, they interpose their claim, provided they are under no legal impediments and have then a present interest in the estate. The impediments, as hath before been said, are coverture, infancy, imprisonment, insanity, and absence beyond the sea. And persons who are thus incapacitated to prosecute their rights have 5 years allowed to them to put in their claims after such impediments are removed. Persons also that have not a present but a future interest only, as those in remainder or reversion, have 5 years allowed to them to claim in from the time that such right accrues. And if within that time they neglect to claim, or by the statute 4 Ann c. 16, if they do not bring an action to try the right within 1 year after making such claim, and prosecute the same with effect, all persons whatsoever are barred of whatever right they may have by force of the statute of non-claim. But in order to make a fine of any avail at all, it is necessary that the parties should have some interest or estate in the lands to be affected by it. Else it were possible that two strangers, by a mere confederacy, might without any risk defraud the owners by levying fines of their lands. For, if the attempt be discovered, they can be no sufferers, but must only remain in statu quo. Whereas, if a tenant for life or years levies a fine, it is an absolute forfeiture of his estate to the remainder man or reversioner if claimed in proper time. It is not, therefore, to be supposed that such tenants will frequently run so great a hazard, but if they do, and the claim is not duly made within 5 years after their respective terms expire, the estate is forever barred by it. Yet, where a stranger, whose presumption cannot thus be punished, officiously interferes in an estate which in no wise belongs to him, his fine is of no effect, and may at any time be set aside, unless by such as parties or privies thereunto, by pleading that partas finis nihil habuerunt. And thus much for the conveyance or assurance by fine, which not only, like other conveyances, binds the grantor himself and his heirs, but also all mankind, whether concerned in the transfer or no, if they fail to put in their claims within the time allotted by law. 4. The fourth species of assurance by matter of record is a common recovery, concerning the original of which it was formerly observed that common recoveries were invented by the ecclesiastics to elude the statutes of mortmain, and afterwards encouraged by the finesse of the courts of law in 12 Edward IV, in order to put an end to all fettered inheritances, and bar not only estate's tail, but also all remainders and reversions expectant thereon. I am now therefore only to consider, first, the nature of a common recovery, and secondly, its force and effect. 1. And, first, the nature of it, or what a common recovery is. A common recovery is so far like a fine that it is a suit or action, either actual or fictitious, and in it the lands are recovered against the tenant of the freehold, which recovery, being a supposed adjudication of the right, binds all persons and vests a free and absolute fee simple in the recoverer. A recovery, therefore, being in the nature of an action at law, not immediately compromised like a fine, but carried on through every regular stage of proceeding, I am greatly apprehensive that its form and method will not be easily understood by the student, who is not yet acquainted with the course of judicial proceedings, which cannot be thoroughly explained till treated of at large in the third book of these Commentaries. However, I shall endeavor to state its nature and progress as clearly and concisely as I can, avoiding, as far as possible, all technical terms and phrases not hitherto interpreted. Let us in the first place suppose David Edwards to be tenant of the freehold, and desirous to suffer a common recovery in order to bar all entails, remainders, and reversions, and to convey the same in fee simple to Francis Golding. To effect this, Golding is to bring an action against him for the lands, and he accordingly sues out a writ called a praecipe quod redat, because those were its initial or most operative words when the law proceedings were in Latin. In this writ, the demandant, Golding, alleges that the defendant, Edwards, here called the tenant, has no legal title to the land, but that he came into possession of it after one Hugh Hunt had turned the demandant out of it. The subsequent proceedings are made up into a record or recovery roll, in which the writ and complaint of the demandant are first recited, whereupon the tenant appears and calls upon one Jacob Moreland, who is supposed at the original purchase to have warranted the title to the tenant, and thereupon he prays that the said Jacob Moreland may be called in to defend the title which he so warranted. This is called the voucher, vocatio, or calling of Jacob Moreland to warranty, and Moreland is called the vouchee. Upon this, Jacob Moreland, the vouchee, appears and is impleaded and defends the title. Whereupon Golding, the demandant, desires leave of the court to imparl or confer with the vouchee in private, which is, as usual, allowed him. And soon afterwards the demandant, Golding, returns to the court, but Moreland, the vouchee, disappears or makes default. Whereupon judgment is given for the demandant, Golding, now called the recoverer, to recover the lands in question against the tenant, Edwards, who is now the recoveree, and Edwards has judgment to recover of Jacob Moreland lands of equal value in recompense for the lands so warranted by him and now lost by his default, which is agreeable to the doctrine of warranty mentioned in the preceding chapter. This is called the recompense, or recovery in value. But Jacob Moreland, having no lands of his own, being usually the crier of the court, who, from being frequently thus vouched, is called the common vouchee, it is plain that Edwards has only a nominal recompense for the lands so recovered against him by Golding, which lands are now absolutely vested in the said recoverer by judgment of law, and seizin thereof is delivered by the sheriff of the county. So that this collusive recovery operates merely in the nature of a conveyance in fee simple from Edwards, the tenant in tail, to Golding, the purchaser. The recovery here described is with a single voucher only, but sometimes it is with double, treble, or farther voucher, as the exigency of the case may require. And indeed, It is now usual always to have a recovery with double voucher at the least, by first conveying an estate of freehold to any indifferent person, against whom the praecipe is brought, and then he vouches for the tenant in tail, who vouches over the common vouchee. 4. If a covery be had immediately against tenant in tail, it bars only such estate in the premises of which he is then actually seized. Whereas if the recovery be had against another person, and the tenant in tail be vouched, it bars every latent right and interest which he may have in the lands recovered. If Edwards, therefore, be tenant of the freehold in possession, and John Barker be tenant in tail in remainder, here Edwards doth first vouch Barker, and then Barker vouches Jacob Moreland the common vouchee, who is always the last person vouched, and always makes default, whereby the demandant Golding recovers the land against the tenant Edwards, and Edwards recovers a recompense of equal value against Barker, the first vouchee, who recovers the like against Moreland, the common vouchee, against whom such ideal recovery in value is always ultimately awarded. This supposed recompense in value is the reason why the issue in tail is held to be barred by a common recovery. 4. If the recovery should ever obtain a recompense in lands from the common vouchee, which there is a possibility in contemplation of law, though a very improbable one of his doing, these lands would supply the place of those so recovered from him by collusion, and would descend to the issue in tail. This reason will also hold with equal force as to most remainder men and reversioners, to whom the possibility will remain and revert as a full recompense for the reality, which they were otherwise entitled to. But it will not always hold, and therefore, as Pigot says, the judges have been even astuti in inventing other reasons to maintain the authority of recoveries. And, in particular, it hath been said that, though the estate tail is gone from the recovery, yet it is not destroyed, but only transferred, and still subsists, and will ever continue to subsist, by construction of law, in the recoverer, his heirs and assigns. And, as the estate tail so continues to subsist forever, the remainders or reversions, expectant on the determination of such estate tail, can never take place. To such awkward shifts, such subtle refinements, and such strange reasoning, were our ancestors obliged to have recourse in order to get the better of that stubborn statute de donis. The design for which these contrivances were set on foot was certainly laudable, the unriveting the fetters of estate's tail, which were attended with a legion of mischiefs to the commonwealth. But, while we applaud the end, we cannot but admire the means. Our modern courts of justice have indeed adopted a more manly way of treating the subject, by considering common recoveries in no other light than as the formal mode of conveyance by which tenant in tail is enabled to alien his lands. But, since the ill consequences of fettered inheritances are now generally seen and allowed, and of course the utility and expedience of setting them at liberty are apparent, it hath often been wished that the process of this conveyance was shortened, and rendered less subject to niceties, either by totally repealing the statute de donis, which, perhaps, by reviving the old doctrine of conditional fees, might give birth to many litigations, or by vesting in every tenant in tail of full age the same absolute fee simple at once, which now he may obtain whenever he pleases, by the collusive fiction of common recovery, though this might possibly bear hard upon those in remainder or reversion, by abridging the chances they would otherwise frequently have, as no recovery can be suffered in the intervals between term and term, which sometimes continue for near 5 months together, or, lastly, by empowering the tenant in tail to bar the estate tail by a solemn deed, to be made in term time and enrolled in some court of record, which is liable to neither of the other objections, and is warranted not only by the usage of our American colonies, but by the precedent of the statute 21 Jacobin 1 C19, which in case of a bankrupt tenant in tail, empowers his commissioners to sell the estate at any time by deed indented and enrolled. And if, in so national a concern, the emoluments to the officers concerned in passing recoveries are thought to be worthy of attention, those might be provided for in the fees to be paid upon each enrollment. 2. The force and effect of common recoveries may appear, from what has been said, to be an absolute bar not only of all estates tail, but of remainders and reversions expectant on the determination of such estates. So that a tenant in tail may, by this method of assurance, convey the lands held in tail to the recoverer, his heirs and assigns, absolutely free and discharged of all conditions and limitations in tail, and of all remainders and reversions. But by statute 34 and 35 Henry VIII c. 20, no recovery had against tenant in tail of the king's gift, whereof the remainder or reversion is in the king, shall bar such estate tail or remainder or reversion of the crown. And by the statute 2 Henry VII c. 20, no woman, after her husband's death, shall suffer a recovery of land settled on her in tail by way of jointure by her husband or any of his ancestors. And by statute 14 Elizabeth c. 8, no tenant for life of any sort can suffer a recovery so as to bind them in remainder or reversion. For which reason, if there be tenant for life, with remainder in tail, and other remainders over, and the tenant for life is desirous to suffer a valid recovery, either he or the tenant to the praecipe by him made must vouch the remainder man in tail, otherwise the recovery is void. But if he does vouch such remainder man, and he appears and vouches the common vouchee, it is then good. For if a man be vouched and appears, and suffers the recovery to be had, it is as effectual to bar the estate tail as if he himself were the recoveree. In all recoveries it is necessary that the recoveree, or tenant to the praecipe, as he is usually called, be actually seized of the freehold, else the recovery is void. For all actions to recover the seizin of lands must be brought against the actual tenant of the freehold, else the suit will lose its effect, since the freehold cannot be recovered of him who hath it not. And though these recoveries are in themselves fabulous and fictitious, yet it is necessary that there be auctores fabulae properly qualified. But the nicety thought by some modern practitioners to be requisite in conveying the legal freehold, in order to make a good tenant to the praecipe, is removed by the provisions of statute 14 George II c. 20, which enacts, with a retrospect and conformity to the ancient rule of law, that though the legal freehold be vested in the lessees, yet those who are entitled to the next freehold estate in remainder or reversion may make a good tenant to the praecipe, and that though the deed or fine which creates such tenant be subsequent to the judgment of recovery, yet, if it be in the same term, the recovery shall be valid in law, and that, though the recovery itself do not appear to be entered, or be not regularly entered on record, yet the deed to make a tenant to the praecipe and declare the uses of recovery shall, after a possession of 20 years, be sufficient evidence on behalf of a purchaser for valuable consideration that such recovery was duly suffered. And this may suffice to give the student a general idea of common recoveries the last species of assurances by matter of record. Before I conclude this head, I must add a word concerning deeds to lead or to declare the uses of fines and of recoveries. For if they be levied or suffered without any good consideration, and without any uses declared, they, like other conveyances, inure only to the use of him who levies or suffers them. And if a consideration appears, yet as the most usual fine, sur cognizance de droit cum eo, etc., conveys an absolute estate, without any limitations, to the cognizee, and as common recoveries do the same to the recoverer, these assurances could not be made to answer the purpose of family settlements, wherein a variety of uses and designations is often expedient, unless their force and effect were subjected to the direction of other more complicated deeds, wherein particular uses can be more particularly expressed. The fine or recovery itself, like a power once gained in mechanics, may be applied and directed to give efficacy to an infinite variety of movements in the vast and intricate machine of voluminous family settlement. And if these deeds are made previous to the fine or recovery, they are called deeds to lead the uses; if subsequent, deeds to declare them. As, if A tenant in tail, with remainder to himself in fee, would settle his estate on B for life, remainder to C in tail, remainder to D in fee. This is what by law he has no power of doing effectually, while his own estate tail is in being. He therefore usually covenants to levy a fine, or, if there be any remainders over, to suffer a recovery, to E, and that the same shall inure to the uses in such settlement mentioned. This is now a deed to lead the uses of that fine or recovery, and the fine when levied, or recovery when suffered, shall inure to the uses so specified, and no other. For though E, the continuee or recovery, hath a fee simple vested in himself by the fine or recovery, yet by the operation of this deed he becomes a mere instrument or conduit pipe, seized only to the use of B, C, and D in successive order, which use is executed immediately by force of the statute of uses. Or, if a fine or recovery be had without any previous settlement, and a deed be afterwards made between the parties, declaring the uses to which the same shall be applied, this will be equally good, as if it had been expressly levied or suffered in consequence of a deed directing its operation to those particular uses. For by statute 4 and 5 and C16, indentures to declare the uses of fines and recoveries made after the fines and recoveries had and suffered shall be good and effectual in law, and the fine and recovery shall inure to such uses, and be esteemed to be only in trust, notwithstanding the statute of frauds 29 Charles II C3 enacts that all trusts shall be declared in writing at, and not after, the time when such trusts are created. End of Chapter 21, Part 2. Chapter 22 of the Commentaries on the Laws of England, Book 2, by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines of Alienation by Special Custom. We are next to consider assurances by special custom, obtaining only in particular places and relative only to a particular species of real property. This, therefore, is a very narrow title, being confined to copyhold lands, and such customary estates as are holden in ancient demesne, or in matters of a similar nature, which, being of a very peculiar kind, and originally no more than tenancies in pure or privileged villanage, were never alienable by deed. For, as that might tend to defeat the lord of his seigniory, it is therefore a forfeiture of a copyhold. Nor are they transferable by matter of record, even in the king's courts, but only in the court baron of the lord. The method of doing this is generally by surrender, though in some manors by special custom recoveries may be suffered of copyholds. But these differing in nothing material from recoveries of free land, save only that they are not suffered in the king's courts, but in the court baron of the manor, I shall confine myself to conveyances by surrender and their consequences. Surrender, sur sum reditio, is the yielding up of the estate by the tenant into the hands of the lord, for such purposes as in the surrender are expressed, as, it may be, to the use and behoof of A and his heirs, to the use of his own will, and the like. The process, in most manors, is, that the tenant comes to the steward, either in court, or, if the custom permits, out of court, or else to two customary tenants of the same manor, provided that also have a custom to warrant it, and thereby delivering up a rod, a glove, or other symbol, as the custom directs, resigns into the hands of the lord, by the hands and acceptance of his said steward, or of the said two tenants, all his interest and title to the estate, in trust to be again granted out by the lord to such persons and for such uses as are named in the surrender, and the custom of the manor will warrant. If the surrender be made out of court, then, at the next or some subsequent court, the jury or homage must present and find it upon their oaths, which presentment is an information to the lord or his steward of what has been transacted out of court. Immediately upon such surrender in court, or upon presentment of a surrender made out of court, the lord by his steward grants the same land again to cestui que use, who is sometimes, though rather improperly, called the surrenderee, to hold by the ancient rites and customary services, and thereupon admits him tenant to the copyhold, according to the form and effect of the surrender, which must be exactly pursued. And this is done by delivering up to the new tenant the rod or glove or the like, in the name and as the symbol of corporal season of the lands and tenements. Upon which admission he pays a fine to the lord according to the custom of the manor, and takes the oath of fealty. In this brief abstract of the manner of transferring copyhold estates, we may plainly trace the visible footsteps of the feudal institutions. The fief, being of a base nature and tenure, is unalienable without the knowledge and consent of the lord. For this purpose it is resigned up or surrendered into his hands. Custom, and the indulgence of the law, which favors liberty, has now given the tenant a right to name his successor, but formerly it was far otherwise. And I am apt to suspect that this right is as much of the same antiquity with the introduction of uses with respect to freehold lands. For the alienee of a copyhold had merely jus fiduciarum, for which there was no remedy at law, but only by subpoena in chancery. When, therefore, the lord had accepted a surrender of his tenant's interest, upon confidence to re-grant the estate to another person, either then expressly named, or to be afterwards named in the tenant's will, the chancery enforced this trust as a matter of conscience, which jurisdiction, though seemingly new in the time of Edward IV., was generally acquiesced in, as it opened the way for the alienation of copyholds as well as of freehold estates, and as it rendered the use of them both equally divisible by testament. Yet, even to this day, the new tenant cannot be admitted but by composition with the lord, and paying him a fine by way of acknowledgment for the license of alienation. Add to this the plain feudal investiture by delivering the symbol of season in presence of other tenants in open court. Quando asta vel aliet corporeum, quid libet porgitora domino se investiturum, facere decente, quae saltem carem duabis vassalis, solemniter fieri debet. And, to crown the whole, the oath of fealty annexed, the very bond of feudal subjection. From all which we may fairly conclude, that had there been no other evidence of the fact in the rest of our tenures and estates, the very existence of copyholds, and the manner in which they are transferred, would incontestably prove the very universal reception which this northern system of property for a long time obtained in this island, and which communicated itself, or at least its similitude, even to our very villains and bondmen. This method of conveyance is so essential to the nature of a copyhold estate that it cannot possibly be transferred by any other assurance. No fiefment, fine, or recovery in the king's courts has any operation thereupon. If I would exchange a copyhold estate with another, I cannot do it by an ordinary deed of exchange at the common law, but we must surrender to each other's use, and the Lord will admit us accordingly. If I would devise a copyhold, I must surrender it to the use of my last will and testament, and in my will I must declare my intentions and name a devise, who will then be entitled to admission. In order to more clearly apprehend the nature of this peculiar assurance, let us take a separate view of its several parts, the surrender, the presentment, and the admittance. 1. A surrender, by an admittance subsequent whereto the conveyance is to receive its perfection and confirmation, is rather a manifestation of the alienor's intention than a transfer of any interest in possession. 4. Till admittance of chestque use, the lord taketh notice of the surrenderer as his tenant, and he shall receive the profits of the land to his own use, and shall discharge all services due to the lord. Yet the interest remains in him not absolutely, but sub modo, for he cannot pass away the land to any other, or make it subject to any other encumbrance than it was subject to at the time of the surrender. But no manner of legal interest is vested in the nominee before admittance. If he enters, he is a trespasser, and punishable in action of trespass, and if he surrenders to the use of another, such surrender is merely void, and by no matter ex post facto can be confirmed. For though he be admitted in pursuance of the original surrender, and thereby acquires afterwards a sufficient and plenary interest as absolute owner, yet his second surrender, previous to his own admittance, is absolutely void ab initio, because at the time of such surrender he had but a possibility of an interest, and could therefore transfer nothing, and no subsequent admittance can make an act good which was ab initio void. Yet, though upon the original surrender the nominee hath but a possibility, it is, however, such a possibility as may, whenever he pleases, be reduced to a certainty, for he cannot either by force or fraud be deprived or deluded of the effect and fruits of the surrender. But if the lord refuse to admit him, he is compellable to do it by a bill in chancery or a mandamus, and the surrenderer can in no wise defeat his grant, his hands being forever bound from disposing of the land in any other way, and his mouth forever stopped from revoking or countermanding his own deliberate act, except in the case of a surrender to the use of his will, which is always revocable. 2. As to the presentment, that, by the general custom of manners, is to be made at the next court baron immediately after the surrender. But by special custom, in some places it will be good, though made at the second or other subsequent court. And it is to be brought into court by the same persons that took the surrender, and then presented by the homage, and in all points material must correspond with the true tenor of the surrender itself. And therefore, if the surrender be conditional, and the presentment be absolute, both the surrender, presentment, and admittance thereupon are wholly void, the surrender as being never truly presented, the presentment as being false, and the admittance as being founded on such untrue presentment. If a man surrenders out of court, and dies before presentment, and presentment be made after his death, according to the custom, this is sufficient. So too, if Chestway Keuse dies before presentment, yet upon presentment made after his death, his heir, according to the custom, shall be admitted. The same law is, if those into whose hands the surrender is made die before presentment, for upon sufficient proof in court that such a surrender was made, the lord shall be compelled to admit accordingly. And if the steward, the tenants, or others into whose hands such a surrender is made, do refuse or neglect to bring it in to be presented, upon a petition preferred to the lord in his court baron, the party grieved shall find remedy. But if the lord will not do him right and justice, he may sue both the lord and them that took the surrender in chancery, and shall there find relief. 3. Admittance is the last stage or perfection of copyhold assurances, and this is of three sorts. First, an admittance upon a voluntary grant from the lord. Secondly, an admittance upon surrender by the former tenant. And thirdly, an admittance upon a descent from the ancestor. In admittances, even upon a voluntary grant from the lord, when copyhold lands have escheated or reverted to him, the lord is considered as an instrument. For though it is in his power to keep the lands in his own hands or dispose of them at his pleasure, by granting an absolute fee simple, a freehold, or a chattel interest therein, and quite to change their nature from copyhold to socage tenure, so that he may well be reputed their absolute owner and lord, yet if he will still continue to dispose of them as copyhold, he is bound to observe the ancient custom precisely in every point, and can neither in tenure nor in estate introduce any kind of alteration, for that were to create a new copyhold. Wherefore, in this respect, the law accounts him custom's instrument. For if a copyhold for life falls into the lord's hands by the tenant's death, though the lord may destroy the tenure and enfranchise the land, yet if he grants it out again by copy, he can neither add to nor diminish the ancient rent, nor make any the minutest variation in other respects, nor is the tenant's estate so granted subject to any charges or encumbrances by the lord. In admittances upon surrender of another, the lord is to no intent reputed as owner, but wholly as an instrument, and the tenant admitted shall likewise be subject to no charges or encumbrances of the lord, for his claim to the estate is solely under him that made the surrender. And, as in admittances upon surrenders, so in admittances upon descents by the death of the ancestor, the lord is used as a mere instrument, and, as no manner of interest passes into him by the surrender or death of his tenant, so no interest passes out of him by the act of admittance. And therefore, neither in the one case nor the other is any respect had to the quantity or quality of the lord's estate in the manner. For whether he be tenant in fee or for years, whether he be in possession by right or by wrong, it is not material, since the admittances made by him shall not be impeached on account of his title, because they are judicial, or rather ministerial acts, which every lord in possession is bound to perform. Admittances, however, upon surrender differ from admittances upon descent in this, that by surrender nothing is vested in chestque use before admittance, no more than in voluntary admittances. But upon descent the heir is tenant by copy immediately upon the death of his ancestor. Not indeed to all intents and purposes, for he cannot be sworn on the homage nor maintain an action in the Lord's court as tenant. But to most intents the law taketh notice of him as of a perfect tenant of the land instantly upon the death of his ancestor, especially where he is concerned with any stranger. He may enter into the land before admittance, may take the profits, may punish any trespass done upon the ground, nay, upon satisfying the Lord for his fine due upon the descent, may surrender into the hands of the Lord to whatever use he pleases. For which reasons we may conclude that the admittance of an heir is principally for the benefit of the Lord, to entitle him to his fine, and not so much necessary for the strengthening and completing the heir's title. Hence, indeed, an observation might arise, that if the benefit which the heir is to receive by the admittance is not equal to the charges of the fine, he will never come in and be admitted to his copyhold in court, and so the Lord may be defrauded of his fine. But to this we may reply in the words of Sir Edward Coke: I assure myself, if it were in the election of the heir to be admitted or not to be admitted, he would be best contented without admittance. But the custom in every manner is in this point compulsory. For, either upon pain of forfeiture of their copyhold, or of incurring some great penalty, the heirs of copyholders are enforced in every manner to come into court and be admitted according to the custom, within a short time after notice given of their ancestors' decease. End of chapter 22. Chapter 23 of the Commentaries on the Laws of England, Book 2, by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Of Alienation by Devise. The last method of conveying real property is by devise, or the disposition contained in a man's last will and testament, and, in considering this subject, I shall not at present inquire into the nature of wills and testaments, which are more properly instruments to convey personal estates, but only into the original and antiquity of devising real estates by will, and the construction of the several statutes upon which that power is now founded. It seems sufficiently clear that before the Conquest lands were divisible by will, but upon the introduction of military tenures the restraint of devising lands naturally took place, as a branch of the feudal doctrine of non-alienation without the consent of the lord. And some have questioned whether this restraint, which we may trace even from the ancient Germans, was not founded upon truer principles of policy than the power of wantonly disinheriting the heir by will and transferring the estate through the dotage or caprice of the ancestor from those of his blood to utter strangers. For this, it is alleged, maintained the balance of property, and prevented one man from growing too big or powerful for his neighbors, since it rarely happens that the same man is heir to many others though by art and management he may frequently become their devise. Thus the ancient law of the Athenians directed that the estate of the deceased should always descend to his children, or, on failure of lineal descendants, should go to the collateral relations, which had an admirable effect in keeping up equality and preventing the accumulation of estates. But when Solon made a slight alteration by permitting them, though only on failure of issue, to dispose of their lands by testament and devise away estates from the collateral heir, this soon produced an excess of wealth in some and of poverty in others, which, by a natural progression, first produced popular tumults and dissensions, and these at length ended in tyranny and the utter extinction of liberty, which was quickly followed by a total subversion of their state and nation. On the other hand, it would now seem hard, on account of some abuses which are the natural consequence of free agency when coupled with human infirmity, to debar the owner of lands from distributing them after his death, as the exigence of his family affairs or the justice due to his creditors may perhaps require. And this power, if prudently managed, has with us a peculiar propriety, by preventing the very evil which resulted from Solon's institution, the too great accumulation of property, which is the natural consequence of our doctrine of succession by primogeniture, to which the Athenians were strangers. Of this accumulation the ill effects were severely felt even in the feudal times. But it should always be strongly discouraged in a commercial country, whose welfare depends on the number of moderate fortunes engaged in the extension of trade. However this be, we find that, by the common law of England since the Conquest, no estate greater than for a term of years could be disposed of by testament, except only in Kent, and in some ancient burghs, and a few particular manors, where their Saxon immunities by special indulgence subsisted. And though the feudal restraint on alienations by deed vanished very early, yet this on wills continued for some centuries after, from an apprehension of infirmity and imposition on the testator in extremis, which made such devises suspicious. Besides, in devises there was wanting that general notoriety and public designation of the successor, which in descents is apparent to the neighborhood, and which the simplicity of the common law always required in every transfer and new acquisition of property. But when ecclesiastical ingenuity had invented the doctrine of uses, as a thing distinct from the land, uses began to be devised very frequently, and the devise of the use could in chancery compel its execution. For it is observed by Gilbert, that as the popish clergy then generally sate in the court of chancery, they considered that men are most liberal when they can enjoy their possessions no longer, and therefore at their death would choose to dispose of them to those who, according to the superstition of the times, could intercede for their happiness in another world. But when the statute of uses had annexed the possession to the use, these uses, being now the very land itself, became no longer divisible, which might have occasioned a great revolution in the law of devises, had not the statute of wills been made about 5 years after, viz., 32 Henry VIII. C.1, explained by 34 Henry VIII. C.5, which enacted that all persons being seized in fee simple, except fem coverts, infants, idiots, and persons of non-sane memory, might by will and testament in writing devise to any other person, but not to bodies corporate, two-thirds of their lands, tenements, and hereditaments held in chivalry, and the whole of those held in socage, which now, through the alteration of tenures by the statute of Charles II, amounts to the whole of their landed property except their copyhold tenements. Corporations were excepted in these statutes to prevent the extension of gifts in mortmain, but now, by construction of the statute 43 Elizabeth C4, it is held that a devise to a corporation for a charitable use is valid, as operating in the nature of an appointment rather than a bequest. And indeed, the piety of the judges hath formerly carried them great lengths in support of such charitable uses, it being held that the statute of Elizabeth, which favors appointments to charities, supersedes and repeals all former statutes, and supplies all defects of assurances, and therefore not only a devise to a corporation, but a devise by a copyhold tenant without surrendering to the use of his will, and a devise, nay, even a settlement, by tenant in tail, without either fine or recovery, if made to a charitable use, are good by way of appointment. With regard to devises in general, experience soon showed how difficult and hazardous a thing it is, even in matters of public utility, to depart from the rules of the common law, which are so nicely constructed and so artificially connected together that the least breach in any one of them disorders for a time the texture of the whole. Innumerable frauds and perjuries were quickly introduced by this parliamentary method of inheritance, for so loose was the construction made upon this act by the courts of law, that bare notes in the handwriting of another person were allowed to be good wills within the statute. To remedy which, the statute of frauds and perjuries, 29 Charles II C3 directs, that all devises of lands and tenements shall not only be in writing, but signed by the testator, or some other person in his presence and by his express direction, and be subscribed in his presence by 3 or 4 credible witnesses, and a similar solemnity is requisite for revoking a devise. In the construction of this last statute, it has been adjudged that the testator's name, written in his own hand at the beginning of his will, as "I, John Mills, do make this my last will and testament," is a sufficient signing without any name at the bottom, though the other is the safer way. It has also been determined that though the witnesses must all see the testator sign, or at least acknowledge the signing, yet they may do it at different times. But they must all subscribe their names as witnesses in his presence, lest by any possibility they should mistake the instrument. And, in a case determined about 20 years ago, the judges were extremely strict in regard to the credibility, or rather the competency, of the witnesses, for they would not allow any legatee, nor by consequence a creditor, where the legacies and debts were charged on the real estate, to be a competent witness to the devise, as being too deeply concerned in interest, not with the establishment of the will. For, if it were established, he gained a security for his legacy or debt from the real estate, whereas otherwise he had no claim but on the personal assets. This determination, however, alarmed many purchasers and creditors, and threatened to shake most of the titles in the kingdom that depended on devises by will. For, if the will was attested by a servant to whom wages were due, by the apothecary or attorney whose very attendance made them creditors, or by the minister of the parish who had any demand for tithes or ecclesiastical dues, and these are the persons most likely to be present in the testator's last illness, and if in such case the testator had charged his real estate with the payment of his debts, the whole will, and every disposition therein, so far as related to real property, were held to be utterly void. This occasioned the statute 25 George II C6, which restored both the competency and credit of such legatees, by declaring void all legacies given to witnesses, and thereby removing all possibility of their interest affecting their testimony. The same statute likewise established the competency of creditors by directing the testimony of all such creditors to be admitted, but leaving their credit, as well as that of all other witnesses, to be considered on a view of all the circumstances by the court and jury before whom such will shall be contested. And in a much later case, the testimony of 3 witnesses who were creditors was held to be sufficiently credible, though the land was charged with the payment of debts, and the reasons of the former determination were adjudged to be insufficient. Another inconvenience was found to attend this new method of conveyance by devise, in that creditors by bond and other specialties, which affected the heir provided he had assets by descent, were now defrauded of their securities, not having the same remedy against the devise of their debtor. To obviate which, the statute 3 and 4 William and Mary C. 14 hath provided, that all wills and testaments, limitations, dispositions, and appointments of real estates, by tenants in fee simple or having power to dispose by will, shall, as against such creditors only, be deemed to be fraudulent and void, and that such creditors may maintain their actions jointly against both the heir and the devise. A will of lands, made by the permission and under the control of these statutes, is considered by the courts of law not so much in the nature of a testament as of a conveyance declaring the uses to which the land shall be subject, with this difference, that in other conveyances the actual subscription of the witnesses is not required by law, though it is prudent for them to do so, in order to assist their memory when living, and to supply their evidence when dead. But in devises of land such subscription is now absolutely necessary by statute in order to identify a conveyance, which in its nature can never be set up till after the death of the devisor. And upon this notion, that a devise affecting lands is merely a species of conveyance, is founded this distinction between such devises and testaments of personal chattels, that the latter will operate upon whatever the testator dies possessed of, the former only upon such real estates as were his at the time of executing and publishing his will. Wherefore, no afterwards purchased lands will pass under such devise, unless, subsequent to the purchase or contract, the devisor republishes his will. We have now considered the several species of common assurances, whereby a title to lands and tenements may be transferred and conveyed from one man to another. But before we conclude this head, it may not be improper to take notice of a few general rules and maxims which have been laid down by courts of justice for the construction and exposition of them all. These are: 1. That the construction be favorable, and as near the minds and apparent intents of the parties as the rules of law will admit. For the maxims of law are that verba intentione debet inservire, and benigne interpretamur chartas propter simplicitatem laecorum. And therefore the construction must also be reasonable and agreeable to common understanding. 2. That quotas verbis nulla est ambiguitas, ibi nulla exposito contra verba fienda est, but that, where the intention is clear, too minute a stress be not laid on the strict and precise signification of words. Nam qui aret in littera, aret in cortice. Therefore, by a grant of a remainder, a reversion may well pass, and a converso. And another maxim of law is that mala grammatica non vitiat chartam. Neither false English nor bad Latin will destroy a deed, which perhaps a classic critic may think to be no unnecessary caution. 3. That the construction be made upon the entire deed, and not merely upon disjointed parts of it. Nam ex antecedentibus et de consequentibus fit optima interpretatio, and therefore that every part of it be, if possible, made to take effect, and no word but what may operate in some shape or other. Nam verba debent intelligi cum effectu, ut res magis valeat quam periat. 4. That the deed be taken most strongly against him that is the agent or contractor, and in favor of the other party. Verba fortius accipuntur contra praeserentem. For the principle of self-preservation will make men sufficiently careful not to prejudice their own interest by the too extensive meaning of their words, and hereby all manner of deceit in any grant is avoided. For men would always affect ambiguous and intricate expressions, provided they were afterwards at liberty to put their own construction upon them. But here a distinction must be taken between an indenture and a deed poll. For the words of an indenture, executed by both parties, are to be considered as the words of them both. For, though delivered as the words of one party, yet they are not his words only, but the other party hath given his consent to every one of them. But in a deed poll, executed only by the grantor, they are the words of the grantor only, and shall be taken most strongly against him. However, this being a rule of some strictness and rigor, is the last to be resorted to, and is never to be relied upon but where all other rules of exposition fail. 5. That if the words will bear two senses, one agreeable to, and the other against, law, the sense be preferred which is most agreeable thereto. As if tenant entail lets a lease for life generally, it shall be construed for his own life only, for that stands with the law, and not for the life of the lessee, which is beyond his power to grant. 6. That in a deed, if there be two clauses so totally repugnant to each other that they cannot stand together, the first shall be received and the latter rejected. Wherein it differs from a will, for there, of two such repugnant clauses, the latter shall stand, which is owing to the different natures of the two instruments, for the first deed and the last will are always most available in law. Yet, in both cases, we should rather attempt to reconcile them. 7. That a devise may be most favorably expounded to pursue, if possible, the will of the deviser, who, for want of advice or learning, may have omitted the legal and proper phrases. And therefore, many times the law dispenses with the want of words in devises that are absolutely requisite in all other instruments. Thus a fee may be conveyed without words of inheritance, and an estate tail without words of procreation. By a will also an estate may pass by mere implication, without any express words to direct its course, as where A devises lands to his heir at law, after the death of his wife. Here, though no estate is given to the wife in express terms, yet she shall have an estate for life by implication, for the intent of the testator is clearly to postpone the heir till after her death, and if she does not take it, nobody else can. So also, where a devise is of black acre to A, and of white acre to B in tail, and if they both die without issue, then to C in fee. Here A and B have cross remainders by implication, and on the failure of either's issue, the other or his issue shall take the whole, and C's remainder over shall be postponed till the issue of both shall fail. But, to avoid confusion, no cross remainders are allowed between more than two devisees, and, in general, where any implications are allowed, they must be such as are necessary, or at least highly probable, and not merely possible implications. And herein there is no distinction between the rules of law and of equity. For the will, being considered in both courts in the light of a limitation to uses, is construed in each with equal favor and benignity, and expounded rather on its own particular circumstances than by any general rules of positive law. And thus we have taken a transient view, in this and the three preceding chapters, of a very large and diffusive subject, the doctrine of common assurances, which concludes our observations on the title to things real, or the means by which they may be reciprocally lost and acquired. We have before considered the estates which may be had in them, with regard to their duration or quantity of interest, the time of their enjoyment, and the number and connections of the persons entitled to hold them. We have examined the tenures, both ancient and modern, whereby those estates have been and are now holden, and have distinguished the object of all these inquiries, namely, things real, into the corporeal or substantial, and incorporeal or ideal kind, and have thus considered the rights of real property in every light wherein they are contemplated by the laws of England. A system of laws that differs much from every other system, except those of the same feudal origin, in its notions and regulations of landed estates, and which therefore could in this particular be very seldom compared with any other. The subject, which has thus employed our attention, is of very extensive use and of as extensive variety. And yet, I am afraid, it has afforded the student less amusement and pleasure in the pursuit than the matters discussed in the preceding volume. To say the truth, the vast alterations which the doctrine of real property has undergone from the Conquest to the present time, the infinite determinations upon points that continually arise, and which have been heaped one upon another for a course of 7 centuries, without any order or method, and the multiplicity of acts of Parliament which have amended, or sometimes only altered, the common law, these cases have made the study of this branch of our national jurisprudence a little perplexed and intricate. It hath been my endeavor principally to select such parts of it as were of the most general use, where the principles were the most simple, and the reasons of them the most obvious, and the practice the least embarrassed. Yet I cannot presume that I have always been thoroughly intelligible to such of my readers as were before strangers even to the very terms of art, which I have been obliged to make use of, though whenever those have first occurred, I have generally attempted a short explication of their meaning. These are indeed the more numerous, on account of the different languages which our law has at different periods been taught to speak, the difficulty arising from which will insensibly diminish by use and familiar acquaintance. And therefore I shall close this branch of our inquiries with the words of Sir Edward Coke: albeit the student shall not at any one day do what he can, reach to the full meaning of all that is here laid down, yet let him no way discourage himself, but proceed. For on some other day, in some other place, or perhaps upon a second perusal of the same, his doubts will probably be removed. End of chapter 23. Chapter 24 of the Commentaries on the Laws of England, Book 2, by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Of Things Personal. Under the name of things personal are included all sorts of things movable, which may attend a man's person wherever he goes, and therefore, being only the objects of the law while they remain within the limits of its jurisdiction, and being also of a perishable quality, are not esteemed of so high a nature, nor paid so much regard to by the law, as things that are in their nature more permanent and immovable, as lands and houses, and the profits issuing thereout. These being constantly within the reach and under the protection of the law, were principal favorites of our first legislators, who took all imaginable care in ascertaining the rights and directing the disposition of such property as they imagined to be lasting, and which would answer to posterity the trouble and pains that their ancestors employed about them, but at the same time entertained a very low and contemptuous opinion of all personal estate, which they regarded as only a transient commodity. The amount of it indeed was, comparatively, very trifling, during the scarcity of money and the ignorance of luxurious refinements which prevailed in the feudal ages. Hence it was that a tax of the 15th, 10th, or sometimes a much larger proportion, of all the movables of the subject was frequently laid without scruple, and is mentioned with much unconcern by our ancient historians, though now it would justly alarm our opulent merchants and stockholders. And hence likewise may be derived the frequent forfeitures inflicted by the common law of all a man's goods and chattels for misbehaviors and inadvertencies that at present hardly seem to deserve so severe a punishment. Our ancient law books, which are founded upon the feudal provisions, do not therefore often condescend to regulate this species of property. There is not a chapter in Britain or the Mirror that can fairly be referred to this head, and the little that is to be found in Glanville, Bracton, and Fleta seems principally borrowed from the civilians. But of later years, since the introduction and extension of trade and commerce, which are entirely occupied in this species of property, and have greatly augmented its quantity and of course its value, we have learned to conceive different ideas of it. Our courts now regard a man's personality in a light nearly, if not quite, equal to his realty, and have adopted a more enlarged and less technical mode of considering the one than the other, frequently drawn from the rules which they found already established by the Roman law, wherever those rules appeared to be well grounded and opposite to the case in question, but principally from reason and convenience, adapted to the circumstances of the times, preserving withal a due regard to ancient usages and a certain feudal tincture, which is still to be found in some branches of personal property. But things personal, by our law, do not only include things movable, but also something more, the whole of which is comprehended under the general name of chattels, catala, which, Sir Edward Coke says, is a French word signifying goods. And this is true, if understood of the Norman dialect, for in the Grand Costumier we find the word chattels used and set in opposition to a fief or a feud, so that not only goods, but whatever was not a feud, were accounted chattels. And it is, I apprehend, in the same large, extended, negative sense that our law adopts it, the idea of goods or movables only being not sufficiently comprehensive to take in everything that our law considers as a chattel interest. For since, as the commentator on the Costumier observes, there are two requisites to make a fief or heritage, duration as to time, and immobility with regard to place. Whatever wants either of these qualities is not, according to the Normans, an heritage or fief, or, according to us, is not a real estate, the consequence of which in both laws is, that it must be a personal estate or chattel. Chattels, therefore, are distributed by the law into two kinds, chattels real and chattels personal. 1. Chattels real, saith Sir Edward Coke, are such as concern or favor of the realty, as terms for years of land, wardships and chivalry, while the military tenure subsisted, the next presentation to a church, estates by statute merchant, statute staple, elegit, or the like, of all which we have already spoken. And these are called real chattels, as being interests issuing out of or annexed to real estates, of which they have one quality, viz., immobility, which denominates them real, but want the other, viz., a sufficient, legal, indeterminate duration, and this want it is that constitutes them chattels. The utmost period for which they can last is fixed and determinate, either for such a space of time certain, or till such a particular sum of money be raised out of such a particular income, so that they are not equal in the eye of the law to the lowest estate of freehold, a lease for another's life. Their tenants were considered, upon feudal principles, as merely bailiffs or farmers, and the tenant of the freehold might at any time have destroyed their interest till the reign of Henry VIII. A freehold, which alone is a real estate, and seems, as has been said, to answer to the fief in Normandy, is conveyed by corporal investiture and livery of season, which gives the tenant so strong a hold of the land that it never after can be wrested from him during his life, but by his own act of voluntary transfer or of forfeiture, or else by the happening of some future contingency, as in estates pour auter vie, and the determinationable freeholds mentioned in a former chapter. And even these, being of an uncertain duration, may by possibility last for the owner's life, for the law will not presuppose the contingency to happen before it actually does, and till then the estate is to all intents and purposes a life estate, and therefore a freehold interest. On the other hand, a chattel interest in lands, which the Normans put in opposition to fief, and we to freehold, is conveyed by no season or corporal investiture, but the possession is gained by the mere entry of the tenant himself, and it is sure to expire at a time prefixed and determined, if not sooner. Thus, a lease for years must necessarily fail at the end and completion of the term. The next presentation to a church is satisfied and gone the instant it comes into possession, that is, by the first avoidance and presentation to the living. The conditional estates by statutes and elegit are determined as soon as the debt is paid, and so guardianships in chivalry were sure to expire the moment that the heir came of age. And if there be any other chattel real, it will be found to correspond with the rest in this essential quality, that its duration is limited to a time certain beyond which it cannot subsist. 2. Chattels personal are, properly and strictly speaking, things movable, which may be annexed to or attendant on the person of the owner, and carried about with him from one part of the world to another. Such are animals, household stuff, money, jewels, corn, garments, and everything else that can properly be put in motion and transferred from place to place. And of this kind of chattel it is that we are principally to speak in the remainder of this book, having been unavoidably led to consider the nature of chattels real and their incidents in the former chapters which were employed upon real estates. That kind of property being of a mongrel amphibious nature, originally endowed with one only of the characteristics of each species of things, the immobility of things real, and the precarious duration of things personal. Chattel interests being thus distinguished and distributed, it will be proper to consider, first, the nature of that property or dominion to which they are liable, which must be principally, nay solely, referred to personal chattels, and secondly, the title to that property, or how it may be lost and acquired. Of each of these in its order. End of chapter 24. Chapter 25 of the Commentaries on the Laws of England, Book 2 by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Of Property and Things Personal. Property, in chattels personal, may be either in possession, which is where a man hath not only the right to enjoy, but hath the actual enjoyment of the thing, or else it is in action, where a man hath only a bare right without any occupation or enjoyment. And of these the former, or property in possession, is divided into two sorts, an absolute and a qualified property. 1. First, then, of property in possession absolute, which is where a man hath, solely and exclusively, the right and also the occupation of any movable chattels, so that they cannot be transferred from him or cease to be his without his own act or default. Such may be all inanimate things, as goods, plate, money, jewels, implements of war, garments, and the like. Such also may be vegetable productions, as the fruit or other parts when severed from the plant, or the whole plant itself when severed from the ground, none of which can be moved out of the owner's possession without his own act or consent, or at least without doing him an injury, which it is the business of the law to prevent or remedy. Of these, therefore, remains little to be said. But with regard to animals, which have in themselves a principle and power of motion, and, unless particularly confined, can convey themselves from one part of the world to another, there is a great difference made with respect to their several classes, not only in our law, but in the law of nature and all civilized nations. They are distinguished into such as are domitae, and such as are verae naturae, some being of a tame and others of a wild disposition. In such as are of a nature tame and domestic, as horses, kine, sheep, poultry, and the like, a man may have as absolute a property as in any inanimate beings, because these continue perpetually in his occupation, and will not stray from his house or person unless by accident or fraudulent enticement, in either of which cases the owner does not lose his property, in which our law agrees with the laws of France and Holland. The stealing or forcible abduction of such property as this is also a felony, for these are things of intrinsic value, serving for the food of man, or else for the uses of husbandry. But in animals verae naturae, a man can have no absolute property. Of all tame and domestic animals, the brood belongs to the owner of the dam, or mother, the English law agreeing with the civil that partus sequitur ventrum in the brute creation, though for the most part in the human species it disallows that maxim. And therefore, in the laws of England as well as Rome, sia quam meum equus tus praegnantem feceret, non est tuum sed meum quod natum est. And for this Pufendorf gives a sensible reason, not only because the male is frequently unknown, but also because the dam during her time of pregnancy is almost useless to the proprietor, and must be maintained with greater expense and care. Wherefore, as her owner is the loser by her pregnancy, he ought to be the gainer by her brood. An exception to this rule is in the case of young cygnets, which belong equally to the owner of the cock and hen, and shall be divided between them. But here the reasons of the general rule cease, and cessante ratione cessat et ipsa lex. For the male is well known by his constant association with the female, and for the same reason the owner of one doth not suffer more disadvantage during the time of pregnancy and nurture than the owner of the other. 2. Other animals that are not of a tame and domestic nature are either not the objects of property at all, or else fall under our other division, namely that of qualified, limited, or special property, which is such as is not in its nature permanent, but may sometimes subsist, and at other times not subsist. In discussing which subject, I shall in the first place show how this species of property may subsist in such animals as are ferae naturae, or of a wild nature, and then how it may subsist in any other things when under particular circumstances. First, then, a man may be invested with a qualified but not an absolute property in all creatures that are ferae naturae, either per industrium, propter impotentium, or propter privilegium. 1. A qualified property may subsist in animals ferae naturae per industrium hominis, by a man's reclaiming and making them tame by art, industry, and education, or by so confining them within his own immediate power that they cannot escape and use their natural liberty. And under this head some writers have ranked all the former species of animals we have mentioned, apprehending none to be originally and naturally tame, but only made so by art and custom, as horses, swine, and other cattle, which, if originally left to themselves, would have chosen to rove up and down, seeking their food at large, and are only made domestic by use and familiarity, and are therefore, say they, called mansueta quasi manui assueta. But however well this notion may be founded, abstractly considered, our law apprehends the most obvious distinction to be between such animals as we generally see tame, and are therefore seldom, if ever, found wandering at large, which it calls domitae naturae, and such creatures as are usually found at liberty, which are therefore supposed to be more emphatically ferae naturae, though it may happen that the latter shall be sometimes tamed and confined by the art and industry of man, such as are deer in a park, hares or rabbits in an enclosed warren, doves in a dove house, pheasants or partridges in a mew, hawks that are fed and commanded by their owner, and fish in a private pond or in trunks. These are no longer the property of a man than while they continue in his keeping or actual possession. But if at any time they regain their natural liberty, his property instantly ceases, unless they have animum revertendi, which is only to be known by their usual custom of returning, a maxim which is borrowed from the civil law. Revertente animum videntur desinere abere tunc, cum revertendi consuetudinem deseruint. The law, therefore, extends this possession farther than the mere manual occupation, for my tame hawk that is pursuing his quarry in my presence, though he is at liberty to go where he pleases, is nevertheless my property, for he hath animum revertendi. So are my pigeons that are flying at a distance from their home, especially of the carrier kind, and likewise the deer that is chased out of my park or forest, and is instantly pursued by the keeper or forester, all which remain still in my possession, and I still preserve my qualified property in them. But if they stray without my knowledge, and do not return in the usual manner, it is then lawful for any stranger to take them. But if a deer, or any wild animal reclaimed, hath a collar or other mark put upon him, and goes and returns at his pleasure, or if a wild swan is taken, and marked and turned loose in the river, the owner's property in him still continues, and it is not lawful for any one else to take him, but otherwise, if the deer has been long absent without returning, or the swan leaves the neighborhood. These are also ferae naturae, but when hived and reclaimed, a man may have a qualified property in them, by the law of nature as well as by the civil law, and to the same purpose, not to say in the same words with the civil law, speaks Bracton. Occupation, that is, hiving or including them, gives the property in bees. For though a swarm lights upon my tree, I have no more property in them till I have hived them, than I have in the birds which make their nests thereon. And therefore, if another hives them, he shall be their proprietor. But a swarm which fly from and out of my hive are mine so long as I can keep them in sight and have power to pursue them. And in these circumstances no one else is entitled to take them. But it hath also been said that with us the only ownership in bees is ratione soli, and the charter of the forest, which allows every freeman to be entitled to the honey found within his own woods, affords great countenance to this doctrine, that a qualified property may be had in bees, in consideration of the property of the soil whereon they are found. In all these creatures reclaimed from the wildness of their nature, the property is not absolute, but defeasible, a property that may be destroyed if they resume their ancient wildness and are found at large. For if the pheasants escape from the mew, or the fishes from the trunk, and are seen wandering at large in their proper element, they become ferae naturae again, and are free and open to the first occupant that has the ability to seize them. But while they thus continue my qualified or defeasible property, they are as much under the protection of law as if they were absolutely and indefeasibly mine, and an action will lie against any man that detains them from me, or unlawfully destroys them. It is also as much felony by common law to steal such of them as are fit for food, as it is to steal tame animals, but not so if they are only kept for pleasure, curiosity, or whim, as dogs, bears, cats, apes, parrots, and singing birds, because their value is not intrinsic, but depending only on the caprice of the owner, though it is such an invasion of property as may amount to a civil injury, and be redressed by a civil action. Yet to steal a reclaimed hawk is felony both by common law and statute, which seems to be a relic of the tyranny of our ancient sportsmen. And, among our elder ancestors, the ancient Britons, another species of reclaimed animal, viz., cats, were looked upon as creatures of intrinsic value, and the killing or stealing one was a grievous crime, and subjected the offender to a fine, especially if it belonged to the king's household and were the curious aurae regii, for which there were a very particular forfeiture. And thus much of qualified property in wild animals reclaimed per industriam. 2. A qualified property may also subsist with relation to animals ferae naturae ratione impotantiae, on account of their own inability, as when hawks, herons, or other birds build in my trees, or conies or other creatures make their nests or burrows in my land, and have young ones there. I have a qualified property in those young ones, till such time as they can fly or run away, and then my property expires. But, till then, it is in some cases trespass, and in others felony, for a stranger to take them away. For here, as the owner of the land has it in his power to do what he pleases with them, the law therefore vests a property in him of the young ones, in the same manner as it does of the old ones if reclaimed and confined, for these cannot through weakness, any more than the others through restraint, use their natural liberty and forsake him. 3. A man may, lastly, have a qualified property in animals ferae naturae propter privilegium, that is, he may have the privilege of hunting, taking, and killing them, in exclusion of other persons. Here he has a transient property in these animals, usually called game, so long as they continue within his liberty, and may restrain any stranger from taking them therein. But the instant they depart into another liberty, this qualified property ceases. The manner in which this privilege is acquired will be shown in a subsequent chapter. The qualified property which we have hitherto considered extends only to animals verae naturae, when either reclaimed, impotent, or privileged. Many other things may also be the objects of qualified property. It may subsist in the very elements of fire or light, of air and of water. A man can have no absolute permanent property in these, as he may in the earth or land, since these are of a vague and fugitive nature, and therefore can admit only of a precarious and qualified ownership, which lasts so long as they are in actual use and occupation, but no longer. If a man disturbs another, and deprives him of lawful enjoyment of these, if one obstructs another's ancient windows, corrupts the air of his house or gardens, fouls his water, or unpens and lets it out, or if he diverts an ancient watercourse that used to run to the other's mill or meadow, the law will animadvert hereon as an injury, and protect the party injured in his possession. But the property in them ceases the instant they are out of possession. For, when no man is engaged in their actual occupation, they become again common, and every man has an equal right to appropriate them to his own use. These kinds of qualification in property depend upon the peculiar circumstances of the subject matter, which is not capable of being under the absolute dominion of any proprietor. But property may also be of a qualified or special nature, on account of the peculiar circumstances of the owner, when the thing itself is very capable of absolute ownership, as in the case of bailment or delivery of goods to another person for a particular use, as to a carrier to convey to London, to an innkeeper to secure his inn, or the like. Here there is no absolute property in either the bailor or the bailee, the person delivering, or him to whom it is delivered. For the bailor hath only the right, and not the immediate possession. The bailee hath the possession, and only a temporary right. But it is a qualified property in them both, and each of them is entitled to an action in case the goods be damaged or taken away. The bailee, on account of his immediate possession; the bailor, because the possession of the bailee is mediately his possession also. So also in case of goods pledged or pawned upon condition, either to repay money or otherwise. Both the pledgor and pledgee have a qualified, but neither of them an absolute property therein. The pledgor's property is conditional, and depends upon the performance of the condition of repayment, etc., and so too is that of the pledgee, which depends upon its non-performance. The same may be said of goods distrained for rent, or other cause of distress, which are in the nature of a pledge, and are not, at the first taking, the absolute property of either the distrainer or party distrained, but may be redeemed or else forfeited by the subsequent conduct of the latter. But a servant, who hath the care of his master's goods or chattels, as a butler of plate, a shepherd of sheep, and the like, hath not any property or possession either absolute or qualified, but only a mere charge or oversight. Having thus considered the several divisions of property in possession, which subsists there only, where a man hath both the right and also the occupation of the thing, we will proceed next to take a short view of the nature of property in action, or such where a man hath not the occupation, but merely a bare right to occupy the thing in question. The possession whereof may, however, be recovered by a suit or action at law, from whence the thing so recoverable is called a thing or chose in action. Thus, money due on a bond is a chose in action, For a property in the debt vests at the time of forfeiture mentioned in the obligation, but there is no possession till recovered by course of law. If a man promises or covenants with me to do any act and fails in it, whereby I suffer damage, the recompense for this damage is a chose in action. For though a right to some recompense vests in me at the time of the damage done, yet what and how large such recompense shall be can only be ascertained by verdict, and the possession can only be given me by legal judgment and execution. In the former of these cases, the student will observe that the property or right of action depends upon an express contract or obligation to pay a stated sum, and in the latter it depends upon an implied contract, that if the covenantor does not perform the act he engaged to do, he shall pay me the damages I sustain by this breach of covenant. And hence it may be collected that all property in action depends entirely upon contracts, either express or implied, which are the only regular means of acquiring a chose in action, and of the nature of which we shall discourse at large in a subsequent chapter. At present we have only to remark that upon all contracts or promises, either express or implied, and the infinite variety of cases into which they are and may be spun out, the law gives an action of some sort or other to the party injured in case of non-performance, to compel the wrongdoer to do justice to the party with whom he has contracted, and, on failure of performing the identical thing he engaged to do, to render a satisfaction equivalent to the damage sustained. But while the thing, or its equivalent, remains in suspense, and the injured party has only the right and not the occupation, it is called a chose in action, being a thing rather in potentia than in esse, though the owner may have as absolute a property of such things in action as of things in possession. And having thus distinguished the different degree or quantity of dominion or property to which things personal are subject, we may add a word or two concerning the time of their enjoyment and the number of their owners, in conformity to the method before observed in treating of the property of things real. First, as to the time of enjoyment. By the rules of the ancient common law, there could be no future property to take place in expectancy created in personal goods and chattels, because being things of transitory and by many accidents subject to be lost, destroyed, or otherwise impaired, the exigencies of trade requiring also a frequent circulation thereof, it would occasion perpetual suits and quarrels, and put a stop to the freedom of commerce if such limitations in remainder were generally tolerated and allowed. But yet, in last wills and testaments, such limitations of personal goods and chattels in remainder after a bequest for life were permitted, though originally that indulgence was only shown when merely the use of the goods, and not the goods themselves, was given to the first legatee, the property being supposed to continue all the time in the executor of the deviser. But now that distinction is disregarded, and therefore, if a man, either by deed or will, limits his books or furniture to A for life, with remainder over to B, this remainder is good. But where an estate tail in things personal is given to the first or any subsequent possessor, it vests in him the total property, and no remainder over shall be permitted on such limitation. For this, if allowed, would tend to a perpetuity, as the devise or grantee in tail of a chattel has no method of barring the entail, and therefore the law vests in him at once the entire dominion of the goods, being analogous to the fee simple which a tenant in tail may acquire in a real estate. Next, as to the number of owners. Things personal may belong to their owners not only in severalty, but also in joint tenancy and in common, as well as real estates. they cannot indeed be vested in coparcenary, because they do not descend from the ancestor to the heir, which is necessary to constitute coparceners. But if a horse or other personal chattel be given to two or more, absolutely they are joint tenants hereof. And unless the jointure be severed, the same doctrine of survivorship shall take place as in estates of lands and tenements. And, in like manner, if the jointure be severed, as by either of them selling his share, the vendee and the remaining part owner shall be tenants in common, without any jus accrescendi or survivorship. So also, if £100 be given by will to two or more, equally to be divided between them, this makes them tenants in common. As we have formerly seen, the same words would have done in regard to real estates. But, for the encouragement of husbandry and trade, it is held that a stock on a farm, though occupied jointly, and also a stock used in a joint undertaking, by way of a partnership in trade, shall always be considered as common and not joint property, and there shall be no survivorship therein. End of chapter 25. Chapter 26 of the Commentaries on the Laws of England, Book 2, by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Of Title to Things Personal by Occupancy. We are next to consider the title to things personal, or the various means of acquiring and of losing such property as may be had therein, both which considerations of gain and loss shall be blended together in one and the same view, as was done in our observations upon real property, since it is for the most part impossible to contemplate the one without contemplating the other also. And these methods of acquisition or loss are principally 12. 1. By occupancy. 2. By prerogative. 3. By forfeiture. 4. By custom. 5. By succession. 6. By marriage. 7. By judgment. 8. By gift. 9. By contract. 10. By bankruptcy. 11. By testament. 12. By administration. And first, a property in goods and chattels may be acquired by occupancy, which, we have more than once remarked, was the original and only primitive method of acquiring any property at all, but which has since been restrained and abridged by the positive laws of society in order to maintain peace and harmony among mankind. For this purpose, by the laws of England, gifts and contracts, testaments, legacies, and administrations have been introduced and countenanced in order to transfer and continue that property and possession in things personal which has once been acquired by the owner. And, where such things are found without any other owner, they for the most part belong to the king by virtue of his prerogative, except in some few instances wherein the original and natural right of occupancy is still permitted to subsist, and which we are now to consider. 1. Thus, in the first place, it hath been said, that anybody may seize to his own use such goods as belong to an alien enemy. For such enemies, not being looked upon as members of our society, are not entitled during their state of enmity to the benefit or protection of the laws, and therefore every man that has opportunity is permitted to seize upon their chattels without being compelled, as in other cases, to make restitution or satisfaction to the owner. But this, however, generally laid down by some of our writers, must in reason and justice be restrained to such captors as are authorized by the public authority of the state residing in the crown, and to such goods as are brought into this country by an alien enemy after a declaration of war, without a safe conduct or passport. And therefore it hath been held, that where a foreigner is resident in England, and afterwards a war breaks out between his country and ours, his goods are not liable to be seized. It hath also been adjudged, that if an enemy take the goods of an Englishman, which are afterwards retaken by another subject of this kingdom, the former owner shall lose his property therein, and it shall be indefeasibly vested in the second taker, unless they were retaken the same day, and the owner before sunset puts in his claim of property, which is agreeable to the law of nations as understood in the time of Grotius, even with regard to captures made at sea, which were held to be the property of the captors after a possession of 24 hours, though the modern authorities require that before the property can be changed, the goods must have been brought into port and have continued a night intra praesidia in a place of safe custody, so that all hope of recovering them is lost. And, as in the goods of an enemy, so also in his person, a man may acquire a sort of qualified property by taking him a prisoner in war, at least till his ransom be paid. And this doctrine seems to have been extended to negro servants, who are purchased when captives of the nations with whom they are at war, and continue therefore in some degree the property of their masters who buy them, though, accurately speaking, that property consists rather in the perpetual service than in the body or person of the captive. 2. Thus again, whatever movables are found upon the surface of the earth or in the sea, and are unclaimed by any owner, are supposed to be abandoned by the last proprietor, and, as such, are returned into the common stock and mass of things, and therefore they belong, as in a state of nature, to the first occupant or fortunate finder, unless they fall within the description of waifs or estrays or wreck or hidden treasure, for these we have formerly seen are vested by law in the king, and form a part of the ordinary revenue of the crown. 3. Thus too the benefit of the elements, the light, the air, and the water, can only be appropriated by occupancy. If I have an ancient window overlooking my neighbor's ground, he may not erect any blind to obstruct the light. But if I build my house close to his wall which darkens it, I cannot compel him to demolish his wall, for there the first occupancy is rather in him than in me. If my neighbor makes a tan yard, so as to annoy and render less fabulous the air of my house or gardens, the law will furnish me with a remedy. But if he is first in possession of the air, and I fix my habitation near him, the nuisance is of my own seeking and must continue. If a stream be unoccupied, I may erect a mill thereon, and detain the water, yet not so as to injure my neighbor's prior mill or his meadow, for he hath by first occupancy acquired a property in the current. 4. With regard likewise to animals ferae naturae, all mankind had by the original grant of the Creator a right to pursue and take any fowl or insect of the air, any fish or inhabitant of the waters, and any beast or reptile of the field, and this natural right still continues in every individual, unless where it is restrained by the civil laws of the country. And when a man has once so seized them, they become, while living, his qualified property, or, if dead, are absolutely his own, so that to steal them or otherwise invade this property is, according to the respective values, sometimes a criminal offense, sometimes only a civil injury. The restrictions which are laid upon this right by the laws of England relate principally to royal fish, as whale and sturgeon, and such terrestrial, aerial, or aquatic animals as go under the denomination of game, the taking of which is made the exclusive right of the prince, and such of his subjects to whom he has granted the same royal privilege. But those animals which are not expressly so reserved are still liable to be taken and appropriated by any of the king's subjects upon their own territories, in the same manner as they might have taken even game itself, till these civil prohibitions were issued, there being in nature no distinction between one species of wild animals and another, between the right of acquiring property in a hare or a squirrel, in a partridge or a butterfly, but the difference at present made arises merely from the positive municipal law. 5. To this principle of occupancy also must be referred the method of acquiring a special personal property in corn growing on the ground, or other emblements, by any possessor of the land who hath sown or planted it, whether he be owner of the inheritance in fee or in tail, or be tenant for life, for years, or at will, which emblements are distinct from the real estate in the land, and subject to many, though not all, the incidents attending personal chattels. They were divisible by testament before the statute of wills, and at the death of the owner shall vest in his executor and not his heir. They are forfeitable by outlawry in a personal action, and by statute 2 George II, c. 19, though not by the common law. They may be distrained for rent arrear. The reason for admitting the acquisition of this special property by tenants who have temporary interests was formerly given, and it was extended to tenants in fee principally for the benefit of their creditors, and therefore, though the emblements are assets in the hands of the executor, are forfeitable upon outlawry and distrainable for rent, they are not in other respects considered as personal chattels, and particularly they are not the object of larceny before they are severed from the ground. 6. The doctrine of property arising from accession is also grounded on the right of occupancy. By the Roman law, if any given corporeal substance received afterwards an accession by natural or by artificial means, as by the growth of vegetables, the pregnancy of animals, the embroidering of cloth, or the conversion of wood or metal into vessels and utensils, the original owner of the thing was entitled by his right of possession to the property of it under such its state of improvement. But if the thing itself, by such operation, was changed into a different species, as by making wine, oil, or bread out of another's grapes, olives, or wheat, it belonged to the new operator, who was only to make a satisfaction to the former proprietor for the materials which he had so converted. And these doctrines are implicitly copied and adopted by our Blackstone in the reign of King Henry III, and have since been confirmed by many resolutions of the courts. It hath even been held that if one takes away another's wife or son, and clothes them, and afterwards the husband or father retakes them back, the garments shall cease to be the property of him who provided them, being now annexed to the person of the child or woman. 7. But in case of confusion of goods, where those of two persons are so intermixed that the several portions can be no longer distinguished, the English law partly agrees with, and partly differs from, the civil. If the intermixture be by consent, I apprehend that in both laws the proprietors have an interest in common, in proportion to their respective shares. But if one wilfully intermixes his money, corn, or hay with that of another man without his approbation or knowledge, or casts gold in a like manner into another's melting pot or crucible, the civil law, though it gives the sole property of the whole to him who has not interfered in the mixture, yet allows a satisfaction to the other for what he has so improvidently lost. But our law, to guard against fraud, allows no remedy in such a case, but gives the entire property without any account to him whose original dominion is invaded, and endeavored to be rendered uncertain without his own consent. 8. There is still another species of property which, being grounded on labor and invention, is more properly reducible to the head of occupancy than any other. Since the right of occupancy itself is supposed by Mr. Locke and many others to be founded on the personal labor of the occupant, and this is the right which an author may be supposed to have in his own original literary compositions, so that no other person without his leave may publish or make profit of the copies. When a man by the exertion of his rational powers has produced an original work, he has clearly a right to dispose of that identical work as he pleases, and any attempt to take it from him, or vary the disposition he has made of it, is an invasion of his right of property. Now, the identity of a literary composition consists entirely in the sentiment and the language. The same conceptions clothed in the same words must necessarily be the same composition, and whatever method be taken of conveying that composition to the ear or the eye of another, by recital, by writing, or by printing, in any number of copies or at any period of time, it is always the identical work of the author which is so conveyed, and no other man can have a right to convey or transfer it without his consent, either tacitly or expressly given. This consent may perhaps be tacitly given when an author permits his work to be published, without any reserve of right, and without stamping on it any marks of ownership. It is then a present to the public, like the building of a church or the laying out of a new highway. But in case of a bargain for a single impression, or a sale or gift of the copyright, the reversion is plainly continued in the original proprietor, or the whole property transferred to another. The Roman law adjudged that if one man wrote anything, though never so elegantly, on the paper or parchment of another, the writing should belong to the original owner of the materials on which it was written, meaning certainly nothing more thereby than the mere mechanical operation of writing, for which it directed the scribe to receive a satisfaction, especially as, in works of genius and invention, such as a picture painted on another man's canvas, the same law gave the canvas to the painter. We find no other mention in the civil law of any property in the works of the understanding, though the sale of literary copies for the purposes of recital or multiplication is certainly as ancient as the times of Terence, Martial, and Statius. Neither with us in England hath there been any direct determination upon the right of authors at the common law, but much may be gathered from the frequent injunctions of the Court of Chancery, prohibiting the invasion of this property, especially where either the injunctions have been perpetual, or have related to unpublished manuscripts, or to such ancient books as were not within the provisions of the statute of Queen Anne. Much may also be collected from the several legislative recognitions of copyrights, and from these adjudged cases at common law, wherein the Crown hath been considered as invested with certain prerogative copyrights. For, if the Crown is capable of an exclusive right in any one book, the subject seems also capable of having the same right in another. But, exclusive of such copyright as may subsist by the rules of the common law, the statute 8 Ann c. 19 hath protected by additional penalties the property of authors and their assigns for the term of 14 years, and hath directed that if, at the end of that term, the author himself be living, that right shall then return to him for another term of the same duration, and a similar privilege is extended to the inventors of prints and engravings for the term of 14 years by the statute 8 George II, c. 13, both which appear to have been copied from the exception in the statute of monopolies 21 Jacobin I, c. 3, which allows a royal patent of privilege to be granted for 14 years to any inventor of a new manufacture for the sole working or making of the same, by virtue whereof a temporary property becomes vested in the patentee. And the statute 12 George II, c. 36, hath also superadded other penalties and forfeitures in case any book first composed or written and printed in Great Britain shall be reprinted abroad and imported for sale into this kingdom. End of chapter 26. Chapter 27, Part 1 of the Commentaries on the Laws of England, Book 2 by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Of Title by Prerogative and Forfeiture, Part 1. A second method of acquiring property in personal chattels is by the king's prerogative, whereby a right may accrue either to the crown itself or to such as claim under the title of the crown, as by grant or prescription. Such, in the first place, are all tributes, taxes, and customs, whether constitutionally inherent in the crown, as flowers of the prerogative and branches of the sensus regalis, or ancient royal revenue, or whether they occasionally be created by authority of Parliament, of both which species of revenue we treated largely in the former volume. In these the king acquires and the subject loses a property the instant they become due. If paid, they are a chose in possession; if unpaid, a chose in action. Hither also may be referred all forfeitures, fines, and amercements due the king, which accrue by virtue of his ancient prerogative or by particular modern statutes, which revenues created by statute do always assimilate or take the same nature with the ancient revenues, and may therefore be looked upon as arising from a kind of artificial or secondary prerogative. And in either case, the owner of the thing forfeited and the person fined or amerced do lose and part with the property of the forfeiture, fine, or amercement the instant the king or his grantee acquires it. In these several methods of acquiring property by prerogative, there is also this peculiar quality, that the king cannot have a joint property with any person in one entire chattel, or such as one as is not capable of division or separation. But where the titles of the king and a subject concur, the king shall have the whole, in like manner as the king can, neither by grant nor contract, become a joint tenant of a chattel real with another person, but by such grant or contract shall become entitled to the whole in severalty. Thus, if a horse be given to the king and a private person, the king shall have the sole property. If a bond be made to the king and a subject, the king shall have the whole penalty, the debt or duty being one single chattel. And so, if two persons have the property of a horse between them, or have a joint debt owing them on bond, and one of them assigns his part to the king, or is attainted, whereby his moiety is forfeited to the crown, the king shall have the entire horse and the entire debt. For, as it is not consistent with the dignity of the crown to be a partner with a subject, so neither does the king ever lose his right in any instance. But, where they interfere, his is always preferred to that of another person. From which two principles it is a necessary consequence that the innocent, though unfortunate partner must lose his share in both the debt and the horse, or in any other chattel in the same circumstances. This doctrine has no opportunity to take place in certain other instances of title by prerogative that remain to be mentioned, as the chattels thereby vested are originally and solely vested in the crown, without any transfer or derivative assignment either by deed or law from any former proprietor. Such is the acquisition of property in wreck, in treasure trove, in waifs, in estrays, in royal fish, in swans and the like, which are not transferred to the sovereign from any former owner, but are originally inherent in him by the rules of law, and are derived to particular subjects as royal franchises by his bounty. These are ascribed to him, partly upon the particular reasons mentioned in the 8th chapter of the former book, and partly upon the general principle of their being bona vacantia, and therefore vested in the king, as well to preserve the peace of the public as in trust to employ them for the safety and ornament of the commonwealth. With regard to the prerogative copyrights, which were mentioned in the preceding chapter, they are held to be vested in the crown upon different reasons. Thus, 1. The king, as executive magistrate, has the right of promulging to the people all acts of state and government. This gives him the exclusive privilege of printing, at his own press or that of his grantees, all acts of Parliament, proclamations, and orders of council. 2. As supreme head of the Church, he hath a right to the publication of all liturgies and books of divine service. 3. He hath a right by purchase to the copies of such law books, grammars, and other compositions as were compiled or translated at the expense of the crown. And upon these two last principles the exclusive right of printing the translation of the Bible is founded. 4. Almanacs have been said to be prerogative copies, either as things derelict, or else as being substantially nothing more than the calendar prefixed to our liturgy. And indeed, the regulation of time has been often considered a matter of state. The Roman Fasti were under the care of the Pontifical College, and Romulus, Numa, and Julius Caesar successively regulated the Roman calendar. There still remains another species of prerogative property, founded upon a very different principle from any that have been mentioned before, the property of such animals ferae naturae as are known by the denomination of game, with the right of pursuing, taking, and destroying them, which is vested in the king alone, and from him derived to such of his subjects as have received the grants of a chase, a park, a free warren, or a free fishery. This may lead us into an inquiry concerning the original of these franchises or royalties, on which we touched a little in the former chapter, the right itself being an incorporeal hereditament, though the fruits and profits of it are of a personal nature. In the first place, then, we have already shown, and indeed it cannot be denied, that by the law of nature every man, from the prince to the peasant, has an equal right of pursuing and taking to his own use all such creatures as are ferae naturae, and therefore the property of nobody, but liable to be seized by the first occupant. And so it was held by the imperial law, even so late as Justinian's time. Ferae igitur bestia, et volucres, et omnia animali quo mari, coelo et terra nascuntur, simul atque ab aliquo capta fuerent, iure gentium statim ilius esse incipient, quod enim nullius est, id naturali ratione occupante conjuditor. But it follows from the very end and constitution of society that this natural right, as well as many others belonging to man as an individual, may be restrained by positive laws enacted for reasons of state or for the supposed benefit of the community. This restriction may be either with respect to the place in which this right may or may not be exercised, with respect to the animals that are the subject of this right, or with respect to the persons allowed or forbidden to exercise it. And, in consequence of this authority, we find that the municipal laws of many nations have exerted such power of restraint, have in general forbidden the entering on another man's grounds for any cause, without the owner's leave, have extended their protection to such particular animals as are usually the objects of pursuit, and have invested the prerogative of hunting and taking such animals in the sovereign of the state only, and such as he shall authorize. Many reasons have concurred for the making of these constitutions, as 1. For the encouragement of agriculture and improvement of lands, by giving every man an exclusive dominion over his own soil. 2. For preservation of the several species of these animals, which would soon be extirpated by a general liberty. 3. For prevention of idleness and dissipation in husbandmen, artificers, and others of lower rank, which would be the unavoidable consequence of universal license. 4. For preventing popular insurrections and resistance to the government by disarming the bulk of the people, which last is a reason oftener meant than avowed by the makers of forest or game laws. Nor, certainly, in these prohibitions is there any natural injustice, as some have weakly enough supposed, since, as Pufendorf observes, the law does not hereby take from any man his present property, or what was already his own, but barely abridges him of one means of acquiring a future property, that of occupancy, which indeed the law of nature would allow him, but of which the laws of society have in most instances very justly and reasonably deprived him. Yet, however defensible these provisions in general may be, on the footing of reason or justice or civil policy, we must notwithstanding acknowledge that, in their present shape, they owe their immediate original to slavery. It is not till after the irruption of the northern nations into the Roman Empire that we read of any other prohibitions than the natural one of not sporting on any private grounds without the owner's leave, and another of a more spiritual nature, which was rather a rule of ecclesiastical discipline than a branch of municipal law. The Roman or civil law, though it knew no restrictions as to persons or animals, so far regarded the article of place that it allowed no man to hunt or sport upon another's ground but by consent of the owner of the soil. Qui alienum fundum ingreditor, venandi aut occupandi gratia, potestas domino prohibere ne ingredatior. For if there can, by the law of nature, be any inchoate, imperfect property supposed in wild animals before they are taken, it seems most reasonable to fix it in him upon whose land they are found. And as to other restrictions which relates to persons and not place, the pontifical or canon law interdicts venationes et silvaticas vacationes concanibus et acetribus to all clergymen without distinction, grounded on a saying of St. Jerome, that it is never recorded that these diversions were used by the saints or primitive fathers. And the canons of our Saxon Church, published in the reign of King Edgar, concur in the same prohibition, though our secular laws, at least after the Conquest, did even in the times of Popery dispense with this canonical impediment, and the spiritual persons were allowed by the common law to hunt for their recreation in order to render them fitter for the performance of their duty. As a confirmation whereof, we may observe that it is to this day a branch of the king's prerogative, at the death of every bishop, to have his kennel of hounds, or a composition in lieu thereof. But, with regard to the rise and original of our present civil prohibitions, it will be found that all forest and game laws were introduced into Europe at the same time and by the same policy as gave birth to the feudal system, when those swarms of barbarians issued from their northern hive and laid the foundation of most of the present kingdoms of Europe on the ruins of the Western Empire. For when a conquering general came to settle the economy of a vanquished country, and to part it out among his soldiers or feudatories who were to render him military service for such donations, it behooved him, in order to secure his new acquisitions, to keep the rustici, or natives of the country, and all who were not his military tenants, in as low a condition as possible, and especially to prohibit them the use of arms. Nothing could do this more effectually than a prohibition of hunting and sporting, and therefore it was the policy of the conqueror to reserve this right to himself and such on whom he should bestow it, which were only his capital feudatories or greater barons. And accordingly we find in the feudal constitutions one and the same law prohibiting the Restucci in general from carrying arms, and also prescribing the use of nets, snares, and other engines for destroying game. This exclusive privilege well suited the martial genius of the conquering troops, who delighted in a sport which in its pursuit and slaughter bore some resemblance to war. Vita omnis, says Caesar, speaking of the ancient Germans, in venationibus atque et studias rei militaris consistit. And Tacitus in like manner observes that quotens bella non ineunt, multum venetibus, plus per otium transigunt. And indeed, like some of their modern successors, they had no other amusement to entertain their vacant hours, they despising all arts as effeminate, and having no other learning than was couched in such rude ditties as were sung at the solemn carousals which succeeded these ancient huntings. And it is remarkable that, in those nations where the feudal policy remains the most uncorrupted, the forest or game laws continue in their highest rigor. In France, all game is properly the king's, and in some parts of Germany it is death for a peasant to be found hunting in the woods of the nobility. With us in England also, hunting has ever been esteemed a most princely diversion and exercise. The whole island was replenished with all sorts of game in the time of the Britons, who lived in a wild and pastoral manner, without enclosing or improving their grounds, and derived much of their subsistence from the chase, which they all enjoyed in common. But when husbandry took place under the Saxon government, and lands began to be cultivated, improved, and enclosed, the beasts naturally fled into the woody and desert tracts, which were called the forests, and, having never been disposed of in the first distribution of lands, were therefore held to belong to the crown. These were filled with great plenty of game, which our royal sportsmen reserved for their own diversion, on pain of a pecuniary forfeiture for such as interfered with their sovereign. But every freeholder had the full liberty of sporting upon his own territories, provided he abstained from the king's forests, as is fully expressed in the laws of Canute and of Edward the Confessor. Sita qui libet homo dignis venetione sua, in silva et in agres, sibi proprius, et in domino suo, et abstiniat omnes homo a veneris regis, ubicunque pacem aes abere valueret, which indeed was the ancient law of the Scandinavian continent, from whence Canute probably derived it. Quique enim in proprio fundo, quam libet ferrum quoquo modo venari permissum. However, upon the Norman conquest a new doctrine took place, and the right of pursuing and taking all beasts of chase or venery, and such other animals as were accounted game, was then held to belong to the king, or to such only as were authorized under him. And this, as well as upon the principles of the feudal law, that the king is the ultimate proprietor of all the lands in the kingdom, they being all held of him as the chief lord or lord paramount of the fee, and that therefore he has the right of the universal soil to enter thereon and to chase and take such creatures at his pleasure, as also upon another maxim of the common law, which we have frequently cited and illustrated, that these animals are bona vacantia, and, having no other owner, belong to the king by his prerogative. As therefore the former reason was held to vest in the king a right to pursue and take them anywhere, the latter was supposed to give the king, and such as he should authorize, a sole and exclusive right. End of chapter 27, part 1. Chapter 27, part 2 of the Commentaries on the Laws of England, Book 2, by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Of Title by Prerogative and Forfeiture, Part 2. This right, thus newly vested in the Crown, was exerted with the utmost rigor at and after the time of the Norman establishment, not only in the ancient forests, but in the new ones which the Conqueror made by laying together vast tracts of country, depopulated for that purpose, and reserved solely for the king's royal diversion, in which were exercised the most horrid tyrannies and oppressions, under color of forest law, for the sake of preserving the beasts of the chase, to kill any of which, within the limits of the forest, was as penal as the death of a man. And, in pursuance of the same principle, King John laid a total interdict upon the winged as well as the four-footed creation. Capturam avium per totem Angliam interdixit. The cruel and insupportable hardships which these forest laws created to the subject occasioned our ancestors to be as zealous for their reformation as for the relaxation of the feudal rigors and other exactions introduced by the Norman family, and accordingly we find the immunities of Carta de Foresta as warmly contended for and extorted from the king with as much difficulty as those of Magna Carta itself. By this charter, confirmed in Parliament, many forests were disafforested or stripped of their oppressive privileges, and regulations were made in the regimen of such as remained. Particularly, killing the king's deer was made no longer a capital offense, but only punished by fine, imprisonment, or abjuration of the realm. And by a variety of subsequent statutes, together with the long acquiescence of the Crown without exerting the forest laws, this prerogative is now become no longer a grievance to the subject. But, as the king reserved to himself the forests for his own exclusive diversion, so he granted out from time to time other tracts of land to his subjects under the names of chases or parks, or gave them license to make such in their own grounds, which indeed are smaller forests in the hands of a subject, but not governed by the forest laws. And by the common law no person is at liberty to take or kill any beasts of chase but such as hath an ancient chase or park, unless they be also beasts of prey. As to all inferior species of game, called beasts and fowls of warren, the liberty of taking or killing them is another franchise or royalty, derived likewise from the crown, and called free warren, a word which signifies preservation or custody, as the exclusive liberty of taking and killing fish in a public stream or river is called a free fishery, of which, however, no new franchise can at present be granted by the express provision of Magna Carta c. 16. The principal intention of granting a man these franchises or liberties was in order to protect the game by giving him a sole and exclusive power of killing it himself, provided he prevented other persons. And no man but he who has a chase or free warren by grant from the crown, or prescription which supposes one, can justify hunting or sporting upon another man's soil, nor indeed, in thorough strictness of common law, either hunting or sporting at all. However novel this doctrine may seem, it is a regular consequence from what has been before delivered, that the sole right of taking and destroying game belongs exclusively to the king. This appears as well from the historical deduction here made, as because he may grant to his subjects an exclusive right of taking them, which he could not do unless such a right was first inherent in himself. And hence it will follow that no person whatsoever, but he who has such derivative right from the crown, is by common law entitled to take or kill any beasts of chase or other game whatsoever. It is true that by the acquiescence of the crown, the frequent grants of free warrant in ancient times, and the introduction of new penalties of late by certain statutes for preserving the game, this exclusive prerogative of the king is little known or considered. Every man that is exempted from these modern penalties, looking upon himself as at liberty to do what he pleases with the game, whereas the contrary is strictly true, that no man, however well qualified he may vulgarly be esteemed, has a right to encroach on the royal prerogative by the killing of game, unless he can show a particular grant of free warrant, or a prescription which presumes a grant, or some authority under an act of Parliament. As for the latter, I know but two instances wherein an express permission to kill game was ever given by statute. The one by 1 Jacobin 1 c. 27, altered by 7 Jacobin 1 c. 2, and virtually repealed by 22 and 23 Charles II c. 25, which gave authority, so long as they remained in force, to the owners of free warrant, to lords of manors, and to all freeholders having £40 per annum in lands of inheritance, or £80 for life or lives, or £400 personal estate, and their servants, to take partridges and pheasants upon their own or their master's free warrant, inheritance, or freehold. The other by 5 Ann c. 14, which empowers lords and ladies of manors to appoint gamekeepers to kill game for the use of such lord or lady, which with some alterations still subsists, and plainly supposes such power not to have been in them before. The truth of the matter is, that these game laws, of which we shall have occasion to speak again in the fourth book of these Commentaries, do indeed qualify nobody, except in the instance of a gamekeeper, to kill game, but only to save the trouble and formal process of an action by the person injured, who perhaps too might remit the offense. These statutes inflict additional penalties to be recovered either in regular or in summary way by any of the king's subjects from certain persons of inferior rank who may be found offending in this particular. But it does not follow that persons excused from these additional penalties are therefore authorized to kill game. The circumstances of having £100 per annum and the rest are not properly qualifications, but exemptions. And these persons, so exempted from the penalties of the game statutes, are not only liable to actions of trespass by the owners of the land, but also, if they kill game within the limits of any royal franchise, they are liable to the actions of such who may have the right of chase or free warrant therein. Upon the whole, it appears that the king, by his prerogative, and such persons as have, under his authority, the royal franchises of chase, park, free warrant, or free fishery, are the only persons who may acquire any property, however fugitive and transitory, in these animals ferae naturae while living, which is said to be vested in them, as was observed in a former chapter, propter privilegium. And it must be also remembered that such persons as may thus lawfully hunt, fish, or fowl, ratione privilegi, have, as has been said, only a qualified property in these animals, it not being absolute or permanent, but lasting only so long as the creatures remain within the limits of such respective franchise or liberty, and ceasing the instant they voluntarily pass out of it. It is held indeed that if a man starts any game within his own grounds, and follows it into another's, and kills it there, the property remains in himself. And this is grounded on reason and natural justice, for the property consists in the possession, which possession commences by the finding it in his own liberty, and is continued by the immediate pursuit. And so, if a stranger starts game in one man's chase or free warren, and hunts it into another liberty, the property continues in the owner of the chase or warren, this property arising from privilege, and not being changed by the act of a mere stranger. Or, if a man starts game on another's private grounds and kills it there, the property belongs to him in whose ground it was killed, because it was also started there, this property arising ratione soli. Whereas, if after being started there, it is killed in the grounds of a third person, the property belongs not to the owner of the first ground, because the property is local, nor yet to the owner of the second, because it was not started in his soil, but it vests in the person who started and killed it, though guilty of trespass against both the owners. 3. I proceed now to a third method, whereby a title to goods and chattels may be acquired and lost, viz., by forfeiture, as a punishment for some crime or misdemeanor in the party forfeiting, and as a compensation for the offense or injury committed against him to whom they are forfeited. Of forfeitures, considered as means whereby real property might be lost and acquired, we treated in a former chapter. It remains, therefore, in this place only to mention by what means or for what offenses goods and chattels become liable to forfeiture. In the variety of penal laws with which the subject is at present encumbered, it were a tedious and impracticable talk to reckon up the various forfeitures inflicted by special statutes for particular crimes and misdemeanors, some of which are mala in se, or offenses against the divine law, either natural or revealed, but by far the greatest part are mala prohibita, or such as derive their guilt merely from their prohibition by the laws of the land, such as is the forfeiture of 40 shillings per month by the statute 5 Elizabeth c. 4 for exercising a trade without having served 7 years as an apprentice thereto, and the forfeiture of £10 by 9 Ann c. 23 for printing an almanac without a stamp. I shall therefore confine myself to those offenses only by which all the goods and chattels of the offender are forfeited, referring the student for such, where pecuniary mulcts of different quantities are afflicted, to their several proper heads, under which very many of them have been or will be mentioned, or else to the collections of Hawkins and Byrne and other laborious compilers. Indeed, as most of these forfeitures belong to the Crown, they may seem as if they ought to have been referred to the preceding method of acquiring personal property, namely, by prerogative. But, as in the instance of partial forfeitures, a moiety often goes to the informer, the poor, or sometimes to other persons, and as one total forfeiture, namely, that by a bankrupt who is guilty of felony by concealing his effects, accrues entirely to his creditors, I have therefore made it a distinct head of transferring property. Goods and chattels, then, are totally forfeited by conviction of high treason or misprision of treason, of petite treason, of felony in general, and particularly of felony de se, of manslaughter, nay, even by conviction of excusable homicide, by outlawry for treason or felony, by conviction of petite larceny, by flight in treason or felony, even though the party be acquitted of the fact, by standing mute when arraigned of felony, by drawing a weapon on a judge, or striking anyone in the presence of the king's courts, by praemunire, by pretended prophecies upon a second conviction, by owling, by the residing abroad of artificers, and by challenging to fight on account of money won at gaming. All these offenses, as will more fully appear in the fourth book of these commentaries, induce a total forfeiture of goods and chattels. And this forfeiture commences from the time of conviction, and not the time of committing the act, as in forfeitures of real property. For chattels are of so vague and fluctuating a nature that to affect them by any relation back would be attended with more inconvenience than in the case of landed estates, and part, if not the whole of them, must be expended in maintaining the delinquent between the time of committing the act and his conviction. Yet a fraudulent conveyance of them, to defeat the interest of the crown, is made void by the statute 13 Elizabeth c. 5. End of chapter 27, part 2. Chapter 28 of the Commentaries on the Laws of England, Book 2, by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Of title by custom. A fourth method of acquiring property in things personal or chattels is by custom, whereby a right vests in some particular persons, either by the local usage of some particular place, or by the almost general and universal usage of the kingdom. It were endless should I attempt to enumerate all the several kinds of special customs which may entitle a man to a chattel interest in different parts of the kingdom. I shall therefore content myself with making some observations on three sorts of customary interests, which obtain pretty generally throughout most parts of the nation, and are therefore of more universal concern, viz., heriots, mortuaries, and heirlooms. 1. Heriots, which were slightly touched upon in a former chapter, are usually divided into two sorts, heriot service and heriot custom. The former are such as are due upon special reservation in a grant or lease of lands, and therefore amount to little more than a mere rent. The latter arise upon no special reservation whatsoever, but depend merely upon immemorial usage and custom. Of these, therefore, we are here principally to speak, and they are defined to be a customary tribute of goods and chattels payable to the lord of the fee on the decease of the owner of the land. The first establishment, if not introduction, of compulsory heriots into England was by the Danes, and we find in the laws of King Canute the several heregiates or heriots specified, which were then exacted by the king on the death of divers of his subjects, according to their respective dignities, from the highest earl down to the most inferior thane or landholder. These, for the most part, consisted in arms, horses, and habiliments of war, which the word itself, according to Sir Henry Spelman, signifies. These were delivered up to the sovereign on the death of the vassal, who could no longer use them, to be put into other hands for the service and defense of the country. And upon the plan of this Danish establishment did William the Conqueror fashion his law of reliefs as was formerly observed. When he ascertained the precise relief to be taken of every tenant in chivalry, and, contrary to the feudal custom, and the usage of his own duchy of Normandy, required arms and implements of war to be paid instead of money. The Danish compulsive heriots, being thus transmuted into reliefs, underwent the same several vicissitudes as the feudal tenures, and in socage estates do frequently remain to this day in the shape of a double rent payable at the death of the tenant. The heriots which now continue among us, and preserve that name, seeming rather to be of Saxon parentage, and at first to have been merely discretionary. These are now for the most part confined to copyhold tenures, and are due by custom only, which is the life of all estates by copy, and perhaps are the only instance where custom has favored the lord. For this payment was originally a voluntary donation, or gratuitous legacy of the tenant, perhaps in acknowledgment of his having been raised a degree above villanage when all his goods and chattels were quite at the mercy of the lord. And custom, which has on the one hand confirmed the tenant's interest in exclusion of the lord's will, has on the other hand established this discretional piece of gratitude into a permanent duty. And heriot may also appertain to free land, that is, held by service and suit of court, in which case it is most commonly a copyhold enfranchised, whereupon the heriot is still due by custom. Bracton speaks of heriots as frequently due on the death of both species of tenants. Est quidem alia praestatita quae nominator herietum, ubi tenens, liber vet servus, in morte sua dominum suum, de quo tenueret, respicit de meliori averio suo, vel de secundo meliori, secundum diversam locorum consuetudinem. And this, he adds, magis vita de gratia quam de jure, in which Fleta and Britain agree, thereby plainly intimating the original of this custom to have been merely voluntary, as a legacy from the tenant, though now the immemorial usage has established it as a right in the lord. This heriot is sometimes the best live beast, or aberium, which the tenant dies possessed of, which is particularly denominated the villain's relief in the 29th law of King William the Conqueror, sometimes the best inanimate good, under which a jewel or piece of plate may be included, but it is always a personal chattel, which, immediately on the death of the tenant who was owner of it, being ascertained by the option of the lord, becomes vested in him as his property, and is no charge upon the lands, but merely on the goods and chattels. The tenant must be the owner of it, else it cannot be due, and therefore, on the death of a femme covert, no heriot can be taken, for she can have no ownership in things personal. In some places there is a customary composition in money, as 10 or 20 shillings in lieu of a heriot, by which the lord and tenant are both bound, if it be an indisputably ancient custom, but a new composition of this sort will not bind the representatives of either party, for that amounts to the creation of a new custom, which is now impossible. 2. Mortuaries are a sort of ecclesiastical heriots, being a customary gift claimed by and due to the minister in very many parishes on the death of his parishioners. They seem originally to have been, like lay heriots, only a voluntary bequest to the church, being intended, as Linwood informs us from a constitution of Archbishop Langham, as a kind of extirpation and amends to the clergy for personal tithes and other ecclesiastical duties which the laity in their lifetime might have neglected or forgotten to pay. For this purpose, after the Lord's heriot or best good was taken out, the second best chattel was reserved to the church as a mortuary. Si decedens plura abueret animalia, optimo qui de jure furet debitum reservato, ecclesia sue sine dolo fraude, seo contradictioni qualebet, pro recompensatione subtractionis decimarum personalium, nec non et oblationum secundum melius animo reservator, pas dobitum pro salute animae suae. And therefore, in the laws of King Canute, this mortuary is called a soul scot, or symbolum animae. And, in pursuance of the same principle, by the laws of Venice, where no personal tithes have been paid during the life of the party, they are paid at his death out of his merchandise, jewels, and other movables. So also, By a similar policy in France, every man that died without bequeathing a part of his estate to the church, which was called dying without confession, was formally deprived of Christian burial; or, if he died intestate, the relations of the deceased, jointly with the bishop, named proper arbitrators to determine what he ought to have given to the church in case he had made a will. But the Parliament, in 1409, redressed this grievance. It was anciently usual in this kingdom to bring the mortuary to the church along with the corpse when it came to be buried, and thence it is sometimes called a corse present, a term which bespeaks it to have been once a voluntary donation. However, in Bracton's time, so early as Henry III, we find it riveted into an established custom, insomuch that the bequests of Heriats and mortuaries were held to be necessary ingredients in every testament of chattels. Imprimus autem debet qui libet, qui testamentum feceret, dominum sum del migliore requam abueret recognoscere, et de postea ecclesiam de alia meliori. The Lord must have the best good left him as an Heriat, and the church the second best as a mortuary. But yet this custom was different in different places. In quibusdem locis habet ecclesia meles animal de consuetudine, in quibusdem secundum vel tertium melius, et in quibusdem nil, et ideo consideranta et consuetudo loci. This custom still varies in different places, not only as to the mortuary to be paid, but the person to whom it is payable. In Wales, a mortuary or corse present was due upon the death of every clergyman to the bishop of the diocese, till abolished upon a recompense given to the bishop by the statute 12 Ann Ft 2 C6. And in the Archdeaconry of Chester a custom also prevailed, that the bishop, who was also archdeacon, should have at the death of every clergyman dying therein his best horse or mare, bridle, saddle, and spurs, his best gown or cloak, hat, upper garment under his gown, and tippet, and also his best signet or ring. But by the statute 28 George II C6, this mortuary is directed to cease, and the act has settled upon the bishop an equivalent in its room. The king's claim to many goods on the death of all prelates in England seems to be of the same nature, though Sir Edward Coke apprehends that this is a duty due upon death, and not a mortuary, a distinction which seems to be without a difference. For not only the king's ecclesiastical character as supreme ordinary, but also the species of the goods claimed, which bear so near a resemblance to those in the Archdeaconry of Chester, which was an acknowledged mortuary, puts the matter out of dispute. The king, according to the record vouched by Sir Edward Coke, is entitled to 6 things: the bishop's best horse or palfrey, with his furniture; his cloak or gown, and tippet; his cup and cover; his basin and ewer; his gold ring; and lastly, his muta canem, his mew or kennel of hounds, as was mentioned in the preceding chapter. This variety of customs with regard to mortuaries, giving frequently a handle to exactions on the one side, and frauds or expensive litigations on the other, it was thought proper by the statute 21 Henry VIII C6 to reduce them to some kind of certainty. For this purpose it is enacted that all mortuaries or corse presents to parsons of any faith shall be taken in the following manner, unless where by custom less or none at all is due, viz., for every person who does not leave goods to the value of 10 marks, nothing; for every person who leaves goods to the value of 10 marks and under £30, 3 shillings 4 pence; if above £30 and under £40, 6 shillings and 8 pence; if above £40, of what value soever they may be, 10 shillings and no more. And no mortuary shall throughout the kingdom be paid for the death of any femme covert, nor any child, nor for any one of full age that is not a housekeeper, nor for any wayfaring man. But such wayfaring man's mortuary shall be paid in the parish to which he belongs. And upon this statute stands the law of mortuaries to this day. 3. Heirlooms are such goods and personal chattels as, contrary to the nature of chattels, shall go by special custom to the heir along with the inheritance, and not to the executor of the last proprietor. The termination loom is of Saxon original, in which language it signifies a limb or member, so that an heirloom is nothing else but a limb or member of the inheritance. They are generally such things as cannot be taken away without damaging or dismembering the freehold. Otherwise, the general rule is, that no chattel interest whatsoever shall go to the heir, notwithstanding it be expressly limited to a man and his heirs, but shall vest in the executor. But deer in a real authorized park, fishes in a pond, doves in a dove house, etc., though in themselves personal chattels, yet they are so annexed to and so necessary to the well-being of the inheritance that they shall accompany the land wherever it vests, either by descent or purchase. For this reason also I apprehend it is, that the ancient jewels of the crown are held to be heirlooms, for they are necessary to maintain the state and support the dignity of the sovereign for the time being. Charters likewise, and deeds, court rolls, and other evidences of the land, together with the chests in which they are contained, shall pass together with the land to the heir in the nature of heirlooms, and shall not go to the executor. By special custom also, in some places, carriages, utensils, and other household implements may be heirlooms, but such custom must be strictly proved. On the other hand, by almost general custom, whatever is strongly affixed to the freehold or inheritance, and cannot be severed from thence without violence or damage, quod ab aedibus non facit revelitor, is become a member of the inheritance, and shall thereupon pass to the heir, as marble chimney pieces, pumps, old fixed or dormant tables, benches, and the like. A very similar notion to which prevails in the Duchy of Brabant, where they rank certain things movable among those of the immovable kind, calling them by a very peculiar appellation, praedia volantia, or volatile estates, such as beds, tables, or other heavy implements of furniture, which, as an author of their own observes, dignitatem istum nacta sunt, ut vilis, silvis, et aedibus, aelisque praedis, comparentur, quod solidioria mobile ipsis, aedibus ex destationi patris familias cohaerere vidientur, et pro parte ipsarem aedium testamentur. Other personal chattels there are, which also descend to the heir in the nature of heirlooms, as a monument or tombstone in a church, or the coat armor of his ancestor there hung up, with the pennons and other ensigns of honor suited to his degree. In this case, albeit the freehold of the church is in the parson, and these are annexed to that freehold, yet cannot the parson or any other take them away or deface them, but is liable to an action from the heir. Dues in the church are somewhat of the same nature, which may descend by custom immemorial, without any ecclesiastical concurrence, from the ancestor to the heir. But though the heir has a property in the monuments and escutcheons of his ancestors, yet he has none in their bodies or ashes, nor can he bring any civil action against such as indecently at least, if not impiously, violate and disturb their remains when dead and buried. The parson, indeed, who has the freehold of the soil, may bring an action of trespass against such as dig and disturb it, And if anyone in taking up a dead body steals the shroud or other apparel, it will be a felony. For the property thereof remains in the executor, or whoever was at the charge of the funeral. But to return to heirlooms, these, though they be mere chattels, yet cannot be devised away from the heir by will. But such a devise is void, even by a tenant in fee simple. For though the owner might during his life have sold or disposed of them, as he might of the timber of the estate, since as the inheritance was his own, he might mangle or dismember it as he pleased, yet, they being at his death instantly vested in the heir, the devise, which is subsequent and not to take effect till after his death, shall be postponed to the custom whereby they have already descended. End of chapter 28. Chapter 29 of the Commentaries on the Laws of England, Book 2, by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Of title by succession, marriage, and judgment. In the present chapter we shall take into consideration three other species of title to goods and chattels. 5. The fifth method, therefore, of gaining a property in chattels, either personal or real, is by succession, which is, in strictness of law, only applicable to corporations aggregate of many, as dean and chapter, mayor and commonalty, master and fellows, and the like, in which one set of men may, by succeeding another set, acquire a property in all the goods, movables, and other chattels of the corporation. The true reason whereof is, because in judgment of law a corporation never dies, and therefore the predecessors who lived a century ago, and their successors now in being, are one and the same body corporate. Which identity is a property so inherent in the nature of a body politic that even when it is meant to give away anything to be taken in succession by such a body, that succession need not be expressed, but the law will of itself imply it. So that a gift to such a corporation, either of lands or of chattels, without naming their successors, vests an absolute property in them so long as the corporation subsists. And thus a lease for years, an obligation, a jewel, a flock of sheep, or other chattel interest, will vest in the successors by succession, as well as in the identical members to whom it was originally given. But with regard to sole corporations, a considerable distinction must be made. For if such sole corporation be the representative of a number of persons, as the matter of an hospital, who is a corporation for the benefit of the poor brethren, an abbot or prior by the old law before the Reformation, who represented the whole convent, or the dean of some ancient cathedral, who stands in place of and represents in his corporate capacity the chapter, such sole corporations as these have in this respect the same powers as corporations aggregate have to take personal property or chattels in succession. And therefore a bond to such a master, abbot, or dean and his successors is good in law, and the successor shall have the advantage of it, for the benefit of the aggregate society, of which he is in law the representative. Whereas, in the case of sole corporations, which represent no others but themselves, as bishops, parsons, and the like, no chattel interest can regularly go in succession, and therefore, if a lease for years be made to the Bishop of Oxford and his successors, in such case his executors or administrators, and not his successors, shall have it. For the word successors, when applied to a person in his politic capacity, is equivalent to the word heirs in his natural, and as such a lease for years, if made to John and his heirs, would not vest in his heirs, but his executors. So, if it be made to John, Bishop of Oxford, and his successors, who are the heirs of his body politic, it shall still vest in his executors, and not in such his successors. The reason of this is obvious, for, besides that the law looks upon goods and chattels as of too low and perishable a nature to be limited either to heirs or such successors as are equivalent to heirs, it would also follow that if any such chattel interest granted to a sole corporation and his successors were allowed to descend to such successor, the property thereof must be in abeyance from the death of the present owner until the successor be appointed, and this is contrary to the nature of a chattel interest, which can never be in abeyance or without an owner. But a man's right therein, when once suspended, is gone forever. This is not the case in corporations aggregate, where the right is never in suspense, nor in the other sole corporation before mentioned, who are rather to be considered as heads of an aggregate body than subsisting merely in their own right. The chattel interest, therefore, in such a case, is really and substantially vested in the hospital, covenant, or chapter, or other aggregate body, though the head is the visible person in whose name every act is carried on, and in whom every interest is therefore said, in point of form, to vest. But the general rule, with regard to corporations merely sole, is this, that no chattel can go or be acquired by right of succession. Yet to this rule there are two exceptions. One in case of the king, in whom a chattel may vest by a grant of it formerly made to a preceding king and his successors. The other exception is, where by a particular custom some particular corporation sole have acquired a power of taking particular chattel interests in succession. And this custom, being against the general tenor of the common law, must be strictly interpreted and not extended to any other chattel interests than such immemorial usage will strictly warrant. Thus, the Chamberlain of London, who is a corporation sole, may by the custom of London take bonds and recognizances to himself and his successors for the benefit of the Orphans' Fund, but it will not follow from thence that he has a capacity to take a lease for years to himself and his successors for the same purpose, for the custom extends not to that, nor that he may take a bond to himself and his successors for any other purpose than the benefit of the Orphans' Fund, for that also is not warranted by the custom. Wherefore, upon the whole, we may close this head with laying down this general rule, that such right of succession to chattels is universally inherent by the common law in all aggregate corporations, in the king, and in such single corporations as represent a number of persons, and may, by special custom, belong to certain other sole corporations for some particular purposes, although, generally, in sole corporations, no such right can exist. 6. A sixth method of acquiring property in goods and chattels is by marriage, whereby those chattels which belonged formerly to the wife are, by act of law, vested in the husband, with the same degree of property and with the same powers as the wife, when sole, had over them. This depends entirely on the notion of an unity of person between the husband and wife, it being held that they are one person in law, so that the very being and existence of the woman is suspended during the coverture, or entirely merged and incorporated in that of the husband. And hence it follows that whatever personal property belonged to the wife before marriage is by marriage absolutely vested in the husband. In a real estate, he only gains a title to the rents and profits during coverture, for that, depending upon feudal principles, remains entire to the wife after the death of her husband, or to her heirs if she dies before him, unless, by the birth of a child, he becomes tenant for life by the courtesy. But in chattel interests, the sole and absolute property vests in the husband, to be disposed of at his pleasure, if he chooses to take possession of them, for, unless he reduces them to possession by exercising some act of ownership upon them, no property vests in him, but they shall remain to the wife or her representatives after the coverture is determined. There is therefore a very considerable difference in the acquisition of this species of property by the husband according to the subject matter, viz., whether it be a chattel real or a chattel personal, and of chattels personal, whether it be in possession or in action only. A chattel real vests in the husband not absolutely, but sub modo, as, in case of a lease for years, the husband shall receive all the rents and profits of it, and may, if he pleases, sell, surrender, or dispose of it during the coverture. If he be outlawed or attainted, it shall be forfeited to the king. It is liable to execution for his debts, and, if he survives his wife, it is to all intents and purposes his own. Yet if he has made no disposition thereof in his lifetime, and dies before his wife, he cannot dispose of it by will; for, the husband having made no alteration in the property during his life, it never was transferred from the wife, but after his death she shall remain in her ancient possession, and it shall not go to his executors. So it is also of chattels personal, or chuses, in action, as debts upon bond, contracts, and the like. These the husband may have if he pleases, that is, if he reduces them into possession by receiving or recovering them at law. And, upon such receipt or recovery, they are absolutely and entirely his own, and shall go to his executors or administrators, or as he shall bequeath them by will, and shall not revert in the wife. But if he dies before he has recovered or reduced them into possession, so that at his death they still continue chuses in action, they shall survive to the wife, for the husband never exerted the power he had of obtaining an exclusive property in them. And so, if an estray comes into the wife's franchise, and the husband seizes it, it is absolutely his property. But, if he dies without seizing it, his executors are not now at liberty to seize it, but the wife or her heirs. For the husband never exerted the right he had, which right determined with the coverture. Thus, in both these species of property the law is the same, in case the wife survives the husband. But, in case the husband survives the wife, the law is very different with respect to chattels real and chuses in action. For he shall have the chattel real by survivorship, but not the chuse in action, except in the case of arrears of rent due to the wife before her coverture, which, in case of her death, are given to the husband by statute 32 Henry VIII, c. 37. And the reason for the general law is this, that the husband is in absolute possession of the chattel real during the coverture, by a kind of joint tenancy with his wife, whereof the law will not wrest it out of his hands and give it to her representatives, though, in case he died first, it would have survived to the wife, unless he thought proper in his lifetime to alter the possession. But a chuse in action shall not survive to him, because he never was in possession of it at all during the coverture, and the only method he had to gain possession of it was by suing in his wife's right. But as, after her death, he cannot as husband bring an action in her right, because they are no longer one and the same person in law, therefore he can never, as such, recover the possession. But he still will be entitled to be her administrator, and may in that capacity recover such things in action as become due her before or during the coverture. Thus, and upon these reasons, stands the law between husband and wife with regard to chattels real and chuses in action. But as to chattels personal, or chuses in possession, which the wife hath in her own right, as ready money, jewels, household goods, and the like, the husband hath therein an immediate and absolute property, devolved to him by marriage, not only potentially but in fact, which never can again revert in the wife or her representative. And as the husband may thus generally acquire a property in all the personal substance of the wife, so in one particular instance the wife may acquire a property in some of her husband's goods, which shall remain to her after his death, and shall not go to his executors. These are called her paraphernalia, which is a term borrowed from the civil law, and is derived from the Greek language, signifying something over and above her dower. Our law uses it to signify the apparel and ornaments of the wife, suitable to her rank and degree, which she becomes entitled to at the death of her husband over and above her jointure or dower, and preferably to all other representatives. And the jewels of a peeress, usually worn by her, have been held to be paraphernalia. Neither can the husband devise by his will such ornaments and jewels of his wife, though during his life perhaps he hath the power, if unkindly inclined to exert it, to sell them or give them away. But if she continues in the use of them till his death, she shall afterwards retain them against his executors and administrators, and all other persons, except creditors where there is a deficiency of assets. And her necessary apparel is protected even against the claim of creditors. 7. A judgment in consequence of some suit or action in a court of justice is frequently the means of vesting the right and property of chattel interests in the prevailing party. And here we must be careful to distinguish between property, the right of which is before vested in the party, and of which only possession is recovered by suit or action, and property to which a man before had no determinate title or certain claim, but he gains as well the right as the possession by the process and judgment of the law. Of the former sort are all debts and chuses in action, as if a man gives bond for £20, or agrees to buy a horse at a stated sum, or takes up goods of a tradesman upon an implied contract to pay as much as they are reasonably worth. In all these cases the right accrues to the creditor, and is completely vested in him at the time of the bond being sealed, and the contract or agreement made, and the law only gives him a remedy to recover the possession of that right, which already in justice belongs to him. But there is also a species of property to which a man has not any claim or title whatsoever till after suit commenced and judgment obtained in a court of law, where the right and the remedy do not follow each other as in common cases, but accrue at one and the same time, and where, before judgment had, no man can say that he had any absolute property, either in possession or in action. Of this nature are 1. Such penalties as are given by particular statutes to be recovered of an action popular, or, in other words, to be recovered by him or them that will sue for the same, such as the penalty of £500, which those persons are by several acts of Parliament made liable to forfeit that, being in particular offices or situations in life, neglect to take the oaths to government, which penalty is given to him or them that will sue for the same. Now here it is clear that no particular person, A or B, has any right, claim, or demand in or upon this penal sum till after action brought. For he that brings his action, and can bona fide obtain judgment first, will undoubtedly secure a title to it, in exclusion of everybody else. He obtains an inchoate, imperfect degree of property by commencing his suit, but it is not consummated till judgment, for if any collusion appears, he loses the priority he had gained. But otherwise, the right so attaches in the first informer, that the king, who before action brought may grant a pardon which shall be a bar to all the world, cannot after suit commenced remit anything but his own part of the penalty. For by commencing the suit, the informer has made the popular action his own private action, and it is not in the power of the crown, or of anything but Parliament, to release the informer's interest. This, therefore, is one instance where a suit and judgment at law are not only the means of recovering, but also of acquiring property. And what is said of this one penalty is equally true of all others that are given thus at large to a common informer, or to any person that will sue for the same. They are placed, as it were, in a state of nature, accessible by all the king's subjects, but the acquired right of none of them. Open, therefore, to the first occupant, who declares his intention to possess them by bringing his action, and who carries that intention into execution by obtaining judgment to recover them. 2. Another species of property that is acquired and lost by suit and judgment at law is that of damages given to a man by a jury, as compensation and satisfaction for some injury sustained, as for a battery, for imprisonment, for slander, or for trespass. Here the plaintiff has no certain demand till after the verdict, but when the jury has assessed his damages, and judgment is given thereupon, whether they amount to £20 or 20s, he instantly acquires, and the defendant loses at the same time, a right to that specific sum. It is true that this is not an acquisition so perfectly original as in the former instance, for here the injured party has unquestionably a vague and indeterminate right to some damages or other the instant he receives the injury, and the verdict of the jurors and judgment of the court thereupon do not in this case so properly vest a new title in him as fix and ascertain the old one. They do not give, but define the right. But, however, though strictly speaking the primary right to a satisfaction for injuries is given by the law of nature, and the suit is only means of ascertaining and recovering that satisfaction, yet, as the legal proceedings are the only visible means of this acquisition of property, we may fairly enough rank such damages or satisfaction assessed under the head of property acquired by suit and judgment at law. 3. Hither also may be referred, upon the same principle, all title to costs and expenses of suit, which are often arbitrary, and rest entirely in the determination of the court upon weighing all circumstances, both as to the quantum, and also, in the courts of equity especially, and upon motions in the courts of law, whether there shall be any costs at all. These costs, therefore, when given by the court to either party, may be looked upon as an acquisition made by the judgment of law. End of chapter 29. Chapter 30, Part 1 of the Commentaries on the Laws of England, Book 2, by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Of Title by Gift, Grant, and Contract, Part 1. We are now to proceed, according to the order marked out, to the discussion of two of the remaining methods of acquiring title to property in things personal, which are much connected together and answer in some measure to the conveyances of real estates, being those by gift or grant, and by contract, whereof the former vests a property in possession, the latter a property in action. 8. Gifts, then, or grants, which are the eighth method of transferring personal property, are thus to be distinguished from each other, that gifts are always gratuitous, grants are upon some consideration or equivalent, and they may be divided, with regard to their subject matter, into gifts or grants of chattels real, and gifts or grants of chattels personal. Under the head of gifts or grants of chattels real may be included all leases for years of land, assignments, and surrenders of those leases, and all other methods of conveying an estate less than freehold, which were considered in the 20th chapter of the present book, and therefore need not be here again repeated, though these very seldom carry the outward appearance of a gift, however freely bestowed, being usually expressed to be made in consideration of blood or natural affection, or of 5 or 10 shillings nominally paid to the grantor, and, in case of leases, always reserving a rent, though it be but a peppercorn, any of which considerations will, in the eye of the law, convert the gift, if executed, into a grant, if not executed, into a contract. Grants or gifts of chattels personal are the act of transferring the right and the possession of them, whereby one man renounces and another man immediately acquires all title and interest therein, which may be done either in writing or by word of mouth attested by sufficient evidence, of which the delivery of possession is the strongest and most essential. But this conveyance, when merely voluntary, is somewhat suspicious, and is usually construed to be fraudulent if creditors or others become sufferers thereby. And particularly by Statute 3 Henry VII c. 4, all deeds of gift of goods made in trust to the use of the donor shall be void, because otherwise persons might be tempted to commit treason or felony without danger of forfeiture, and the creditors of the donor might also be defrauded of their rights. And by Statute 13 Elizabeth c. 5, every grant or gift of chattels, as well as lands, with intent to defraud creditors or others, shall be void as against such persons to whom such fraud would be prejudicial, but as against the grantor himself shall stand good and effectual, and all persons partakers in, or privy to, such fraudulent grants shall forfeit the whole value of the goods, one moiety to the king, and another moiety to the party grieved, and also, on conviction, shall suffer imprisonment for half a year. A true and proper gift or grant is always accompanied with delivery of possession, and takes effect immediately, as if A gives to B £100 or a flock of sheep, and puts him in possession of them directly. It is then a gift executed in the donee, and it is not in the donor's power to retract it, though he did it without any consideration or recompense, unless it be prejudicial to creditors, or the donor were under any legal incapacity, as infancy, coverture, duress, or the like, or if he were drawn in, circumvented, or imposed upon by false pretenses, ebriety, or surprise. But if the gift does not take effect by delivery of immediate possession, it is then not properly a gift, but a contract, and this a man cannot be compelled to perform but upon good and sufficient consideration, as we shall see under our next division. 9. A contract, which usually conveys an interest merely in action, is thus defined: an agreement upon sufficient consideration to do or not to do a particular thing, from which definition there arise 3 points to be contemplated in all contracts: 1. The agreement; 2. The consideration; and 3. The thing to be done or omitted, or the different species of contracts. First, then, it is an agreement, a mutual bargain or convention, and therefore there must be at least 2 contracting parties of sufficient ability to make a contract, as where A contracts with B to pay him £100, and thereby transfers a property in such sum to B, which property is, however, not in possession, but in action merely, and recoverable by suit at law. Wherefore it could not be transferred to another person by the strict rules of the ancient common law. For no chosen action could be assigned or granted over, because it was thought to be a great encouragement to litigiousness if a man were allowed to make over to a stranger his right of going to law. But this nicety is now disregarded, though, in compliance with the ancient principle, the form of assigning a chosen action is in the nature of a declaration of trust, and an agreement to permit the assignee to make use of the name of the assignor in order to recover the possession. And therefore, When in common acceptation a debt or bond is said to be assigned over, it must still be sued in the original creditor's name, the person to whom it is transferred being rather an attorney than an assignee. But the king is an exception to this general rule, for he might always either grant or receive a chose in action by assignment, and our courts of equity, considering that in a commercial country almost all personal property must necessarily lie in contract, will protect the assignment of a chose in action as much as the law will that of a chose in possession. This contract or agreement may be either express or implied. Express contracts are where the terms of the agreement are openly uttered and avowed at the time of the making, as to deliver an ox or 10 load of timber, or to pay a stated price for certain goods. Implied are such as reason and justice dictate, and which therefore the law presumes that every man undertakes to perform. As, if I employ a person to do any business for me, or perform any work, the law implies that I undertook or contracted to pay him as much as his labor deserves. If I take up wares from a tradesman without any agreement of price, the law concludes that I contracted to pay their real value. And there is also one species of implied contracts, which runs through and is annexed to all other contracts, conditions, and covenants, viz., that if I fail in my part of the agreement, I shall pay the other party such damages as he has sustained by such my neglect or refusal. In short, almost all the rights of personal property, when not in actual possession, do in great measure depend upon contracts of one kind or another, or at least might be reduced under some of them, which indeed is the method taken by the civil law, it having referred the greatest part of the duties and rights which it treats of to the head of obligations ex contractu and quasi ex contractu. A contract may also be either executed, as if A agrees to change horses with B, and they do it immediately, in which case the possession and the right are transferred together, or it may be executory, as if they agree to change next week. Here the right only vests, and their reciprocal property in each other's horse is not in possession but in action. For a contract executed, which differs nothing from a grant, conveys a chose in possession. A contract executory conveys only a chose in action. Having thus shown the general nature of a contract, we are, secondly, to proceed to the consideration upon which it is founded, or the reason which moves the party contracting to enter into the contract. It is an agreement upon sufficient consideration. The civilians hold that in all contracts, either express or implied, there must be something given in exchange, something that is mutual or reciprocal. This thing, which is the price or motive of the contract, we call the consideration, and it must be a thing lawful in itself, or else the contract is void. A good consideration, we have before seen, is that of blood or natural affection between near relations, the satisfaction accruing from which the law esteems an equivalent for whatever benefit may move from one relation to another. This consideration may sometimes, however, be set aside, and the contract becomes void when it tends in its consequences to defraud creditors or other third persons of their just rights. But a contract for any valuable consideration, as for marriage, for money, for work done, or for other reciprocal contracts, can never be impeached at law, and, if it be of a sufficient adequate value, is never set aside in equity, for the person contracted with has then given an equivalent in recompense, and is therefore as much an owner or a creditor as any other person. These valuable considerations are divided by the civilians into four species. 1. Do uta des, as when I give money or goods on a contract that I shall be repaid money or goods for them again. Of this kind are all loans of money upon bond, or promise of repayment, and all sales of goods in which there is either an express contract to pay so much for them, or else the law implies a contract to pay so much as they are worth. 2. The second species is facio ut facias, as when I agree with a man to do his work for him if he will do mine for me, or if two persons agree to marry together, or to do any other positive acts on both sides. Or it may be to forbear on one side in consideration of something done on the other, as that in consideration A, the tenant, will repair his house, B, the landlord, will not sue him for waste. Or it may be for mutual forbearance on both sides, as that in consideration that A will not trade to Lisbon, B will not trade to Marseille, so as to avoid interfering with each other. 3. The third species of consideration is facio ut des, when a man agrees to perform anything for a price, either specifically mentioned or left to the determination of law to set a value on it, and when a servant hires himself to his master for certain wages or an agreed sum of money. Here the servant contracts to do his master's service in order to earn that specific sum. Otherwise, if he be hired generally, for then he is under an implied contract to perform this service for what it shall be reasonably worth. 4. The fourth species is do ut facias, which is the direct counterpart of the other, as when I agree with a servant to give him such wages upon his performing such work, which, we see, is nothing else but the last species inverted. For servus facit ut heros det, and heros det ut servus facet. A consideration of some sort or other is so absolutely necessary to the forming of a contract that a nudum pactum, or agreement, to do or pay anything on one side without any compensation on the other, is totally void in law, and a man cannot be compelled to perform it. As if one man promises to give another £100. Here there is nothing contracted for or given on the one side, and therefore there is nothing binding on the other. And, however a man may or may not be bound to perform it, in honor or conscience, which the municipal laws do not take upon them to decide, certainly those municipal laws will not compel the execution of what he had no visible inducement to engage for, and therefore our law has adopted the maxim of the civil law, that ex nudo pacto non auditor actio. But any degree of reciprocity will prevent the pact from being nude. Nay, even if the thing be founded on a prior moral obligation, as a promise to pay a just debt though barred by the statute of limitations, it is no longer nudum pactum. And as this rule was principally established to avoid the inconvenience that would arise from setting up mere verbal promises for which no good reason could be assigned, it therefore does not hold in some cases where such promise is authentically proved by written documents. For if a man enters into a voluntary bond, or gives a promissory note, he shall not be allowed to aver the want of a consideration in order to evade the payment. For every bond from the solemnity of the instrument, and every note from the subscription of the drawer, carries with it an internal evidence of a good consideration. Courts of justice will therefore support them both, as against the contractor himself, but not to the prejudice of creditors or strangers to the contract. We are next to consider, thirdly, the thing agreed to be done or omitted. A contract is an agreement upon sufficient consideration to do or not to do a particular thing. The most usual contracts whereby the right of chattels personal may be acquired in the laws of England are 1. That of sale or exchange, 2. That of bailment, 3. Hiring and borrowing, 4. That of debt. 1. Sale or exchange is a transmutation of property from one man to another in consideration of some recompense in value. For there is no sale without a recompense. There must be a quid pro quo. If it be a commutation of goods for goods, it is more properly an exchange. But if it be a transferring of goods for money, it is called a sale, which is a method of exchange introduced for the convenience of mankind by establishing an universal medium which may be exchanged for all sorts of other property. Whereas if goods were only to be exchanged for goods by way of barter, it would be difficult to adjust the respective values, and the carriage would be intolerably cumbersome. All civilized nations adopted therefore very early the use of money. For we find Abraham giving 400 shekels of silver, current money with the merchant, for the field of Machpelah, though the practice of exchanges still subsists among several savage nations. But with regard to the law of sales and exchanges, there is no difference. I shall therefore treat of them both under the denomination of sales only, and shall consider their force and effect, in the first place, where the vendor hath in himself, and secondly, where he hath not, the property of the things sold. Where the vendor hath in himself the property of the goods sold, he hath the liberty of disposing of them to whomever he pleases at any time and in any manner, unless judgment has been obtained against him for a debt or damages, and the writ of execution is actually delivered to the sheriff. For then, by the statute of frauds, the sale shall be looked upon as fraudulent, and the property of the goods shall be bound to answer the debt from the time of delivering the writ. Formerly it was bound from the testi, or issuing of the writ, and any subsequent sale was fraudulent. But the law was thus altered in favor of purchasers, though it still remains the same between the parties. And therefore, if a defendant dies after the awarding and before the delivery of the writ, his goods are bound by it in the hands of his executors. If a man agrees with another for goods at a certain price, he may not carry them away before he hath paid for them, for it is no sale without payment, unless the contrary be expressly agreed. And therefore, if the vendor says the price of a beast is £4, and the vendee says he will give £4, the bargain is struck, and they neither of them are at liberty to be off, provided immediate possession be tendered by the other side. But if neither the money be paid, nor the goods delivered, nor tender made, nor any subsequent agreement be entered into, it is no contract, and the owner may dispose of the goods as he pleases. But if any part of the price is paid down, if it be but a penny, or any portion of the goods delivered by way of earnest, which the civil law calls ara, and interprets to be emptiones venditiones contractae argumentum, the property of the goods is absolutely bound by it, and the vendee may recover the goods by action, as well as the vendor may the price of them. And such regard does the law pay to earnest as an evidence of a contract, that, by the same statute 29 Charles II c. 3, no contract for the sale of goods to the value of £10 or more shall be valid unless the buyer actually receives part of the goods sold by way of earnest on his part, or unless he gives a part of the price to the vendor by way of earnest to bind the bargain, or in part of payment, or unless some note in writing be made and signed by the party or his agent who is to be charged with the contract. And, with regard to goods under the value of £10, no contract or agreement for the sale of them shall be valid unless the goods are to be delivered within 1 year, or unless the contract be made in writing and signed by the party who is to be charged therewith. Anciently, among all the northern nations, shaking of hands was held necessary to bind the bargain, a custom which we still retain in many verbal contracts. A sale thus made was called a hand sale, venditio per mertuum manuum complexionum, till, in the process of time, the same word was used to signify the price or earnest which was given immediately after the shaking of hands, or instead thereof. As soon as the bargain is struck, the property of goods is transferred to the vendee, and that of the price to the vendor. but the vendee cannot take the goods until he renders the price agreed on. But if he tenders the money to the vendor, and he refuses it, the vendee may seize the goods or have an action against the vendor for detaining them. And by a regular sale, without delivery, the property is so absolutely vested in the vendee that if A sells a horse to B for £10, and B pays him earnest, or signs a note in writing of the bargain, and afterwards, before the delivery of the horse or money paid, the horse dies in the vendor's custody, still he is entitled to the money, because by the contract the property was in the vendee. Thus may property and goods be transferred by sale where the vendor hath such property in himself. But property may also in some cases be transferred by sale, though the vendor hath none at all in the goods. For it is expedient that the buyer, by taking proper precautions, may at all events be secure of his purchase. Otherwise, all commerce between man and man must soon be at an end. And therefore, the general rule of law is, that all sales and contracts of anything vendible in fairs or markets overt, that is, open, shall not only be good between the parties, but also be binding on all those that have any right or property therein. And for this purpose, the Mirror informs us, were tolls established in markets, viz., to testify the making of contracts, for every private contract was discountenanced by law. Wherefore, our Saxon ancestors prohibited the sale of anything above the value of 20 pence unless in open market, and directed every bargain and sale to be contracted in the presence of credible witnesses. Market overt in the country is only held on the special days provided for by particular towns by charter or prescription, but in London every day except Sunday is market day. The marketplace, or spot of ground set apart by custom for the sale of particular goods, is also in the country the only market overt, but in London every shop in which goods are exposed publicly to sale is market overt, for such things only as the owner professes to trade in. But if my goods are stolen from me, and sold out of market overt, my property is not altered, and I may take them wherever I find them. And it is expressly provided by statute 1 Jacobin 1 C21 that the sale of any goods wrongfully taken to any pawnbroker in London or within 2 miles thereof shall not alter the property, for this, being usually a clandestine trade, is therefore made an exception to the general rule. And, even in market overt, if the goods be the property of the king, such sale, though regular in all other respects, will in no case bind him, though it binds infants, femme coverts, idiots, or lunatics, and men beyond the sea, or in prison. Or if the goods be stolen from a common person, and then taken by the king's officer from the felon, and sold in open market, still, if the owner has used due diligence in prosecuting the thief to conviction, he loses not his property in the goods. So likewise, if the buyer knoweth the property not to be in the seller, or there be any other fraud in the transaction, if he knoweth the seller to be an infant or femme covert not usually trading for herself, if the sale be not originally and wholly made in the fair or market, or not at the usual hours, the owner's property is not bound thereby. If a man buys his own goods at a fair or market, the contract of sale shall not bind him so as that he shall render the price, unless the property had been previously altered by a former sale. And, notwithstanding any number of intervening sales, if the original vendor, who sold without having the property, comes again into possession of the goods, the original owner may take them when found in his hands who was guilty of the first breach of justice. By which wise regulations the common law has secured the right of the proprietor in personal chattels from being divested, so far as was consistent with that other necessary policy, that purchasers bona fide, in a fair, open, and in regular manner, should not be afterwards put to difficulties by reason of the previous knavery of the seller. But there is one species of personal chattels in which the property is not easily altered by sale without the express consent of the owner, and those are horses, the sale of which, even in fairs or markets overt, is void in many instances where that of other property is valid, because a horse is so fleet an animal that the stealers of them may flee far off in a short space, and be out of reach of the most industrious owner. All persons, therefore, that have occasion to deal in horses, and are therefore liable sometimes to buy stolen ones, would do well to observe that whatever price they may give, or how long soever they may keep possession before it be claimed, they gain no property in a horse that has been stolen, unless it be bought in a fair or market overt, nor even then unless the directions be pursued that are laid down in the statutes 2 P.N.M. C7 and 31 Elizabeth C12, by which it is enacted that every horse so to be sold shall be openly exposed in the time of such fair or market for 1 whole hour together, between 10 in the morning and sunset, in the open and in public place used for such sales, and not in any private yard or stable, that the horse shall be brought by both the vendor and vendee to the toll gatherer or bookkeeper of such fair or market, that toll be paid if any be due, and if not, 1 penny to the bookkeeper, who shall enter down the price, color, and marks of the horse, with the names, additions, and abode of the vendee and vendor, the latter either upon his own knowledge or the testimony of some credible witness. And, even if all these points be fully complied with, yet such sale shall not take away the property of the owner if within 6 months after the horse is stolen he puts in a claim before the mayor or some justice of the district in which the horse shall be found, and within 40 days after that proves such his property by the oath of 2 witnesses before such mayor or justice, and also tenders to the person in possession such price as he bona fide paid for him in market overt. But in case any one of the points before mentioned be omitted, or not observed in the sale, such sale is utterly void, and the owner shall not lose his property, but at any distance of time may seize or bring an action for his horse wherever he happens to find him. Wherefore Sir Edward Coke observes, that both by the common law and these 2 statutes, the property of horses is so well preserved, that if the owner be of capacity to understand them, and be vigilant and industrious to pursue the same, it is almost impossible that the property of any horse, either stolen or not stolen, should be altered by any sale in market overt by him that is mali fide possessor. By the civil law, an implied warranty was annexed to every sale in respect to the title of the vendor, and so too in our law a purchaser of goods and chattels may have a satisfaction from the seller if he sells them as his own, and the title proves deficient, without any express warranty for that purpose. But with regard to the goodness of the wares so purchased, the vendor is not bound to answer, unless he expressly warrants them to be sound and good, or unless he knew them to be otherwise and hath used any art to disguise them, or unless they turn out to be different from what he represented to the buyer. End of chapter 30, part 1. Chapter 30, Part 2 of the Commentaries on the Laws of England, Book 2, by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Of Title by Gift, Grant, and Contract, Part 2. 2. Bailment, from the French bailler, to deliver, is a delivery of goods in trust upon a contract expressed or implied, that the trust shall be faithfully executed on the part of the bailee, as if cloth be delivered, or, in our legal dialect, bailed, to a tailor to make a suit of clothes. He has it upon an implied contract to render it again when made, and that in a workmanly manner. If money or goods be delivered to a common carrier, to convey from Oxford to London, he is under a contract in law to pay or carry them to the person appointed. If a horse or other goods be delivered to an innkeeper or his servants, he is bound to keep them safely, and restore them when his guest leaves the house. If a man takes in a horse or other cattle to graze and depasture in his grounds, which law calls agistment, he takes them upon an implied contract to return them safe to the owner. If a pawnbroker receives plate or jewels as a pledge or security for the repayment of money lent thereon at a day certain, he has them upon an express contract or condition to restore them if the pledgor performs his part by redeeming them in due time, for the due execution of which contract many useful regulations are made by statute 30 George II, c. 24. And so if a landlord distrains goods for rent, or a parish officer for taxes, these are for a time only a pledge in the hands of the distrainers, and they are bound by an implied contract in law to restore them on payment of the debt, duty, and expenses before the time of sale, or, when sold, to render back the overplus. If a friend delivers anything to his friend to keep for him, the receiver is bound to restore it on demand, and it was formerly held that in the meantime he was answerable for any damage or loss it might sustain, whether by accident or otherwise, unless he expressly undertook to keep it only with the same care as his own goods, and then he should not be answerable for theft or other accidents. But now the law seems to be settled upon a much more rational footing, that such a general bailment will not charge the bailee with any loss, unless it happens by gross neglect, which is construed to be an evidence of fraud. But if the bailee undertakes specially to keep the goods safely and securely, he is bound to answer all perils and damages that may befall them for want of the same care with which a prudent man would keep his own. In all these instances, there is a special qualified property transferred from the bailor to the bailee together with the possession. It is not an absolute property in the bailee, because of his contract for restitution, and the bailor hath nothing left in him but the right to a chose in action, grounded upon such contract, the possession being delivered to the bailee. And, on account of this qualified property of the bailee, he may, as well as the bailor, maintain an action against such as injure or take away these chattels. The tailor, the carrier, the innkeeper, the adjusting farmer, the pawnbroker, the distrainer, and the general bailee may all of them vindicate, in their own right, this their possessory interest against any stranger or third person. 4. As such bailee is responsible to the bailor if the goods are lost or damaged by his wilful default or gross negligence, or if he do not deliver up the chattels on lawful demand, it is therefore reasonable that he should have a right to recover either these specific goods, or else a satisfaction in damages against all other persons who may have purloined or injured them, that he may always be ready to answer the call of the bailor. 3. Hiring and borrowing are also contracts by which a qualified property may be transferred to the hirer or borrower, in which there is only this difference, that hiring is always for a price, a stipend, or additional recompense. Borrowing is merely gratuitous, but the law in both cases is the same. They are both contracts whereby the possession and a transient property is transferred for a particular time or use, on condition and agreement to restore the goods so hired or borrowed as soon as the time is expired, or use performed, together with the price or stipend in the case of hiring, either expressly agreed on by the parties or left to be implied by law according to the value of the service. By this mutual contract, the hirer or borrower gains a temporary property in the thing hired, accompanied with an implied condition to use it with moderation and not abuse it, and the owner or lender retains a reversionary interest in the same, and acquires a new property in the price or reward. Thus, if a man hires or borrows a horse for a month, he has the possession and a qualified property therein during that period, on the expiration of which his qualified property determines, and the owner becomes, in the case of hiring, entitled to the premium or price for which the horse was hired. There is one species of this price or reward, the most usual of any, but concerning which many good and learned men have in former times very much perplexed themselves and other people by raising doubts about its legality in formo conscientiae. That is, when money is lent on a contract to receive not only the principal sum again, but also an increase by way of compensation for the use, which is generally called interest by those who think it lawful, and usury by those who do not so. It may not be amiss, therefore, to enter into a short inquiry upon what footing this matter of interest or usury does really stand. The enemies to interest in general make no distinction between that and usury, holding any increase of money to be indefensibly usurious. And this they ground as well on the prohibition of it by the law of Moses among the Jews as upon what is laid down by Aristotle, that money is naturally barren, and to make it breed money is preposterous, and a perversion of the end of its institution, which was only to serve the purposes of exchange and not of increase. Hence, the school divines have branded the practice of taking interest as being contrary to the divine law, both natural and revealed, and the canon law has prescribed it taking the least increase for the loan of money as a mortal sin. But, in answer to this, it may be observed that the Mosaical precept was clearly a political and not a moral precept. It only prohibited the Jews from taking usury from their brethren the Jews, but in express words permitted them to take it of a stranger, which proves that the taking of moderate usury, or a reward for the use, or so the word signifies, is not malum in se, since it was allowed where any but an Israelite was concerned. And as to Aristotle's reason, deduced from the natural barrenness of money, the same may with equal force be alleged of houses which never breed houses, and 20 other things which nobody doubts it is lawful to make a profit of by letting them to hire. And though money was originally used only for the purposes of exchange, yet the laws of any state may be well justified in permitting it to be turned to the purposes of profit, if the convenience of society, the great end for which money was invented, shall require it. And that the allowance of moderate interest tends greatly to the benefit of the public, especially in a trading country, will appear from that generally acknowledged principle that commerce cannot subsist without mutual and extensive credit. Unless money, therefore, can be borrowed, trade cannot be carried on, and if no premium were allowed for the hire of money, few persons would care to lend it, or at least the case of borrowing at a short warning, which is the life of commerce, would be entirely at an end. Thus, in the dark ages of monkish superstition and civil tyranny, when interest was laid under a total interdict, commerce was also at its lowest ebb, and fell entirely into the hands of the Jews and Lombards. But when men's mind began to be more enlarged, when true religion and real liberty revived, commerce grew again into credit, and again introduced itself its inseparable companion, the doctrine of loans upon interest. And, really, considered abstractly from this its use, since all other conveniences of life may either be bought or hired, but money can only be hired, there seems no greater impropriety in taking a recompense or price for the hire of this than of any other convenience. If I borrow £100 to employ in a beneficial trade, it is but equitable that the lender should have a proportion of my gains. To demand an exorbitant price is equally contrary to conscience, for the loan of a horse or the loan of a sum of money, but a reasonable equivalent for the temporary inconvenience the owner may feel by the want of it, and for the hazard of his losing it entirely, is not more immoral in one case than it is in the other. And indeed, the absolute prohibition of lending upon any, even moderate interest, introduces the very inconvenience which it seems meant to remedy. The necessity of individuals will make borrowing unavoidable. Without some profit allowed by law, there will be but few lenders, and those principally bad men who will break through the law and take a profit, and then will endeavor to indemnify themselves from the danger of the penalty by making that profit exorbitant. Thus, while all degrees of profit were discountenanced, we find more complaints of usury and more flagrant instances of oppression than in modern times when money may be easily had at a low interest. A capital distinction must therefore be made between a moderate and exorbitant profit, to the former of which we usually give the name interest, to the latter the truly odious appellation of usury. The former is necessary in every civil state, if it were but to exclude the latter, which ought never to be tolerated in any well-regulated society. For, as the whole of this matter is well summed up by Grotius, if the compensation allowed by law does not exceed the proportion of the hazard run, or the want felt, by the loan, its allowance is neither repugnant to the revealed nor the natural law, but if it exceeds those bounds, it is then oppressive usury, and though the municipal laws may give it impunity, they never can make it just. We see that the exorbitance or moderation of interest for money lent depends on two circumstances: the inconvenience of parting with it for the present, and the hazard of losing it entirely. The inconvenience to individual lenders can never be eliminated by laws. The rate, therefore, of general interest must depend upon the usual or general inconvenience. This results entirely from the quantity of specie or current money in the kingdom. For, the more specie there is circulating in any nation, the greater superfluity there will be, beyond what is necessary to carry on the business of exchange and the common concerns of life. In every nation or public community there is a certain quantity of money thus necessary, which a person well skilled in political arithmetic might perhaps calculate as exactly as a private banker can the demand for running cash in his own shop. All above this necessary quantity may be spared or lent without much inconvenience to the respective lenders, and the greater this national superfluity is, the more numerous will be the lenders, and the lower ought the rate of national interest be. But where there is not enough, or barely enough, circulating cash to answer the ordinary uses of the public, interest will be proportionably high, for lenders will be but few, as few as can submit to the inconvenience of lending. So also, the hazard of entire loss has its weight in the regulation of interest. Hence, the better the security, the lower will the interest be, the rate of interest being generally in a compound ratio formed out of the inconvenience and the hazard. And as, if there were no inconvenience, there should be no interest but what is equivalent to the hazard, so, if there were no hazard, there ought to be no interest save only what arises from the mere inconvenience of lending. Thus, if the quantity of specie in a nation be such that the general inconvenience of lending for a year is computed to amount to 3%, a man that has money by him will perhaps lend it upon good personal security at 5%, allowing 2 for the hazard run. He will lend it upon landed security or mortgage at 4%, the hazard being proportionally less, but he will lend it to the state, on the maintenance of which all his property depends, at 3%, the hazard being none at all. But sometimes the hazard may be greater than the rate of interest allowed by law will compensate, and this gives rise to the practice, 1. Of bottomry, or respondentia, 2. Of policies of insurance, and first, bottomry, which originally arose from permitting the master of a ship in a foreign country to hypothecate the ship in order to raise money to refit, is in the nature of a mortgage of a ship, where the owner takes up money to enable him to carry on his voyage, and pledges the keel or bottom of the ship pars pro toto as a security for the repayment. In which case it is understood that, if the ship be lost, the lender loses also his whole money, but if it returns in safety, then he shall receive back his principal, and also the premium or interest agreed upon, however it may exceed the legal rate of interest. And this is allowed to be a valid contract in all trading nations, for the benefit of commerce, and by reason of the extraordinary hazard run by the lender. And in this case, the ship and tackle, if brought home, are answerable, as well as the person of the borrower, for the money lent. But if the loan is not upon the vessel, but upon the goods and merchandise, which must necessarily be sold or exchanged in the course of the voyage, then only the borrower, personally, is bound to answer the contract, who therefore, in this case, is said to take up money at respondentia. These terms are also applied to contracts for the repayment of money borrowed, not on the ship and goods only, but on the mere hazard of the voyage itself. When a man lends a merchant £1,000 to be employed in a beneficial trade, with conditions to be repaid with extraordinary interest in case such voyage be safely performed, which kind of agreement is sometimes called voenus nauticum and sometimes usura maritima. But, as this gave an opening for usurious and gaming contracts, especially on long voyages, it was enacted by the statute 19 George II, c. 37, that all moneys lent on bottomry or at respondentia on vessels bound to or from the East Indies shall be expressly lent only upon the ship or upon the merchandise, that the lender shall have the benefit of salvage, and that, if the borrower has not on board effects to the value of the sum borrowed, he shall be responsible to the lender for so much of the principal as hath not been laid out, with legal interest and all other charges, though the ship and merchandise be totally lost. Secondly, a policy of insurance is a contract between A and B, that upon A's paying a premium equivalent to the hazard run, B will indemnify or insure him against a particular event. This is founded upon one of the same principles as the doctrine of interest upon loans, that of hazard, but not that of inconvenience. For if I insure a ship to the Levant and back again at 5%, here I calculate the chance that she performs her voyage to be 20 to 1 against being lost, and, if she be lost, I lose £100 and get £5. Now this is much the same as if I lent the merchant, whose whole fortunes are embarked in this vessel, £100 at the rate of 8%. For by a loan I should be immediately out of my money, the inconvenience of which we have computed equal to 3%. If therefore I had actually lent him £100, I must have added £3 on the score of inconvenience to the £5 allowed for the hazard, which together would have made £8. But, as upon an insurance, I am never out of my money till the loss actually happens. Nothing is therein allowed upon the principle of inconvenience, but all upon the principle of hazard. Thus, too, in a loan, if the chance of repayment depends upon the borrower's life, it is frequent, besides the usual rate of interest, for the borrower to have his life insured till the time of repayment, for which he is loaded with an additional premium suited to his age and constitution. Thus, if Sempronius has only an annuity for his life, and would borrow £100 of titius for a year, the inconvenience and general hazard of this loan we have seen are equivalent to £5, which is therefore the legal interest. But there is also a special hazard in this case, for if Sempronius dies within the year, Titius must lose the whole of his £100. Suppose this chance to be 1 to 10, it will follow that the extraordinary hazard is worth £10 more, and therefore the reasonable rate of interest in this case would be 15%. But this the law, to avoid abuses, will not permit to be taken. Sempronius therefore gives Titius the lender only £5, the legal interest, but applies to Gaius, an insurer, and gives him the other £10 to indemnify Titius against the extraordinary hazard. And in this manner may extraordinary or particular hazard be provided against, which the established rate of interest will not reach, that being calculated by the state to answer the ordinary and general hazard, together with the lender's inconvenience in parting with his specie for a time. The learning relating to maritime insurances have of late years been greatly improved by a series of judicial decisions, which have now established the law in such a variety of cases that, if well and judiciously collected, they would form a very complete title in a code of commercial jurisprudence. But, being founded on equitable principles, which chiefly result from the special circumstances of the case, it is not easy to reduce them to any general heads in mere elementary institutes. Thus much may however be said, that being contracts, the very essence of which consists in observing the purest good faith and integrity, they are vacated by any the least shadow of fraud or undue concealment, and, on the other hand, being much for the benefit and extension of trade, by distributing the loss or gain among a number of adventurers, they are greatly encouraged and protected by both common law and acts of Parliament. But, as a practice had obtained of insuring large sums without having any property on board, which were called insurances, interest or no interest, and also of insuring the same goods several times over, both of which were a species of gaming without any advantage to commerce, and were denominated wagering policies, it is therefore enacted by the statute 19 George II, c. 37, that all insurances, interest or no interest, or without further proof of interest than the policy itself, or by way of gaming or wagering, or without benefit of salvage to the insurer, all which had the same pernicious tendency, shall be totally null and void, except upon privateers or ships in the Spanish and Portuguese trade for reasons sufficiently obvious, and that no reassurance shall be lawful except the former insurer shall be insolvent, a bankrupt, or dead. And lastly, that in the East India trade, a lender of money on bottomry or at respondentia shall alone have the right to be insured for the money lent, and the borrower shall, in the case of a loss, recover no more upon any insurance than the surplus of his property above the value of his bottomry or respondentia bond. But to return to the doctrine of common interest on loans. Upon two principles of inconvenience and hazard, compared together, different nations have at different times established different rates of interest. The Romans at one time allowed centesimi, or 12%, to be taken for common loans, but Justinian reduced it to trientes, or one-third of the centesimi, that is, 4%, but allowed higher interest to be taken of merchants, because there the hazard was greater. So, too, Grotius informs us that in Holland the rate of interest was then 8% in common loans, but 12 to merchants. Our law establishes one standard for all alike, where the pledge or security itself is not put in jeopardy, lest, under the general pretense of vague and indeterminate hazards, a door should be opened to fraud and usury, leaving specific hazards to be provided against by specific insurances or by loans upon respondentia or bottomry. But as to the rate of legal interest, It has varied and decreased for 200 years past, according as the quantity of species in the kingdom has increased by accessions of trade, the introduction of paper credit, and other circumstances. The statute 37 Henry VIII c. 9 confined interest to 10%, and so did the statute 13 Elizabeth c. 8. But as, through the encouragements given in her reign to commerce, the nation grew more wealthy, so under her successor the statute 21 Jacobin 1 c. 17 reduced it to 8%, as did the statute 12 Charles II c. 13 to 6, and lastly, by the statute 12 Anne Ft 2 c. 16, it was brought down to 5% yearly, which is now the extremity of legal interest that can be taken. But yet, if a contract which carries interest be made in a foreign country, our courts will direct payment of interest according to the law of that country in which the contract was made. Thus Irish, American, Turkish, and Indian interest have been allowed in our courts to the amount of 12%, for the moderation or exorbitance of interest depends upon local circumstances, and the refusal to enforce such contracts would put a stop to all foreign trade. End of Chapter 30, Part 2. Chapter 23, Part 3 of the Commentaries on the Laws of England, Book 2, by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Of Title by Gift, Grant, and Contract. Part 3. 4. The last general species of contracts which I have to mention is that of debt, whereby a chosen action or a right to a certain sum of money is mutually acquired and lost. This may be the counterpart of, and arise from, any of the other species of contracts. As in case of a sale, where the price is not paid in ready money, the vendee becomes indebted to the vendor for the sum agreed on, and the vendor has a property in this price as a chosen action by means of this contract of debt. In bailment, if the bailee loses or detains a sum of money bailed to him for any special purpose, he becomes indebted to the bailor in the same numerical sum, upon his implied contract that he shall execute the trust reposed in him or repay the money to the bailor. Upon hiring or borrowing, the hirer or borrower, at the same time he acquires a property in the thing lent, may also become indebted to the lender, upon his contract to restore the money borrowed, to pay the price or premium of the loan, the hire of the horse, or the like. Any contract, in short, whereby a determinate sum of money becomes due to any person, and is not paid, but it remains in action merely, is a contract of debt. And, taken in this light, it comprehends a great variety of acquisition, being usually divided into debts of record, debts by special, and debts by simple contract. A debt of record is a sum of money which appears to be due by the evidence of a court of record. Thus, when any specific sum is adjudged to be due from the defendant to the plaintiff on an action or suit at law, this is a contract of the highest nature, being established by the sentence of a court of judicature. Recognizances also are a sum of money recognized or acknowledged to be due to the crown or a subject in the presence of some court or magistrate, with the condition that such acknowledgment shall be void upon the appearance of the party, his good behavior, or the like. And these, together with statutes merchant and statutes staple, etc., if forfeited by non-performance of the condition, are also ranked among this and principal class of debts, viz., debts of record, since the contract on which they are founded is witnessed by the highest kind of evidence, viz., by matter of record. Debts by specialty, or special contract are such whereby a sum of money becomes or is acknowledged to be due by deed or instrument under seal, such as by deed of covenant, by deed of sale, by lease reserving rent, or by bond or obligation, which last we took occasion to explain in the 20th lecture of the present book, and then showed that it is an acknowledgment or a creation of debt from the obliger to the obligee, unless the obligor performs a condition thereunto usually annexed, as the payment of rent or money borrowed, the observance of a covenant, and the like, on failure of which the bond becomes forfeited and the debt becomes due in law. These are looked upon as the next class of debts after those of record, being confirmed by special evidence under seal. Debts by simple contract are such, where the contract upon which the obligation arises is neither ascertained by matter of record, nor yet by deed or special instrument, but by mere oral evidence, the most simple of any, or by notes unsealed, which are capable of a more easy proof, and, therefore only, better than a verbal promise. It is easy to see into what a vast variety of obligations this last class may be branched out, through the numerous contracts for money, which are not only expressed by the parties, but virtually implied in law. Some of these we have already occasionally hinted at, and the rest, to avoid repetition, must be referred to those particular heads in the third book of these commentaries, where the breach of such contracts will be considered. I shall only observe at present, that by the statute 29 Charles III, no executor or administrator shall be charged upon any special promise to answer damages out of his own estate, and no person shall be charged upon any promise to answer for the debt or default of another, or upon any agreement in consideration of marriage, or upon any contract or sale of any real estate, or upon any agreement that is not to be performed within 1 year from the making, unless the agreement or some memorandum thereof be in writing and signed by the party himself or by his authority. But there is one species of debts upon simple contract which, being a transaction now introduced into all sorts of civil life under the name of paper credit, deserves a more particular regard. These are debts by bills of exchange and promissory notes. A bill of exchange is a security, originally invented among merchants in different countries for the more easy remittance of money from the one to the other, which has since spread itself into almost all pecuniary transactions. It is an open letter of request from one man to another, desiring him to pay a sum named therein to a third person on his account, by which means a man at the most distant part of the world may have money remitted to him from any trading country. If A lives in Jamaica, and owes B, who lives in England, £1,000, now if C be going from England to Jamaica, he may pay B this £1,000, and take a bill of exchange drawn by B in England upon A in Jamaica, and receive it when he comes thither. Thus does B receive his debt at any distance of place by transferring it to C, who carries over his money in paper credit without danger of robbery or loss. This method is said to have been brought into general use by the Jews and Lombards when banished for their usury and other vices, in order the more easily to draw their effects out of France and England into those countries in which they had chosen to reside. The invention of them was a little earlier, for the Jews were banished out of Guienne in 1287, and out of England in 1290, and in 1236 the use of paper credit was introduced into the Mogul Empire in China. In common speech such a bill is frequently called a draft, but a bill of exchange is the more legal as well as mercantile expression. The person, however, who writes this letter is called in law the drawer, and he to whom it is written the drawee, and the third person or negotiator to whom it is payable, whether specially named or the bearer generally, is called the payee. These bills are either foreign or inland. Foreign, when drawn by a merchant residing abroad upon his correspondent in England, or vice versa, and inland, when both the drawer and the drawee reside within the kingdom. Formerly, foreign bills of exchange were much more regarded in the eye of the law than inland ones, as being thought of more public concern in the advancement of trade and commerce. But now, by two statutes, the one 9 and 10 William III, c. 17, the other 3 and 4 Anne, c. 9, inland bills of exchange are put upon the same footing as foreign ones. What was the law and custom of merchants with regard to the one, and taken notice of merely as such, being by those statutes expressly enacted with regard to the other, so that there is now in law no manner of difference between them. Promissory notes, or notes of hand, are a plain and direct engagement in writing, to pay a sum specified at the time therein limited to a person therein named, or sometimes to his order, or often to the bearer at large. These also, by the same statute 3 and 4 Anne, c. 9, are made assignable and endorsable in like manner as bills of exchange. The payee, we may observe, either of a bill of exchange or promissory note, has clearly a property vested in him, not indeed in possession, but in action, by the express contract of the drawer in the case of a promissory note, and, in the case of a bill of exchange, by his implied contract, viz., that provided the drawee does not pay the bill, the drawer will. For which reason it is usual in bills of exchange to express that the value thereof hath been received by the drawer, in order to show the consideration upon which the implied contract of repayment arises. And this property so vested may be transferred and assigned from the payee to any other man, contrary to the general rule of the common law that no chosen action is assignable, which assignment is the life of paper credit. It may therefore be of some use to mention a few of the principal incidents attending this transfer or assignment, in order to make it regular, and thereby to charge the drawer with the payment of the debt to other persons than those with whom he originally contracted. In the first place, then, the payee, or person to whom the whole order such a bill of exchange or promissory note is payable, may, by endorsement, or writing his name in dorso, or on the back of it, assign over his whole property to the bearer, or else to another person by name, either of whom is then called the indorsee, and he may assign the same to another, and so on in infinitum. And a promissory note payable to a or bearer is negotiable without any endorsement, and payment thereof may be demanded by any bearer of it. But in case of a bill of exchange, the payee or the endorsee, whether it be a general or particular endorsement, is to go to the drawee and offer his bill for acceptance, which acceptance, so as to charge the drawer with costs, must be in writing under or on the back of the bill. If the drawee accepts the bill, either verbally or in writing, he then makes himself liable to pay it, this being now a contract on his side, grounded on an acknowledgment that the drawer has effects in his hand, or at least credit sufficient to warrant the payment. If the drawee refuses to accept the bill, and it be of the value of £20 or upwards, and expressed to be for value received, the payee or endorsee may protest it for non-acceptance, which protest must be made in writing under a copy of such bill of exchange by some notary public, or, if no such notary be resident in the place, then by another substantial inhabitant in the presence of two credible witnesses, and notice of such protest must, within 14 days after, be given to the drawer. But In case such a bill be accepted by the drawee, and after acceptance he fails or refuses to pay it within 3 days after it becomes due, which 3 days are called days of grace, the payee or endorsee is then to get it protested for non-payment, in the same manner and by the same persons who are to protest it in case of non-acceptance, and such protest must also be notified within 14 days after to the drawer, and he, on producing such protest, either of non-acceptance or non-payment, is bound to make good to the payee or endorsee not only the amount of the said bills, which he is bound to do within a reasonable time after non-payment without any protest by the rules of the common law, but also interest and all charges to be computed from the time of making such protest. But if no protest be made or notified to the drawer, and any damage accrues by such neglect, it shall fall on the holder of the bill. The bill, when refused, must be demanded of the drawer as soon as conveniently may be. For though, when one draws a bill of exchange, he subjects himself to the payment, if the person on whom it is drawn refuses either to accept or pay, yet that is with this limitation, that if the bill be not paid when due, the person to whom it is payable shall in convenient time give the drawer notice thereof, for otherwise the law will imply it paid, since it would be prejudicial to commerce if a bill might rise up to charge the drawer at any distance of time, when in the meantime all reckonings and accounts may be adjusted between the drawer and the drawee. If the bill be an endorsed bill, and the endorsee cannot get the drawee to discharge it, he may call upon either the drawer or the endorser, or, if the bill has been negotiated through many hands, upon any of the endorsers, for each endorser is a warrantor for the payment of the bill, which is frequently taken in payment as much, or more, upon the credit of the endorser as of the drawer. And if such endorser, so called upon, has the names of one or more endorsers prior to his own, to each of whom he is properly an endorsee, he is also at liberty to call upon any of them to make satisfaction, and so upwards. But the first endorser has nobody to resort to but the drawer only. What has been said of bills of exchange is applicable also to promissory notes, that are endorsed over, and negotiated from one hand to another, only that, in this case, as there is no drawee, there can be no protest for non-acceptance, or rather, the law considers a promissory note in the light of a bill drawn by a man upon himself, and accepted at the time of drawing, and, in case of non-payment by the drawer, the several endorsees of a promissory note have the same remedy as upon bills of exchange against the prior endorsers. End of Chapter 30, Part 3. Chapter 31, Part 1 of the Commentaries on the Laws of England by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Of Title by Bankruptcy, Part 1. The preceding chapter having treated pretty largely of the acquisition of personal property by several commercial methods, we from thence shall easily be led to take into our present consideration a 10th method of transferring property, which is that of 10. Bankruptcy, a title which we before lightly touched upon, so far as it related to the transfer of the real estate of a bankrupt. At present we are to treat of it more minutely, as it principally relates to the disposition of chattels, in which the property of persons concerned in trade more usually consists than in lands or tenements. Let us therefore first of all consider 1. Who may become a bankrupt? 2. What acts make a bankrupt? 3. the proceedings on a commission of bankrupt, and 4. In what manner an estate of goods and chattels may be transferred by bankruptcy. 1. Who may become a bankrupt? A bankrupt was before defined to be a trader who secretes himself or does certain other acts tending to defraud his creditors. He was formerly considered merely in the light of a criminal or offender, and in this spirit we are told by Sir Edward Coke that we has fetched as well the name as the wickedness of bankrupts from foreign nations. But at present the laws of bankruptcy are considered as laws calculated for the benefit of trade, and founded on the principles of humanity as well as justice, and to that end they confer some privileges not only on the creditors, but also on the bankrupt or debtor himself. On the creditors, by compelling the bankrupt to give up all his effects to their use, without any fraudulent concealment. On the debtor, by examining him from the rigor of the general law, whereby his person might be confined at the discretion of his creditor, though in reality he has nothing to satisfy the debt. Whereas the law of bankrupts, taking into consideration the sudden and unavoidable accidents to which men in trade are liable, has given them the liberty of their persons, and some pecuniary emoluments, upon condition they surrender up their whole estate to be divided among their creditors. In this respect our legislature seems to have attended to the example of the Roman law. I mean not the terrible law of the 12 tables, whereby the creditors might cut the debtor's body into pieces, and each of them take his proportionable share, if indeed that law, de debitore in parte secando, is to be understood in so very butcherly a light, which many learned men have with reason doubted. Nor do I mean those less inhuman laws, if they may be called so, as their meaning is indisputably certain, of imprisoning the debtor's person in chains, subjecting him to stripes and hard labor, at the mercy of his rigid creditor, and sometimes selling him, his wife, and children to perpetual foreign slavery trans Tiberium, an oppression which produced so many popular insurrections and secessions to the mons fece. But I mean the law of cession, introduced by the Christian emperors, whereby if a debtor ceded or yielded up all his fortune to his creditors, he was secured from being dragged to a jail, omne quoque corpore cruciatus in moto. For, as the emperor justly observes, in humanum eret spoliatum fortunae suis in solidum damnari. Thus far was just and reasonable, but, as the departing from one extreme is apt to produce its opposite, we find it afterwards enacted, that if the debtor, by any unforeseen accident, was reduced to low circumstances, and would swear that he had not sufficient left to pay his debts, he should not be compelled to cede or give up even that which he had in his possession, a law which under a false notion of humanity seems to be fertile of perjury, injustice, and absurdity. The laws of England, more wisely, have steered in the middle between both extremes, providing at once against the inhumanity of the creditor, who is not suffered to continue an honest bankrupt after his effects are delivered up, and at the same time taking care that all his just debts shall be paid so far as the effects will extend. But still they are cautious of encouraging prodigality and extravagance by this indulgence to debtors, and therefore they allow the benefit of the laws of bankruptcy to none but actual traders, since that set of men are, generally speaking, the only persons liable to accidental losses to an inability of paying their debts without any fault of their own. If persons in other situations of life run in debt without the power of payment, they must take the consequences of their own indiscretion, even though they meet with sudden accidents that may reduce their fortunes. For the law holds it to be an unjustifiable practice for any person but a trader to encumber himself with debts of any considerable value. If a gentleman, or one in a liberal profession, at the time of contracting his debts, has a sufficient fund to pay them, The delay of payment is a species of dishonesty and a temporary injustice to his creditor, and if at such time he has no sufficient fund, the dishonesty and injustice is the greater. He cannot therefore murmur if he suffers the punishment which he has voluntarily drawn upon himself. But in mercantile transactions the case is far otherwise. Trade cannot be carried on without mutual credit on both sides. The contracting of debts is therefore here not only justifiable, but necessary. And if by accidental calamities, as by the loss of a ship in a tempest, the failure of brother traders, or by the non-payment of persons out of trade, a merchant or trader becomes incapable of discharging his own debts, it is his misfortune and not his fault. To the misfortunes, therefore, of debtors, the law has given a compassionate remedy, but denied it to their faults, since at the same time it provides for the security of commerce by enacting that every considerable trader may be declared a bankrupt for the benefit of his creditors as well as himself. It has also to discourage extravagance declared, that no one shall be capable of being made a bankrupt but only a trader, nor capable of receiving the full benefit of the statutes, but only an industrious trader. The first statute made concerning any English bankrupts was 34 Henry VIII c. 4, when trade began first to be properly cultivated in England, which has been almost totally altered by the statute 13 Elizabeth c. 7, whereby bankruptcy is confined to such persons only as have used the trade of merchandise, in gross or by retail, by way of bargaining, exchange, rechange, bartering, chevisance, or otherwise, or have sought their living by buying and selling. And by statute 21 Jacobin 1 c. 19, persons using the trade or profession of a scrivener, receiving other men's monies and estates into their trust and custody, are also made liable to the statutes of bankruptcy, and the benefits, as well as the penal parts of the law, are extended as well to aliens and denizens as to natural-born subjects, being intended entirely for the protection of trade, in which aliens are often as deeply concerned as natives. By many subsequent statutes, but lastly by the statute of 5 George II c. 30, bankers, brokers, and factors are declared liable to the statutes of bankruptcy, and this upon the same reason that scriveners are included by the statute of James I, viz., for the relief of their creditors, whom they have otherwise more opportunities of defrauding than any other set of dealers, and they are properly to be looked upon as traders, since they make merchandise of money, in the same manner as other merchants do of goods and other movable chattels. By the same act, no farmer, grazer, or drover shall, as such, be liable to be deemed a bankrupt, for, though they buy and sell corn and hay and beasts in the course of husbandry, yet trade is not their principal, but only a collateral object, their chief concern being to manure and till the ground and make the best advantage of its produce. And besides, subjecting them to the laws of bankruptcy might be a means of defeating their landlords of the security which the law has given them above all others, for the payment of their reserved rents. Wherefore also, upon a similar reason, the receiver of the king's taxes is not capable, as such, of being a bankrupt, lest the king should be defeated of those extensive remedies against his debtors which are put into his hands by the prerogative. By the same statute, no person shall have a commission of bankrupt awarded against him, unless at the petition of some one creditor to whom he owes £100, or of two to whom he is indebted £150, or of more to whom altogether he is indebted £200. For the law does not look upon persons whose debts amount to less, to be traders considerable enough either to enjoy the benefit of the statutes themselves, or to entitle the creditors for the benefit of public commerce to demand distribution of their effects. In the interpretation of these several statutes, it hath been held that buying only or selling only will not qualify a man to be a bankrupt, but it must be both buying and selling, and also getting a livelihood by it, as by exercising the calling of a merchant, a grocer, a mercer, or, in one general word, a chapman, who is one that buys and sells anything. But no handicraft occupation, where nothing is bought and sold, and therefore an extensive credit for the stock in trade is not necessary to be had, will make a man a regular bankrupt, as that of a husbandman, a gardener, and the like, who are paid for their work and labor. Also, an innkeeper cannot, as such, be a bankrupt, for his gain or livelihood does not arise from buying and selling in the way of merchandise, but greatly from the use of his rooms and furniture, his attendants, and the like. And though he may buy corn and victuals to sell again at a profit, yet that no more makes him a trader than a schoolmaster or other person is that keeps a boarding house and makes considerable gains by buying and selling what he spends in the house, and such a one is clearly not within the statutes. But where persons buy goods, and make them into saleable commodities, as shoemakers, smiths, and the like, here, though part of the gain is by bodily labor, and not by buying and selling, yet they are within the statutes of bankrupts, for the labor is only in melioration of the commodity, and rendering it more fit for sale. One single act of buying and selling will not make a man a trader, but a repeated practice and profit by it. Buying and selling bank stock or other government securities will not make a man a bankrupt, they not being goods, wares, or merchandise within the intent of the statute, by which a profit may be fairly made. Neither will buying and selling under particular restraints, or for other particular purposes, as if a commissioner of the navy uses to buy victuals for the fleet, and dispose of the surplus and refuse, he is not thereby made a trader within the statutes. An infant, though a trader, cannot be made a bankrupt, for an infant can own nothing but for necessaries, and the statutes of bankruptcy create no new debts, but only give a speedier and more effectual remedy for recovering such as were before due, and no person can be made a bankrupt for debts which he is not liable at law to pay. But a femme covert in London, being a sole trader according to the custom, is liable to a commission of bankrupt. 2. Having thus considered who may and who may not be made a bankrupt, we are to inquire secondly, by what acts a man may become a bankrupt. A bankrupt is a trader who secrets himself or does certain other acts tending to defraud his creditors. We have hitherto been employed in explaining the former part of this description, a trader. Let us now attend to the latter, who secrets himself or does certain other acts tending to defraud his creditors. And, in general, whenever such a trader as is before described hath endeavored to avoid his creditors or evade their just demands, this hath been declared by the legislature to be an act of bankruptcy, upon which a commission may be sued out. For in this extrajudicial method of proceeding, which is allowed merely for the benefit of commerce, the law is extremely watchful to detect a man whose circumstances are declining in the first instance, or at least as early as possible, that the creditors may receive as large a proportion of their debts as may be, and that a man may not go on wantonly wasting his substance, and then claim the benefit of the statutes when he has nothing left to distribute. To learn what the particular acts of bankruptcy are, which render a man a bankrupt, we must consult the several statutes and the resolutions formed by the courts thereon. Among these may therefore be reckoned 1. Departing from the realm whereby a man withdraws himself from the jurisdiction and coercion of the law with intent to defraud his creditors. 2. Departing from his own house with the intent to secret himself and avoid his creditors. 3. keeping in his own house, privately, so as not to be seen or spoken with by his creditors, except for just and necessary cause, which is likewise construed to be an intention to defraud his creditors by avoiding the process of the law. 4. Procuring or suffering himself willingly to be arrested, or outlawed, or imprisoned, without just and lawful cause, which is likewise deemed an attempt to defraud his creditors. 5. Procuring his money, goods, chattels, and effects to be attached or sequestered by any legal process, which is another plain and direct endeavor to disappoint his creditors of their security. 6. Making any fraudulent conveyance to a friend, or secret trustee, of his lands, tenements, goods, or chattels, which is an act of the same suspicious nature with the last. 7. Procuring any protection, not being himself privileged by Parliament, in order to screen his person from arrests, which also is an endeavor to elude the justice of the law. 8. Endeavoring or desiring, by any petition to the king, or bill exhibited in any of the king's courts against any creditors, to compel them to take less than their just debts, or to procrastinate the time of payment originally contracted for, which are an acknowledgment of either his poverty or his knavery. 9. Lying in prison for 2 months or more upon arrest or other detention for debt, without finding bail, in order to obtain his liberty. For the inability to procure bail argues a strong deficiency in his credit, owing either to his suspected poverty or ill character, and his neglect to do it, if able, can arise only from a fraudulent intention, in either of which cases it is high time for his creditors to look to themselves and compel the distribution of his effects. 10. Escaping from prison after an arrest for a just debt of £100 or upwards. For no man would break prison that was able and desirous to procure bail, which brings it within the reason of the last case. 11. Neglecting to make satisfaction for any just debt to the amount of £100 within 2 months after service of legal process for such debt upon any trader having privilege of Parliament. These are the several acts of bankruptcy expressly defined by the statutes relating to this title, which being so numerous, and the whole law of bankrupts being an innovation on the common law, our courts of justice have been tender of extending or multiplying acts of bankruptcy by any construction or implication. And therefore Sir John Holt held that a man's removing his goods privately to prevent their being seized in execution was no act of bankruptcy. For the statutes mention only fraudulent gifts to third persons, and procuring them to be seized by sham process in order to defraud creditors. But this, though a palpable fraud, yet falling within neither of those cases, cannot be adjudged an act of bankruptcy. So also it has been determined expressly that a banker's stopping or refusing payment is no act of bankruptcy, for it is not within the description of any of these statutes, and there may be good reasons for his so doing, as suspicion of forgery and the like. And if, in the consequence of such refusal, he is arrested and puts in bail, still it is no act of bankruptcy, for if he goes to prison and lies there 2 months, then, and not before, is he become a bankrupt. End of chapter 31, part 1. Chapter 31, Part 2 of the Commentaries on the Laws of England, Book 2, by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Of Title by Bankruptcy, Part 2. We have seen who may be a bankrupt and what acts will make him so. Let us next consider 3. The proceedings on a commission of bankrupt, so far as they affect the bankrupt himself, and these depend entirely on the several statutes of bankruptcy, all of which I shall endeavor to blend together and digest into a concise methodical order. And, first, there must be a petition to the Lord Chancellor by one creditor to the amount of £100, or by two to the amount of £150, or by three or more to the amount of £200, upon which he grants a commission to such discreet persons as to him shall seem good, who are then styled Commissioners of Bankrupt. The petitioners, to prevent malicious applications, must be bound in a security of £200 to make the party amends in case they do not prove him a bankrupt. And if on the other hand they receive any money or effects from the bankrupt as a recompense for suing out the commission, so as to receive more than their rateable dividends of the bankrupt's estate, they forfeit not only what they shall have so received, but their whole debt. These provisions are made, as well to secure persons in good credit from being damnified by malicious petitions, as to prevent knavish combinations between the creditors and bankrupt in order to obtain the benefit of a commission. When the commission is awarded and issued, the commissioners are to meet, at their own expense, and to take an oath for the due execution of their commission, and to be allowed a sum not exceeding 20 shillings per diem each at every sitting, and no commission of bankrupt shall abate or be void upon any demise of the crown. When the commissioners have received their commission, they are first to receive proof of the person's being a traitor, and having committed some act of bankruptcy, and then to declare him a bankrupt if proved so, and to give notice thereof in the Gazette, and at the same time to appoint 3 meetings. At one of these meetings an election must be made of assignees, or persons to whom the bankrupt's estate shall be assigned, and in whom it shall be vested for the benefit of the creditors, which assignees are to be chosen by the major part in value of the creditors, who shall then have proved their debts, but may be originally appointed by the commissioners and afterwards approved or rejected by the creditors. But no creditor shall be admitted to vote in the choice of assignees whose debt on the balance of accounts does not amount to £10. And at the 3rd meeting, at farthest, which must be on the 42nd day after the advertisement in the Gazette, the bankrupt, upon notice also personally served upon him, or left at his usual place of abode, must surrender himself personally to the commissioners, and must thenceforth in all respects conform to the directions of the statutes of bankruptcy, or, in default thereof, shall be guilty of felony without benefit of clergy, and shall suffer death, and his goods and estate shall be distributed among his creditors. In case the bankrupt absconds, or is likely to run away, between the time of the commission issued and the last day of surrender, he may by warrant from any judge or justice of the peace be committed to the county jail, in order to be forthcoming to the commissioners, who are also empowered immediately to grant a warrant for seizing his goods and papers. When the bankrupt appears, the commissioners are to examine him touching all matters relating to his trade and effects. They may also summon before them and examine the bankrupt's wife and any other person whatsoever as to all matters relating to the bankrupt's affairs. And in case any of them shall refuse to answer, or shall not answer fully, to any lawful question, or shall refuse to subscribe such their examination, the commissioners may commit them to prison without bail, till they make and sign a full answer, the commissioners specifying in their warrant of commitment the question so refused to be answered, and any jailer permitting such persons to escape or go out of prison shall forfeit £500 to the creditors. The bankrupt, upon this examination, is bound upon pain of death to make a full discovery of all his estate and effects, as well in expectancy as possession, and how he has disposed of the same, together with all books and writings relating thereto, and is to deliver up all in his own power to the commissioners, except the necessary apparel of himself, his wife, and his children, or, in case he conceals or embezzles any effects to the amount of £20, or withholds any books or writings with intent to defraud his creditors, he shall be guilty of felony without benefit of clergy. After the time allowed to the bankrupt for such discovery is expired, any other person voluntarily discovering any part of his estate before unknown to the assignees shall be entitled to 5% out of the effects so discovered, and such farther reward as the assignees and commissioners shall think proper. And any trustee wilfully concealing the estate of any bankrupt after the expiration of the 42 days shall forfeit £100 and double the value of the estate concealed to the creditors. Hitherto everything is in favor of the creditors, and the law seems to be pretty rigid and severe against the bankrupt. But in case he proves honest, it makes him full amends for all this rigor and severity. For if the bankrupt hath made an ingenious discovery, hath conformed to the direction of the law, and hath acted in all points to the satisfaction of his creditors, and if they, or 4 parts in 5 of them in number and value, but none of them creditors for less than £20, will sign a certificate to that purport, the commissioners are then to authenticate such certificate under their hands and seals, and to transmit it to the Lord Chancellor, and he or 2 judges whom he shall appoint, on oath made by the bankrupt that such certificate was obtained without fraud, may allow the same, or disallow it, upon cause shown by any of the creditors of the bankrupt. If no cause be shown to the contrary, the certificate is allowed, of course, and then the bankrupt is entitled to a decent and reasonable allowance out of his effects for his future support and maintenance, and to put him in a way of honest industry. This allowance is also in proportion to his former good behavior in the early discovery of the decline of his affairs, and thereby giving his creditors a larger dividend. 4. If his effects will not pay half of his debts, or 10 shillings in the pound, he is left to the discretion of the commissioners and assignees to have a competent sum allowed him, not exceeding 3%. But if they pay 10 shillings in the pound, he is to be allowed 5%. If 12 shillings and 6 pence, then 7.5%. And if 15 shillings in the pound, then the bankrupt shall be allowed 10%, provided that such allowance do not in the first case exceed £200, in the second £250, and in the third £300. Besides this allowance, he has also an indemnity granted him of being free and discharged forever from all debts owing by him at the time he became a bankrupt, even though judgment shall have been obtained against him, and he lies in prison upon execution for such debts, and, for that among other purposes, all proceedings on commission of bankrupt are, on petition, to be entered of record, as a perpetual bar against actions to be commenced on this account, though in general the production of the certificate properly allowed shall be sufficient evidence of all previous proceedings. Thus the bankrupt becomes a clear man again, and, by the assistance of his allowance and his own industry, may become a useful member of the Commonwealth, which is rather to be expected, as he cannot be entitled to these benefits but by the testimony of his creditors themselves of his honest and ingenious disposition, and unless his failures have been owing to misfortunes rather than to misconduct and extravagance. For no allowance or indemnity shall be given to a bankrupt unless his certificate be signed and allowed as before mentioned. And also, if any creditor produces a fictitious debt, and the bankrupt does not make discovery of it, but suffers the fair creditors to be imposed upon, he loses all title to these advantages. Neither can he claim them if he has given with any of his children above £100 for a marriage portion, unless he had at that time sufficient left to pay all his debts, or if he has lost at any one time £5, or in the whole £100, within a 12-month before he became bankrupt, by any manner of gaming or wagering whatsoever, or within the same time has lost to the value of £100 by stock jobbing. Also, to prevent the too common practice of frequent and fraudulent or careless breaking, a mark is set upon such as have been once cleared by a commission of bankrupt, or have compounded with their creditors, or have been delivered by an act of insolvency, which is an occasional act frequently passed by the legislature, whereby all persons whatsoever, who are either in too low a way of dealing to become bankrupts, or not being in a mercantile state of life, are not included within the laws of bankruptcy, are discharged from all suits and imprisonment upon delivering up all their estate and effects to their creditors upon oath at the sessions or assizes, in which case their perjury or fraud is usually, as in case of bankrupts, punished with death. Persons who have been once cleared by this, or either of the other methods, of composition with their creditors or bankruptcy, and afterwards become bankrupts again, unless they pay full 15 shillings in the pound, are only thereby indemnified as to the confinement of their bodies, but any future estate they shall acquire remains liable to their creditors, excepting their necessary apparel, household goods, and tools and implements of their trades. Thus much for the proceedings on a commission of bankrupt, so far as they affect the bankrupt himself personally. Let us next consider 4. How such proceedings affect or transfer the estate and property of the bankrupt. The method whereby a real estate in lands, tenements, and hereditaments may be transferred by bankruptcy was shown under its proper head in a former chapter. At present, therefore, we are only to consider the transfer of things personal by this operation of law. By virtue of the statutes before mentioned, all the personal estate and effects of the bankrupt are considered as vested by the act of bankruptcy in the future assignees of his commissioners, whether they be goods in actual possession or debts, contracts, and other chuses of action. And the commissioners by their warrant may cause any house or tenement of the bankrupt to be broken open in order to enter upon and seize the same. And when the assignees are chosen or approved by the creditors, the commissioners are to assign everything over to them, and the property of every part of the estate is thereby as fully vested in them as it was in the bankrupt himself, and they have the same remedies to recover it. The property vested in the assignees is the whole that the bankrupt had in himself at the time he committed the first act of bankruptcy, or that has been vested in him since, before his debts are satisfied or agreed for. Therefore, it is usually said that once a bankrupt and always a bankrupt, by which is meant that a plain direct act of bankruptcy once committed cannot be purged or explained away by any subsequent conduct as dubious equivocal act may be, but that if a commission is afterwards awarded, the commission and the property of the assignees shall have a relation or reference back to the first and original act of bankruptcy, insomuch that all transactions of the bankrupt are from that time absolutely null and void, either with regard to the alienation of his property or the receipt of his debts from such as are privy to his bankruptcy, for they are no longer his property or his debts, but those of future assignees. And if an execution be sued out, but not served and executed on the bankrupt's effects till after the effect of the bankruptcy, it is void as against the assignees. But the king is not bound by this fictitious relation, nor is within the statutes of bankrupts. For if, after the act of bankruptcy committed, and before the assignment of his effects, an extent issues for the debt of the crown, the goods are bound thereby. In France, this doctrine of relation is carried to a very great length. For there, every act of a merchant for 10 days precedent to the act of bankruptcy is presumed to be fraudulent and is therefore void. But with us the law stands on a more reasonable footing. For, As these acts of bankruptcy may sometimes be secret to all but a few, it would be prejudicial to trade to carry this notion to its utmost length. It is provided by Statute 19 George II, C. 32, that no money paid by a bankrupt to a bona fide or real creditor in a course of trade, even after an act of bankruptcy done, shall be liable to be refunded. Nor, by the Statute 1 Jacobin 1 C. 15, shall any debtor of a bankrupt that pays him his debt without knowing of his bankruptcy be liable to account for it again. The intention of this relative power being only to reach fraudulent transactions, and not to distress the fair trader. The assignees may pursue any legal method of recovering this property so vested in them by their own authority, but cannot commence a suit in equity, nor compound any debts owing to the bankrupt, nor refer any matters to arbitration without the consent of the creditors, or the major part of them in value, at a meeting to be held in pursuance of notice in the Gazette. When they have got in all the effects they can reasonably hope for, and reduced them to ready money, the assignees must, within 12 months after the commission issued, give 1 days' notice to the creditors of a meeting for a dividend or distribution, at which time they must produce their accounts, and verify them upon oath, if required. And then the commissioners shall direct a dividend to be made at so much in the pound to all creditors who have before proved, or shall then prove, their debts. This dividend must be made equally and in a rateable proportion to all the creditors according to the quantity of their debts, no regard being had to the quality of them. Mortgages, indeed, for which the creditor has a real security in his own hands, are entirely safe, for the commission of bankrupt reaches only the equity of redemption. So are also personal debts, where the creditor has a chattel in his hands, as a pledge or pawn for the payment, or has taken the debtor's lands or goods in execution. And, upon the equity of the statute 8 Ann C. 14, which directs that upon all executions of goods being on any premises demised to a tenant, 1 year's rent and no more shall, if due, be paid to the landlord, it hath also been held that under a commission of bankrupt, which is in the nature of a statute execution, the landlord shall be allowed his arrears of rent to the same amount in preference to other creditors, even though he hath neglected to distrain while the goods remained on the premises, which he is otherwise entitled to do for his entire rent, be the quantum what it may. But otherwise, judgments and recognizances, both which are debts of record, and therefore at other times have a priority, and also bonds and obligations by deed or special instrument, which are called debts by specialty, and are usually the next in order, these are all put on a level with debts by mere simple contract, and paid pari passu. Nay, so far as this matter is carried, that by the express provision of the statutes, debts not due at the time of the dividend made, as bonds or notes of hand, payable at a future day, shall be paid equally with the rest, allowing a discount or drawback in proportion. And assurances and obligations upon bottomry or respondentia bona fide made by the bankrupt, though forfeited after the commission is awarded, shall be looked upon in the same light as debts contracted before any act of bankruptcy. Within 18 months after the commission issued, a second and final dividend shall be made, unless all the effects were exhausted by the first. And if any surplus remains, after paying every creditor his full debt, it shall be restored to the bankrupt. This is a case which sometimes happens to men in trade, who involuntarily, or at least unwarily, commit acts of bankruptcy by absconding and the like, while their effects are more than sufficient to pay their creditors. And if any suspicious or malevolent creditor will take the advantage of such acts and sue out a commission, the bankrupt has no remedy, but must quietly submit to the effects of his own imprudence, except that, Upon satisfaction made to all the creditors, the commission may be superseded. This case may also happen when a knave is desirous of defrauding his creditors, and is compelled by a commission to do them that justice which otherwise he wanted to evade. And therefore, though the usual rule is that all interest on debts carrying interest shall cease from the time of issuing the commission, yet, in case of a surplus left after the payment of every debt, such interest shall again revive and be chargeable on the bankrupt or his representatives. End of Chapter 31, Part 2. Chapter 32, Part 1 of the Commentaries on the Laws of England, Book 2, by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Of Title by Testament and Administration, Part 1. There yet remain to be examined in the present chapter two other methods of acquiring personal estates, viz., by testament and administration, and these I propose to consider in one and the same view, they being in their nature so connected and blended together as makes it impossible to treat of them distinctly without manifest tautology and repetition. 11.12. In pursuit, then, of this joint subject, I shall first inquire into the original and antiquity of testaments and administrations, shall secondly show who is capable of making a last will and testament, shall thirdly consider the nature of a testament and its incidents, shall fourthly show what an executor and an administrator are and how they are to be appointed, and lastly shall select some few of the general heads of the office and duty of executors and administrators. First, as to the original of testaments and administrations. We have more than once observed that when property came to be vested in individuals by the right of occupancy, it became necessary for the peace of society that this occupancy should be continued, not only in the present possessor, but in those persons to whom he should think proper to transfer it, which introduced the doctrine and practice of alienations, gifts, and contracts. But these precautions would be very short and imperfect if they were confined to the life only of the occupier, for then, upon his death, all his goods would again become common, and create an infinite variety of strife and confusion. The law of very many societies has therefore given to the proprietor a right of continuing his property after his death, in such persons as he shall name, and, in defect of such appointment or nomination, the law of every society has directed the goods to be vested in certain particular individuals exclusive of all other persons. The former method of acquiring personal property, according to the express directions of the deceased, we call a testament. The latter, which is also according to the will of the deceased, not expressed in deed, but presumed by the law, we call in England an administration, being the same which the civil lawyers term a succession ab intestato, and which answers to the descent or inheritance of real estates. Testaments are of very high antiquity. We find them in use among the ancient Hebrews, though I hardly think the example usually given of Abraham's complaining that unless he had some children of his body, his steward, Eleazar of Damascus, would be his heir, is quite conclusive to show that he had made him so by will. And indeed, a learned writer has adduced this very passage to prove that in the patriarchal age, on failure of children or kindred, the servants born under their master's roof succeeded to the inheritance as heirs at law. But, to omit what Eusebius and others have related of Noah's testament, made in writing and witnessed under his seal, whereby he disposed of the whole world, I apprehend that a much more authentic instance of the early use of testaments may be found in the sacred writings, wherein Jacob bequeaths to his son Joseph a portion of his inheritance double to that of his brethren, which we will find carried into execution many hundred years afterwards, when the posterity of Joseph were divided into two distinct tribes, those of Ephraim and Manasseh, and had two several inheritances assigned them, whereas the descendants of each of the other patriarchs formed only one single tribe and had only one lot of inheritance. Solon was the first legislator that introduced wills into Athens, but in many other parts of Greece they were totally discountenanced. In Rome they were unknown till the laws of the 12 Tables were compiled, which first gave the right of bequeathing, and among the northern nations, particularly among the Germans, testaments were not received into use. And this variety may serve to evince that the right of making wills and disposing of property after death is merely a creature of the civil state, which has permitted it in some countries and denied it in others, and, even where it is permitted by law, it is subjected to different formalities and restrictions in almost every nation under heaven. With us in England, this power of bequeathing is coeval with the first rudiments of the law, for we have no traces or memorials of any time when it did not exist. Mention is made of intestacy in the old law before the conquest as being merely accidental, and the distribution of the intestate's estate after payment of the lord's heriot is then directed to go according to the established law. Sive quis incorria, sive morte repentina, fueret intestatus mortus, dominus tamen nullam rerum suarum partem, frite eram quae iure debitor eriate nomine, sive essem vito, verum possessiones uxori, liberis, et cognatione proximus, pro suo quique iure distribuantur. But we are not to imagine that the power of bequeathing extended originally to all men's personal estate. On the contrary, Glanville will inform us that by the common law, as it stood in the reign of Henry II, a man's goods were to be divided into 3 equal parts, of which one went to his heirs or lineal descendants, another to his wife, and the third was at his own disposal. Or, if he died without a wife, he might then dispose of one moiety, and the other went to his children. And so, e converso, if he had no children, the wife was entitled to one moiety, and he might bequeath the other. But if he died without either wife or issue, the whole was at his own disposal. The shares of the wife and children was called their reasonable parts, and the writ de ratione belli parte bonorum was given to recover it. This continued to be the law of the land at the time of Magna Carta, which provides that the king's debts shall first of all be levied, and then the residue of the goods shall go to the executor to perform the will of the deceased, and if nothing be owing to the crown, omnia catala cedunt defuncto, salvis exori ipsus et pueres sui rationalibus partis sui. In the reign of King Edward III, this right of the wife and children was still held to be the universal or common law, though frequently pleaded as the local custom of Berks, Devon, and other counties, and Sir Henry Finch lays it down expressly in the reign of Charles I to be the general law of the land. But this law is at present altered by imperceptible degrees, and the deceased may now by will bequeath the whole of his goods and chattels, though we cannot trace out when first this alteration began. Indeed, Sir Edward Coke is of the opinion that this never was the general law, but only obtained in particular places by special custom, and to establish that doctrine he relies on a passage in Bracton, which, in truth, when compared with the context, makes directly against his opinion, for Bracton lays down the doctrine of the reasonable part to be the common law, but mentions that as a particular exception, which Sir Edward Coke has hastily cited for the general rule. And Glanville, Magna Carta, Fleta, the Yearbooks, Fitzherbert, and Finch do all agree with Bracton that this right to the pars rationalibus was by the common law, which also continues to this day to be the general law of our sister kingdom of Scotland. To which we may add, that whatever may have been the custom of later years in many parts of the kingdom, or however it was introduced in derogation of the old common law, the ancient method continued in use in the province of York, the Principality of Wales, and the city of London till very modern times, when, in order to favor the power of bequeathing, and to reduce the whole kingdom to the same standard, three statutes have been provided. The one, 4 and 5 William and Mary c. 2, explained by 2 and 3 Anne c. 5 for the province of York; another, 7 and 8 William III c. 38 for Wales; and a third, 2 George I c. 18 for London, whereby it is enacted that persons within those districts and liable to those customs may, if they think proper, dispose of all their personal estates by will, and the claims of the widow, children, and other relations to the contrary are totally barred. Thus is the old common law now utterly abolished throughout all the kingdom of England, and a man may devise the whole of his chattels as freely as he formerly could his third part or moiety, in disposing of which he was bound by the custom of many places, as was stated in a former chapter, to remember his Lord and the Church, by leaving them his two best chattels, which was the original of heriots and mortuaries, and afterwards he was left at his own liberty to bequeath the remainder as he pleased. In case a person made no distribution of such his goods as were testable, whether that were only part or the whole of them, he was and is said to die intestate, and in such cases it is said that by the old law the king was entitled to seize upon his goods as the parens patriae and general trustee of the kingdom. This prerogative of the king continued to exercise for some time by his own ministers of justice, and probably in the county court, where matters of all kinds were determined, and it was granted as a franchise to many lords of manors and others, who have to this day a prescriptive right to grant administration to their intestate tenants and suitors in their own courts baron and other courts, or to have their wills there proved in case they made any disposition. Afterwards the crown, in favor of the church, invested the prelates with this branch of the prerogative, which was done, Faith Perkins, because it was intended by the law that spiritual men are of better conscience than laymen, and that they had more knowledge what things would conduce to the benefit of the soul of the deceased. The goods, therefore, of intestates were given to the ordinary by the crown, and he might seize them and keep them without wasting, and also might give, alien, or sell them at his will, and dispose of the money in pius usos. And if he did otherwise, he broke the confidence which the law reposed in him, so that properly the whole interest and power which were granted to the ordinary were only those of being the king's almoner within his diocese, in trust to distribute the intestate's goods in charity to the poor, or in such superstitious uses as the mistaken zeal of the times had denominated pious. And, as he had thus the disposition of the intestate's effects, the probate of wills of course followed, for it was thought just and natural that the will of the deceased should be proved to the satisfaction of the prelate, whose right of distributing his chattels for the good of his soul was effectually superseded thereby. The goods of the intestate being thus vested in the ordinary upon the most solemn and conscientious trust, The reverend prelates were therefore not accountable to any but to God and themselves for their conduct. But even in Fleda's time it was complained, Quod ordinari, ujus mode bone nomen ecclesia occupantes, nullum vel saltem indebitum faciunt distributionem. And to what a length of iniquity this abuse was carried, most evidently appears from a gloss of Pope Innocent IV, written about the year 1250, wherein he lays it down for established canon law, that in Britannia tertia pars bonorum descendentium ab intestado in opus ecclesiae et pauperum dispensanda est. Thus the popish clergy took to themselves, under the name of the Church and poor, the whole residue of the deceased's estate, after the partes rationables, or 2/3 of the wife and children, were deducted, without paying even his lawful debts or other charges thereon. For which reason it was enacted by the statute of Westminster II, that the ordinary shall be bound to pay the debts of the intestate so far as his goods will extend, in the same manner that executors were bound in case the deceased had left a will, a use more truly pious than any requiem or mass for his soul. This was the first check given to that exorbitant power which the law had entrusted with ordinaries. But though they were now made liable to the creditors of the intestate for their just and lawful demands, yet the residuum, after payment of debts, remained still in their hands, to be applied to whatever purposes the conscience of the ordinary should approve. The flagrant abuses of which power occasioned the legislature again to interpose, in order to prevent the ordinaries from keeping any longer the administration in their hands of those their immediate dependents, and therefore the statute 31 Edward III c. 2 provides that in case of intestacy the ordinary shall dispute the nearest and most lawful friends of the deceased to administer his goods, which administrators are put upon the same footing with regard to suits and to accounting as executors appointed by will. This is the original of administrators as they at present stand, who are only the officers of the ordinary, appointed by him in pursuance of this statute, which singles out the next and most lawful friend of the intestate, who is interpreted to be the next of blood that is under no legal disabilities. The statute 21 Henry VIII c. 5 enlarges a little more the power of the ecclesiastical judge, and permits him to grant administration either to the widow or the next of kin, or both of them, at his own discretion, and where 2 or more persons are in the same degree of kindred, gives the ordinary his election to accept whichever he pleases. Upon this footing stands the general law of administrations at this day. I shall, in the further progress of this chapter, mention a few more particulars with regard to who may and who may not be an administrator, and what he is bound to do when he has taken this charge upon him. What has been hitherto remarked only serving to show the original and gradual progress of testaments and administrations, in what manner the latter was first of all vested in the bishops by the royal indulgence, and how it was afterwards, by the authority of Parliament, taken from them in effect by obliging them to commit all their power to particular persons nominated expressly by the law. I proceed now, secondly, to inquire who may or who may not make a testament, and what persons are absolutely obliged by law to die intestate. And this law is entirely prohibitory, for regularly every person hath full power and liberty to make a will, that is not under some special prohibition by our law or custom, which prohibitions are principally upon 3 accounts: for want of sufficient discretion, for want of sufficient liberty and free will, and on account of their criminal conduct. 1. In the first species are to be reckoned infants under the age of 14 if males and 12 if females, which is the rule of the civil law. 4. Though some of our common lawyers have held that an infant of any age, even 4 years old, might make a testament, and others have denied that under 18 he is capable, yet, as the ecclesiastical court is the judge of every testator's capacity, this case must be governed by the rules of ecclesiastical law, so that no objection can be admitted to the will of an infant of 14 merely for want of age. But if the testator was not of sufficient discretion, whether at the age of 14 or 24, that will overthrow his testament. Madmen, or otherwise non-compotes, idiots or natural fools, persons grown childish by reason of old age or distemper, such as have their senses besotted with drunkenness, all these are incapable by reason of mental disability to make any will so long as such disability lasts. To this class also may be referred such persons as are born deaf, blind, and dumb, who, as they want the common inlets of understanding, are incapable of having animum testandi, and their testaments are therefore void. 2. Such persons as are intestable for want of liberty or freedom of will are, by the civil law of various kinds, as prisoners, captives, and the like. But the law of England does not make such persons absolutely intestable, but only leaves it to the discretion of the court to judge, upon consideration of the particular circumstances of duress, whether or no such persons could be supposed to have liberum animum testandi. And with regard to fem coverts, our laws differ still more materially from the civil. Among the Romans there was no distinction. A married woman was as capable of bequeathing as a fem sole. But with us, a married woman is not only utterly incapable of devising lands, being excepted out of the statute of wills, 34, 35, Henry VIII, c. 5, but also she is incapable of making a testament of chattels without the license of her husband. For all her personal chattels are absolutely his own, and he may dispose of her chattels real, or shall have them to himself if he survives her. It would be, therefore, extremely inconsistent to give her a power of defeating that provision of the law by bequeathing those chattels to another. Yet by her husband's license she may make a testament, and the husband upon marriage frequently convents with her friends to allow her that license. But such license is more properly his assent, for, unless it be given to the particular will in question, it will not be a complete testament, even though the husband beforehand hath given her permission to make a will. Yet it shall be sufficient to repel the husband from his general right of administering his wife's effects, and administration shall be granted to her appointee, with such testamentary paper annexed. So that in reality the woman makes no will at all, but only something like a will, operating in the nature of an appointment, the execution of which the husband by his bond, agreement, or covenant is bound to allow, a distinction similar to which we meet within the civil law. For, though a son who was in potestate parentis could not by any means make a formal and legal testament, even though his father permitted it, yet he might, with the like permission of his father, make what was called a donatio mortis causa. The queen consort is an exception to this general rule, for she may dispose of her chattels by will, without the consent of her lord, and any fem covert may make her will of goods which are in her possession in auter droit, as executrix or administratrix, for these can never be the property of the husband. And if she has any pin money or separate maintenance, it is said she may dispose of her savings thereout by testament, without the control of her husband. But if a fem sole makes her will, and afterwards marries, such subsequent marriage is esteemed a revocation in law, and entirely vacates the will. 3. Persons incapable of making testaments on account of their criminal conduct are in the first place all traitors and felons from the time of their conviction, for then their goods and chattels are no longer at their own disposal, but forfeited to the king. Neither can a fellow de se make a will of goods and chattels, for they are forfeited by the act and manner of his death. But he may make a devise of his lands, for they are not subjected to any forfeiture. Outlaws also, though it be but for debt, are incapable of making a will, for so long as the outlawry subsists, for their goods and chattels are forfeited during that time. As for persons guilty of other crimes short of felony, who are by the civil law precluded from making testaments, as usurers, libelers, and others of a worse stamp, at the common law their testaments may be good. And in general, the rule is, and has been so at least ever since Glanville's time, quod libera sit cujuscunte ultima voluntas. End of chapter 32, part 1. Chapter 32, Part 2 of the Commentaries on the Laws of England, Book 2, by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Of Title by Testament and Administration, Part 2. Let us next, thirdly, consider what this last will and testament is, which almost every one is thus at liberty to make, or the nature and incidents of a testament. Testaments, both Justinian and Sir Edward Coke agree to be so called, because they are testatio mentis, an etymon, which seems to favor too much of the conceit, it being plainly a substantive derived from the verb testari, in a like manner as juramentum, incrementum, and others from other verbs. The definition of the old Roman lawyers is much better than their etymology. Voluntas nostra ustas sententia de eo, quod quis post mortem suam fieri velit, which may thus be rendered into English, the legal declaration of a man's intentions which he wills to be performed after his death. It is called sententia to denote the circumspection and prudence with which it was supposed to be made. It is voluntatis nostrae sententia because its efficacy depends on declaring the testator's intention, whence in England it is emphatically styled his will. It is justa sententia, that is, drawn, attested, and published with all due solemnities and forms of law. It is de eo, quod quis post mortem suam fieri velet, because the testament is of no force till after the death of the testator. These testaments are divided into two sorts, written and verbal or nuncupative, of which the former is committed to writing. The latter depends merely on oral evidence, being declared by the testator in extremis before a sufficient number of witnesses and afterwards reduced to writing. A codicil, codicillus, a little book or writing, is a supplement to a will, or an addition made by the testator and annexed to and to be taken as part of a testament, being for its explanation or alteration, or to make some addition to, or else some subtraction from, the former dispositions of the testator. This may also either be written or nuncupative. But as nuncupative wills and codicils, which were formerly more in use than at present, when the art of writing is become more universal, are liable to great impositions, and may occasion many perjuries, the Statute of Frauds 29 Charles II c. 3 enacts, 1. That no written will shall be revoked or altered by a subsequent nuncupative one, except the same be in the lifetime of the testator, reduced to writing and read over to him and approved, and unless the same be proved to have been so done by the oaths of 3 witnesses at the least, who, by statute 4 and 5 and C16, must be such as are admissible upon trials at common law. 2. That no nuncupative will shall in any wise be good, where the estate bequeathed exceeds £30, unless proved by 3 such witnesses present at the making thereof, the Roman law requiring 7, and unless they, or some of them, were specially required to bear witness thereto by the testator himself, and unless it was made in his last sickness, in his own habitation or dwelling house, or where he had been previously resident 10 days at the least, except he be surprised with sickness on a journey or from home, and dies without returning to his dwelling. 3. That no nuncupative will shall be proved by the witnesses after 6 months from the making, unless it were put in writing within 6 days. Nor shall it be proved till 14 days after the death of the testator, nor till process has first issued a call to the widow or next of kin to contest it if they think proper. Thus has the legislature provided against any frauds in setting up nuncupative wills by so numerous a train of requisites that the thing itself is fallen into disuse, and hardly ever heard of but in the only instance where favor ought to be shown to it, when the testator is surprised by a sudden and violent sickness. The testamentary words must be spoken with an intent to bequeath, not any loose idle discourse in his illness, for he must require the bystanders to bear witness of such his intention. The will must be made at home, or among his family and friends, unless by unavoidable accident, to prevent impositions from strangers. It must be in his last sickness, for if he recovers, he may alter his dispositions, and has time to make a written will. It must not be proved at too long a distance from the testator's death, lest the words should escape the memory of the witnesses, nor yet too hastily and without notice, lest the family of the testator should be put to inconvenience or surprised. As to written wills, they need not any witness of their publication. I speak not here of devises of lands, which are entirely another thing, a conveyance by statute, unknown to the feudal or common law, and not under the same jurisdiction as personal testaments. But a testament of chattels, written in the testator's own hand, though it has neither his name nor seal to it, nor witnesses present at its publication, is good, provided sufficient proof can be had that it is his handwriting. And though written in another man's hand, and never signed by the testator, yet if proved to be according to his instructions and approved by him, it hath been held a good testament of the personal estate. Yet it is the safer and more prudent way, and leaves less in the breast of the ecclesiastical judge, if it be signed or sealed by the testator, and published in the presence of witnesses, which last was always required in the time of Blackstone, or, rather, he in this respect has implicitly copied the rule of the civil law. No testament is of any effect till after the death of the testator. Nam omne testamentum morte consummatum est, et volenta testatoris est ambulatoria usque ad mortem. And therefore, if there be many testaments, the last overthrows all the former, but the republication of a former will revokes one of a latter date and establishes the first again. Hence it follows that testaments may be avoided 3 ways. 1. If made by a person laboring under any of the incapacities before mentioned. 2. By making another testament of a later date. And 3. By canceling or revoking it. For though I make a last will and testament irrevocable in the strongest words, yet I am at liberty to revoke it, because my own act or words cannot alter the disposition of law, so as to make that irrevocable which is in its own nature revocable. For this, saith Lord Bacon, would be for a man to deprive himself of that which of all other things is most incident to the human condition, and that is alteration or repentance. It hath also been held, that without an express revocation, if a man who hath made his will afterwards marries and hath a child, this is a presumptive or implied revocation of his former will, which he made in his state of celibacy. The Romans were also wont to set aside testaments as being inefficiosa, deficient in a natural duty, if they disinherited or totally passed by, without assigning a true and sufficient reason, any of the children of the testator. But if the child had any legacy, though ever so small, it was a proof that the testator had not lost his memory or his reason, which otherwise the law presumed, but was then supposed to have acted thus for some substantial cause. And in such case no querela inefficiosi testamenti was allowed. Hence probably has arisen that groundless vulgar error of the necessity of leaving the heir a shilling or some other express legacy in order to disinherit him effectually, whereas the law of England makes no such wild suppositions of forgetfulness or insanity, and therefore, though the heir or next of kin be totally omitted, it admits no querela inefficiosi to set aside such a testament. We are next to consider, fourthly, what is an executor and what is an administrator, and how they are both to be appointed. An executor is he to whom another man commits by will the execution of that his last will and testament. And all persons are capable of being executors that are capable of making wills, and many others besides, as fem coverts and infants, nay, even infants unborn, or in ventre samere, may be made executors. But no infant can act as such till the age of 17 years, till which time administration must be granted to some other durante minore aetate, in like manner as it may be granted durante absentia or pedente lite, when the executor is out of the realm, or when a suit is commenced in the ecclesiastical court touching the validity of the will. This appointment of an executor is essential to the making of a will, and it may be performed either by express words or such as strongly imply the same. But if the testator makes his will without naming any executors, or if he names incapable persons, or if the executor's name refuse to act, in any of these cases the ordinary must grant administration cum testamento annexo to some other person, and then the duty of the administrator, as also when he is constituted only durante minore aetate, etc., of another, is very little different from that of an executor. And this was law so early as the reign of Henry II, when Glanville informs us that testamente executores est dedement y quos testator ad hoc elegerit, et quibus custom ipse commisserit. Si vero testator nullos ad hoc nominaverit, possunt propinque et consanguine ipsius defuncti ad id faciendum se ingerere. But if the deceased died totally intestate without making either will or executors, then general letters of administration must be granted by the ordinary to such administrator as the statutes of Edward III and Henry VIII before mentioned direct. In consequence of which we may observe, 1. That the ordinary is compellable to grant administration of the goods and chattels of the wife to the husband or his representatives, and of the husband's effects to the widow or next of kin, but he may grant it to either or both at his discretion. 2. That among the kindred those are to be preferred that are nearest in degree to the intestate, but of persons in equal degree the ordinary may take which he pleases. 3. That this nearness or propinquity of degree shall be reckoned according to the computation of the civilians, and not of the canonists, which the law of England adopts in the descent of real estates. because in the civil computation the intestate himself is the terminus a quo. The several degrees are numbered, and not the common ancestor according to the rule of the canonists. And therefore, in the first place, the children, or, on failure of children, the parents of the deceased, are entitled to the administration, both which are indeed in the first degree, but with us the children are allowed the preference. Then follow brothers, grandfathers, uncles or nephews, and the females of each class respectively, and lastly cousins. 4. The half-blood is admitted to the administration as well as the whole, for they are of the kindred of the intestate, and only excluded from inheritances of land upon feudal reasons. Therefore, the brother of the half-blood shall exclude the uncle of the whole blood, and the ordinary may grant administration to the sister of the half, or the brother of the whole blood, at his own discretion. 5. If none of the kindred will take out administration, a creditor may, by custom, do it. 6. If the executor refuses or dies intestate, the administration may be granted to the residuary legatee in exclusion of the next of kin. And lastly, the ordinary may, in defect of all of these, commit administration, as he might have done before the statute Edward III, to such discreet person as he approves of, or may grant him letters ad collegendum bona defuncti, which neither make him executor nor administrator, his only business being to keep the goods in his safe custody, and to do other acts for the benefit of such as are entitled to the property of the deceased. If a bastard who has no kindred, being nullius filius, or anyone else that has no kindred, dies intestate without a wife or child, it hath been formerly held that the ordinary might seize his goods and dispose of them in pios usos. But the usual course now is for someone to procure letters patent or other authority from the king, and then the ordinary course grants administration to such appointee of the crown. The interest vested in an executor by the will of the deceased may be continued and kept alive by the will of the same executor, so that the executor of A's executor is to all intents and purposes the executor and representative of A himself, but the executor of A's administrator, or the administrator of A's executor, is not the representative of A. For the power of an executor is founded upon the special confidence and actual appointment of the deceased, and such executor is therefore allowed to transmit that power to another in whom he has equal confidence. But the administrator of A is merely the officer of the ordinary, prescribed to him by Act of Parliament, in whom the deceased has reposed no trust at all, and therefore, on the death of that officer, it results back to the ordinary to appoint another. And, with regard to the administrator of A's executor, he has clearly no privity or relation to A, being only commissioned to administer the effects of the intestate executor, and not the original testator. Wherefore, in both these cases, and whenever the course of representation from executor to executor is interrupted by any one administration, it is necessary for the ordinary to commit administration afresh of the goods of the deceased, not administered by the former executor or administrator. And this administrator, de bonis non, is the only legal representative of the deceased in matters of personal property. But he may, as well as the original administrator, have only a limited or special administration committed to his care, viz., of certain specific effects, such as a term of years and the like, the rest being committed to others. Having thus shown what is and who may be an executor or administrator, I proceed now, fifthly and lastly, to inquire into some few of the principal points of their office and duty. These in general are very much the same in both executors and administrators, excepting, first, that the executor is bound to perform a will, which an administrator is not, unless where a testament is annexed to his administration, and then he differs still less from an executor, and, secondly, that an executor may do many acts before he proves the will, but an administrator may do nothing till letters of administration are issued, for the former derives his power from the will and not from the probate. The latter owes his entirely to the appointment of the ordinary. If a stranger takes upon him to act as executor without any just authority, as by intermeddling with the goods of the deceased and many other transactions, he is called in law an executor of his own wrong, de son tort, and is liable to all the trouble of an executorship without any of the profits or advantages, but merely doing acts of necessity or humanity, as locking up the goods or burying the corpse of the deceased, will not amount to such intermeddling as will charge a man as executor of his own wrong. Such a one cannot bring an action himself in right of the deceased, but actions may be brought against him. And in all actions by creditors against such an officious intruder, he shall be named an executor generally, for the most obvious conclusion which strangers can form from his conduct is that he hath a will of the deceased, wherein he is named executor, but hath not yet taken probate thereof. He is chargeable with the debts of the deceased so far as assets come into his hands, and, as against creditors in general, shall be allowed all payments made to any other creditor in the same or superior degree, himself only excepted. And though, as against the rightful executor or administrator, he cannot plead such payment, yet it shall be allowed him in mitigation of damages, unless perhaps upon a deficiency of assets, whereby the rightful executor may be prevented from satisfying his own debt. But let us now see what are the power and duty of a rightful executor or administrator. 1. He must bury the deceased in a manner suitable to the estate which he leaves behind him. Necessary funeral expenses are allowed, previous to all other debts and charges, but if the executor or administrator be extravagant, it is a species of devastation or waste of the substance of the deceased, and shall only be prejudicial to himself and not to the creditors or legatees of the deceased. 2. The executor or administrator, durante minore aetate, or durante absentia, or cum testamento annexo, must prove the will of the deceased, which is done either in common form, which is only upon his own oath before the ordinary or his surrogate, or per testes, in more solemn form of law, in case the validity of the will be disputed. When the will is so proved, the original must be deposited in the registry of the ordinary, and a copy thereof in parchment is made out under the seal of the ordinary and delivered to the executor or administrator, together with a certificate of its having been proved before him, all which together is usually styled the probate. In defect of any will, the person entitled to be administrator must also at this period take out letters of administration under the seal of the ordinary, whereby an executorial power to collect and administer, that is, dispose of the goods of the deceased, is vested in him, and he must, by statute 22 and 23, Charles II, c. 10, enter into a bond with sureties faithfully to execute his trust. If all the goods of the deceased lie within the same jurisdiction, a probate before the ordinary or an administration granted by him are the only proper ones. But if the deceased had bona notabilia, or chattels to the value of 100 shillings in two distinct dioceses or jurisdictions, then the will must be proved or administration taken out before the metropolitan of the province, by way of special prerogative, whence the court where the validity of such wills is tried, and the office where they are registered, are called the prerogative court, and the prerogative office of the provinces of Canterbury and York. Linwood, who flourished in the beginning of the 15th century and was official to Archbishop Ciccelli, interprets these 100 shillings to signify salidas legales, of which he tells us 72 amounted to a pound of gold, which in his time was valued at 50 nobles, or £16 13 shillings 4 pence. He therefore computes that the 100 shillings which constituted bona notabilia were then equal in current money to £23 3 shillings and 1/4 pence. This will account for what is said in our ancient books, that bona notabilia in the diocese of London, and indeed everywhere else, were of the value of £10 by composition. For, if we pursue the calculations of Linwood to their full extent, and consider that a pound of gold is now almost equal in value to 150 nobles, we shall extend the present amount of bona notabilia to nearly £70. But the makers of the canons of 1603 understood this ancient rule to be meant of the shillings current in the reign of James I, and have therefore directed that £5 shall for the future be the standard of bona notabilia, so as to make the probate fall within the archiepiscopal prerogative. Which prerogative, properly understood, is grounded upon this reasonable foundation, that as bishops were themselves originally the administrators to all intestates in their own diocese, and as the present administrators are in effect no other than their officers or substitutes, it was impossible for the bishops or those who acted under them to collect any goods of the deceased other than such as lay within their own diocese, beyond which their episcopal authority extends not. But it would be extremely troublesome if as many administrations were to be granted as there are dioceses within the deceased had bona notabilia, besides the uncertainty which creditors and legatees would be at in case different administrators were appointed to ascertain the fund out of which their demands are to be paid. A prerogative is therefore very prudently vested in the metropolitan of each province to make in such cases one administration serve for all. This accounts very satisfactorily for the reason of taking out administration to intestates that have large and diffusive property in the prerogative court. And the probate of wills naturally follows, as was before observed, the power of granting administrations, in order to satisfy the ordinary that the deceased has, in a legal manner, by appointing his own executor, excluded him and his officers from the privilege of administrating the effects. End of Chapter 32, Part 2. Chapter 32, Part 3 of the Commentaries on the Laws of England, Book 2, by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Of Title by Testament and Administration, Part 3. 3. The executor or administrator is to make an inventory of all the goods and chattels, whether in possession or action, of the deceased, which he is to deliver into the ordinary upon oath if thereunto lawfully required. 4. He is to collect all the goods and chattels so inventoried, and to that end has very large powers and interests conferred upon him by law, being the representative of the deceased, and having the same property in his goods as the principal had when living, and the same remedies to recover them. And, if there be 2 or more executors, a sale or release by one of them shall be good against all the rest. But in case of administrators, it is otherwise. Whatever is so recovered, that is of a saleable nature and may be converted into ready money, is called assets in the hands of the executor or administrator, that is, sufficient or enough, from the French assez, to make him chargeable to a creditor or legatee, so far as such goods and chattels extend. Whatever assets so come to his hands, he may convert into ready money, to answer the demands that may be made upon him, which are the next thing to be considered. For 5. The executor or administrator must pay the debts of the deceased. In payment of debts, he must observe the rules of priority. Otherwise, on deficiency of assets, if he pays those of a lower degree first, he must answer those of a higher out of his own estate. And first, he may pay all funeral charges and the expense of proving the will and the like. Secondly, debts due to the king on record or specialty. Thirdly, such debts as are by particular statutes to be preferred to all others, as forfeitures for not burying in woolen, money due on poor rates, for letters to the post office, and some others. Fourthly, debts of record, as judgments docketed according to the statute 4 and 5 William and Mary c. 20, statutes and recognizances. Fifthly, debts due on special contracts, as for rent, for which the lessor has often a better remedy in his own hands by distraining, or upon bonds, covenants, and the like, under seal. Lastly, debts on simple contracts, viz., upon notes unsealed and verbal promises. Among these simple contracts, servants' wages are by some with reason preferred to any other, and so stood the ancient law according to Bracton and Fleta, who reckon among the first debts to be paid, servitia servientum et stipendia famulorum. Among debts of equal degree, the executor or administrator is allowed to pay himself first, by retaining in his hands so much as his debt amounts to. But an executor of his own wrong is not allowed to retain, for that would tend to encourage creditors to strive who should first take possession of the goods of the deceased, and would besides be taking advantage of their own wrong, which is contrary to the rule of law. If a creditor constitutes his debtor his executor, this is a release or discharge of the debt, whether the executor acts or no, provided there be assets sufficient to pay the testator's debts. For, though this discharge of the debt shall take place of all legacies, yet it were unfair to defraud the testator's creditors of their just debts by a release which is absolutely voluntary. Also, if no suit is commenced against him, the executor may pay any one creditor in equal degree his whole debt, though he has nothing left for the rest. For, without a suit commenced, the executor has no legal notice of the debt. 6. When the debts are all discharged, the legacies claim the next regard, which are to be paid by the executor so far as his assets will extend. But he may not give himself the preference herein, as in the case of debts. A legacy is a bequest or gift of goods and chattels by testament, and the person to whom it is given is styled the legatee, which every person is capable of being, unless particularly disabled by the common law or statutes, as traders, papists, and some others. This bequest transfers an inchoate property to the legatee, but the legacy is not perfect without the assent of the executor. For if I have a general or pecuniary legacy of £100, or a specific one of a piece of plate, I cannot in either case take it without the consent of the executor. For in him all chattels are vested, and it is his business first of all to see whether there is a sufficient fund left to pay the debts of the testator, the rule of equity being that a man must be just before he is permitted to be generous, or, as Bracton expresses the sense of our ancient law, de bonis defuncte primo deducenda sent ea quae sunt necessitatis, et postea quae sunt utilitatis, et ultimo quae sunt voluntatis. And in case of a deficiency of assets, all the general legacies must abate proportionally in order to pay the debts. But a specific legacy of a piece of plate, a horse, or the like, is not to abate at all, or allow anything by way of abatement, unless there be not sufficient without it. Upon the same principle, if the legatees have been paid their legacies, they are afterwards bound to refund a rateable part in case debts come in more than sufficient to exhaust the residuum after the legacy is paid. And this law is as old as Bracton and Fleta, who tell us, Si plura sunt debita, vel placa legatum fuerit, ad quae catala defuncti non sufficiant, fiat ubique del vacatio, excepto regis privilegio. If the legatee dies before the testator, the legacy is a lost or lapsed legacy, and shall sink into the residuum. And if a contingent legacy be left to anyone, as when he attains, or if he attains, the age of 21, and he dies before that time, it is a lapsed legacy. But a legacy to one to be paid when he attains the age of 21 years is a vested legacy, an interest which commences in presente, although it be solvendum in futuro. And if the legatee dies before that age, his representatives shall receive it out of the testator's personal estate, at the same time that it would have become payable in case the legatee had lived. This distinction is borrowed from the civil law, and its adoption in our courts is not so much owing to its intrinsic equity as to its having been before adopted by the ecclesiastical courts. 4. Since the Chancery has a concurrent jurisdiction with them in regard to the recovery of legacies, it was reasonable that there should be a conformity in their determinations, and that the subject should have the same measure of justice in whatever court he sued. But if such legacies be charged upon a real estate, in both cases they shall lapse for the benefit of the heir. For, with regard to devises affecting lands, the ecclesiastical court hath no concurrent jurisdiction. And, in case of a vested legacy due immediately, and charged on land or money in the funds, which yield immediate profit, interest shall be payable thereon from the testator's death. But if charged only on the personal estate, which cannot be immediately got in, it shall carry interest only from the end of the year after the death of the testator. Besides these formal legacies contained in a man's will and testament, there is also permitted another deathbed disposition of property, which is called a donation causa mortis. And that is, when a person in his last sickness, apprehending his dissolution near, delivers or causes to be delivered to another the possession of any personal goods, under which have been included bonds and bills drawn by the deceased upon his banker to keep in case of his decease. This gift, if the donor dies, needs not the assent of his executor. Yet it shall not prevail against creditors, and is accompanied with this implied trust, that if the donor lives, the property thereof shall revert to himself, being only given in contemplation of death, or mortis causa. This method of donation might have subsisted in a state of nature, being always accompanied with delivery of actual possession, and so far differs from a testamentary disposition, but seems to have been handed to us from the civil lawyers, who themselves borrowed it from the Greeks. 7. When all the debts and particular legacies are discharged, the surplus or residuum must be paid to the residuary legatee, if any be appointed by the will, and, if there be none, it was a long settled notion that it devolved to the executor's own use by virtue of his executorship. But whatever ground there might have been formerly for this opinion, it seems now to be understood with this restriction, that although where the executor has no legacy at all, the residuum shall in general be his own, yet wherever there is sufficient on the face of a will, by means of a competent legacy or otherwise, to imply that the testator intended his executor should not have the residue, The undivided surplus of the estate shall go to the next of kin, the executor then standing upon exactly the same footing as an administrator, concerning whom, indeed, there was formerly much debate, whether or no he could be compelled to make any distribution of the intestate's estate. For though after the administration was taken in effect from the ordinary and transferred to the relations of the deceased, the spiritual court endeavored to compel a distribution and took bonds of the administrator for that purpose, they were prohibited by the temporal courts, and the bonds declared void at law. And the right of the husband not only to administer, but also to enjoy exclusively the effects of his deceased wife depends still on this doctrine of the common law, the statute 29 Charles II, declaring only that the statute of distributions does not extend to this case. But now these controversies are quite at an end, for by the statute 22-23 Charles II c. 10, it is enacted that the surplusage of intestate's estates, except of femmes covert, shall, after the expiration of 1 full year from the death of the intestate, be distributed in the following manner. 1/3 shall go to the widow of the intestate, and the residue in equal proportions to his children, or, if dead, to their representatives, that is, their lineal descendants. If there are no children or legal representatives subsisting, then a moiety shall go to the widow, and a moiety to the next of kindred in equal degree and their representatives. If no widow, the whole shall go to the children. If neither widow nor children, the whole shall be distributed among the next of kin in equal degree and their representatives. But no representatives are admitted among collaterals farther than the children of the intestate's brothers and sisters. The next of kindred here referred to are to be investigated by the same rules of consanguinity as those who are entitled to letters of administration, of whom we have sufficiently spoken. And therefore by this statute the mother, as well as the father, succeeded to all the personal effects of their children who died intestate and without wife or issue, in exclusion of the other sons and daughters, the brothers and sisters of the deceased. And so the law still remains with respect to the father, but by the statute 1 Jacobin 2 c. 17, if the father be dead and any of the children die intestate without wife or issue in the lifetime of the mother, she and each of the remaining children or their representatives shall divide his effects in equal portions. It is obvious to observe how near a resemblance this statute of distributions bears to our ancient English law, de rationabili parte bonorum, spoken of at the beginning of this chapter, and which Sir Edward Coke himself, though he doubted the generality of its restraint on the power of devising by will, held to be universally binding upon the administrator or executor in the case of either total or partial intestacy. It also bears some resemblance to the Roman law of successions ab intestato, which, and because the act was also penned by an eminent civilian, has occasioned the notion that the Parliament of England copied it from the Roman Praetor, though indeed it is little more than a restoration, with some refinements and regulations, of our old constitutional law, which prevailed as an established right and custom from the time of King Canute downwards, many centuries before Justinian's laws were known or heard of in the western parts of Europe. So likewise there is another part of the statute of distributions where directions are given that no child of the intestate, except his heir at law, on whom he settled in his lifetime any estate in lands or pecuniary portion equal to the distributive shares of the other children, shall have any part of the surplusage with their brothers and sisters. But if the estates so given them by way of advancement are not quite equivalent to the other shares, the children so advanced shall now have so much as will make them equal. This just and equitable provision hath been also said to be derived from the collatio bonorum of the imperial law, which it certainly resembles in some points, though it differs wildly in others. But it may not be amiss to observe that, with regard to goods and chattels, this is part of the ancient custom of London, of the province of York, and of our sister kingdom of Scotland. And with regard to lands descending in coparcenary, that it hath always been, and still is, the common law of England, under the name of hotchpot. Before I quit this subject, I must however acknowledge that the doctrine and limits of representation laid down in the Statute of Distributions seem to have been principally borrowed from the civil law, whereby it will sometimes happen that personal estates are divided per capita and sometimes per stirpes, whereas the common law knows no other rule of succession but that per stirpes only. They are divided per capita to every man an equal share, when all the claimants claim in their own rights as in equal degree of kindred, and not jure representationis in the right of another person. As if the next of kin be the intestate's three brothers, A, B, and C. Here his estate is divided into three equal portions and distributed per capita, one to each. But if one of these brothers, A, had been dead, leaving three children, and another, B, leaving two, then the distribution must have been per stirpes, viz., 1/3 to A's three children, another third to B's two children, and the remaining third to C, the surviving brother. Yet, if C had also been dead, without issue, then A's and B's 5 children, being all in equal degree to the intestate, would take in their own rights per capita, viz., each of them 1/5 part. The statute of distributions expressly accepts and reserves the customs of the city of London, of the province of York, and of all other places having peculiar customs of distributing intestates effects. So that, though in those places the restraint of devising is removed by the statutes formerly mentioned, their ancient customs remain in full force with respect to the estates of intestates. I shall therefore conclude this chapter, and with it the present book, with a few remarks on those customs. In the first place, we may observe that in the city of London and the province of York, as well as in the kingdom of Scotland, and therefore probably also in Wales, concerning which there is little to be gathered but from the statute 7 and 8 William III, c. 38, the effects of the intestate, after payment of his debts, are in general divided according to the ancient universal doctrine of the pars rationabilis. If the deceased leaves a widow and children, his substance, deducting the widow's apparel and furniture of her bedchamber, which in London is called the widow's chamber, is divided into 3 parts, one of which belongs to the widow, another to the children, and the third to the administrator. If only a widow or only children, they shall respectively, in either case, take one moiety, and the administrator the other. If neither widow nor child, the administrator shall have the whole. And this portion, or dead man's part, the administrator was wont to apply to his own use, till the statute 1 Jacobin 2 c. 17 declared that the same should be subject to the statutes of distribution. So that if a man dies worth £1,800, leaving a widow and 2 children, the estate shall be divided into 18 parts, whereof the widow shall have 8, 6 by the custom and 2 by the statute, and each of the children 5, 3 by the custom, and 2 by the statute. If he leaves a widow and 1 child, they shall each have a moiety of the whole, or 9 such 18th parts, 6 by the custom, and 3 by the statute. If he leaves a widow and no child, the widow shall have 3/4 of the whole, 2 by the custom, and 1 by the statute, and the remaining 4th shall go by the statute to the next of kin. It is also to be observed that if the wife be provided for by a jointure before marriage, in bar of her customary part, it puts her in a state of nonentity with regard to the custom only, but she shall be entitled to her share of the dead man's part under the statute of distributions, unless barred by special agreement. And if any of the children are advanced by the father in his lifetime with any sum of money not amounting to their full portionable part, they shall bring that portion into the hotchpot with the rest of the brothers and sisters, but not with the widow, before they are entitled to any benefit under the custom. But if they are fully advanced, the custom entitles them to no farther dividend. Thus far, in the main, the customs of London and of York agree, but besides certain other less material variations, there are 2 principal points in which they considerably differ. One is, that in London the share of the children, or orphanage part, is not fully vested in them till the age of 21, before which they cannot dispose of it by testament, and if they die under that age, whether sole or married, their share shall survive to the other children. But after the age of 21, it is free from any orphanage custom, and, in case of intestacy, shall fall under the statute of distributions. The other, that in the province of York, the heir at common law, who inherits any lands either in fee or in tail, is excluded from any filial portion or reasonable part. But, notwithstanding these provincial variations, the customs appear to be substantially one and the same. And, as a similar policy formerly prevailed in every part of the island, we may fairly conclude the whole to be of British original, or, if derived from the Roman law of successions, to have been drawn from that fountain much earlier than the time of Justinian, from whose constitutions in many points, particularly in the advantages given to the widow, it very considerably differs, though it is not improbable that the resemblances which yet remain may be owing to the Roman usages, introduced in the time of Claudius Caesar, who established a colony in Britain to instruct the natives in legal knowledge, inculcated and diffused by Papinian, who presided at York as Praefectus Praetorio under the emperors Severus and Caracalla, and continued by his successors till the final departure of the Romans in the beginning of the 5th century after Christ. End of chapter 32, part 3. End of the Commentaries on the Laws of England, book the 2nd of the Rights of Things, by William Blackstone.